Good morning, everyone. I am delighted to welcome you to Widener University Commonwealth Law School. My name is André Cummings. I am the Dean of the Law School, and as I said, I am really enthusiastic about welcoming everyone here today. We have about 100 people that are online joining us, as well as everyone here in the room. Here at Widener Law Commonwealth, we were built on the principles of access to justice and equality. And one of the things that I think is very important that we do here at Widener Law Commonwealth is we have hard conversations. We bring together individuals to grapple with the issues of our day and the things that really matter. And one of the things that is exciting for me is to be able to welcome everyone to the 6th annual Emergency Medical Services Symposium to talk about medical civil rights in emergency services today. When you think about the issues that confront the world, particularly when we're talking about issues that include Tyree Nichols, Elijah McClain, the interfacing of law enforcement when it comes to emergency medical services and whose jurisdiction should countenance and what outcomes should best approximate. We are here today to really talk about and grapple with the issues that matter, especially when it comes to the critical services of EMS practitioners. So I'm really delighted to welcome everyone here today, and as we often do here at Widener Law Commonwealth, we're going to talk about the hard issues, we're going to talk about the things that matter, and we're especially going to talk about the ways that we can go forward in a fair and just manner. So this is the 6th annual. One of the great things about this symposium is that one of the very proud graduates of our law school, Doug Wolfberg, is here and has helped us organize this symposium for the last 6 years. We are very proud to be the law school of Doug, and we're very proud to be able to host this event. It originated 6 years ago when Christian Johnson was dean of the law school, and together, Doug Wolfberg, Christian Johnson, and now Corinna Wilson and me this year have been in a position for us to organize and host this event. Christian Johnson led this law school for 5 years. He put it on extremely sound footing. I am very proud to have followed in his footsteps. I'd like to bring to you Christian Johnson to introduce the event for today. Christian.
Thank you. Welcome everyone to our 6th annual symposium that Doug Wolfberg, his law firm, and the law school has organized. It's really been exciting and satisfying to have worked each year on issues affecting such an important industry. And it's really terrific to see all of you here. And we all appreciate all of the work and time and energy that you put into helping our communities. And we're also grateful to all those that are attending both here and remotely. We have right now over 100 people logged in that are also participating in the program. Now, before I begin, I would like to publicly thank our behind-the-scenes coordinator and ramrod, Corinna Wilson. Corinna, raise your arm there, who without her help, this really wouldn't happen, and we really appreciate it. And we also want to thank the hardworking staff here at Widener Law Commonwealth and all the work that they've done to set things up, make sure you get your continuing legal education credits, and all the hard work, again, that goes on behind the scenes. I'm honored to introduce Doug Wolfberg. And as Dean Cummings mentioned, we are proud to call him our alum. Doug Wolfberg is an attorney and founding partner of Page, Wolfberg, and Wirth, which exclusively represents EMS, ambulance, and public safety clients nationally. Doug previously worked for many years as an EMT, and prior to law school served as a county EMS director, a Pennsylvania regional EMS director, and formerly worked on the staff of the Pennsylvania Emergency Health Centers Council for a number of years. He's also served at the federal level on the staff of the U.S. Department of Health and Human Services, Division of Trauma and Emergency Medical Systems. In his current practice as an attorney and consultant, Doug represents public, private, and nonprofit EMS agencies, hospitals, and healthcare systems, local government agencies, and other on EMS issues, just like the ones that we're going to be discussing today. Doug also serves as an adjunct at the law school where he teaches health law. He also serves on the Widener University Board of Trustees. Please join me in welcoming Doug Wolfberg.
Thanks, Christian. Good morning, everyone. It's a pleasure to be here. I first and foremost want to thank Widener Commonwealth Law School and Widener University again for their steadfast support in this program and hosting it and giving us this forum. And I want to particularly thank Dean Cummings for continuing that tradition of support, and really want to thank Professor Johnson and Corinna Wilson as well, who have really helped us spearhead this program from day one. Our core team has been doing this from the very start. So I want to really, again, echo and thank them for this as well. Let me clear the screen out of some stuff here. And we'll go ahead and really just jump into the program. So again, to thank Professor Johnson and Corinna. And I also want to thank our symposium sponsors. You heard both Dean Cummings and Professor Johnson kindly acknowledge our firm as a sponsor, but I also want to acknowledge the Ambulance Association of Pennsylvania, and Heather Harris is here with us, who's the executive director of the association, and the Pennsylvania Fire and Emergency Services Institute, and its director, Jerry Ozog, is also here with us today. And I want to thank those organizations who have been founding sponsors, who have been with us since day one when we started this program. Very quickly, I want to acknowledge the other colleagues from my firm who are here, Christy Malott, Ryan Stark, Matt Konya, and Scott Jockin. The last three that I just introduced are all also alumni of this school. So I wanted to take a moment to introduce them as well and thank them for being here. Real quick announcement before we get into anything. Those of you that are on the EMS side of the house, we know we have attorneys here. We have some law enforcement folks, some medical folks, EMS folks. There is a survey that will be open for a few weeks yet called the National EMS Documentation Survey, looking at EMS documentation practices from management perspective, from field clinician perspective, from medical director perspective, and we'd like to encourage all EMS folks in any segment of the industry to take that survey. You can screenshot that QR code, and then there is a link there as well, and you can circulate that amongst your organizations as well, and we'd appreciate that. I'm going to channel it here. If anybody else needs that, go ahead. Okay, for continuing education, just a couple of quick housekeeping things. If you are an attorney and you need continuing legal education, there are forms that were available at the registration table, and you know the drill. If you're an attorney needing CLE, you fill that out and return that at the end of the program. If you are an EMS practitioner, if you are a Pennsylvania EMS provider, today's program is accredited for 6 hours of continuing education in the other category. There is a EMS Con Ed sign-in sheet at the table. Some of you got here before the sign-in sheet. Not a problem. You can sign in at the break and put your information on that. If you are attending virtually and you're a Pennsylvania EMS provider, you can email one of the individuals I just introduced, Matt Konya, at mkonya@pwwemslaw.com, as you see on the slide, and provide the information that you see here, and he will assist you in getting your Con Ed if you're attending virtually. If you are an EMS practitioner outside of PA, most states will allow you to submit a certificate of completion, which we can email to you if you contact Matt, and the program agenda and materials to get your continuing education approved. And if you need assistance with that, you can also reach out to Matt Konya. And thank you, Matt, for coordinating all of our EMS Con Ed. Real quickly, our agenda is available virtually. There was a scan code at the reg desk when you checked in. Everyone should have also gotten an email with the electronic materials. But very quickly, we're going to start off with a session on case studies on preventing future failures in accountability in the EMS and law enforcement interaction. We're going to then have a group here from the Harvard-affiliated Medical Civil Rights Initiative that will talk about state legislative initiatives that they've spearheaded to close the statutory gap in providing care for folks in custody. Then we are very fortunate to have with us today 2 members of the litigation team from the Elijah McClain trial in Colorado, who will be joining us a little bit later. We're also scheduled to hear in person from the Commonwealth's Attorney General, Michelle Henry, and then we are going to hear from 2 of the authors of a new position paper, National Consensus Statement on Collaboration between Law Enforcement and EMS Practitioners, one of whom is our former Commonwealth EMS Medical Director, Dr. Kupis, who many of you know. And then we will close the day with a panel discussion with medical, legal, and law enforcement representatives taking questions. So if you do have questions, if you're attending virtually or in person, you can, we'll be able to open up the mic and take live questions here. If you have questions online, you can type those in anytime today during the program into your Zoom question panel, and we have folks that will be monitoring those and will be moderating questions at various times throughout the day. If you don't want to ask live questions, that's fine too. You can jot them down on a piece of note paper and give them to one of us, and we'll make sure we review those questions and put them before the panel later on today. So with that, I want to introduce a co-presenter on this program. Come on down. This guy there's a written introduction, but I'm not going to read it because he's also my older brother. So if I can't handle that introduction, we've got 5 and some decades of trouble. This is Mark Wolfberg, who is a retired police chief from Selinsgrove Area School District. Before that, for 30-some years, he was a police officer in Selinsgrove. Also, the original EMT of the family, became an EMT in 1976 when we were both busy watching the TV show Emergency. And then he went out and actually did it, and I simply followed in his footsteps. So, Mark, thanks for joining us. So what we're going to do is I'm going to start this session, and we're going to cover 4 different scenarios. And we're going to see some body cam video, and you'll see how these incidents unfolded for yourself. And then we're going to discuss both the EMS and the law enforcement perspectives. Mark will jump in with color commentary from the law enforcement side. And then we will open it up in case any of the audience has any thoughts on some of these scenarios. But more importantly, it's to really address the lessons that we can take going forward from these case studies. Some of these were very nationally prominent cases that you may have heard about before. But if we don't learn from these tragedies, then we do not want these tragedies and these deaths to be in vain. So that is really the main purpose of these today. So with that, I want to frame this issue because we're going to talk pretty much exclusively today about cases that have gone sideways, that have gone bad in the EMS law enforcement relationship and that have led to bad patient outcomes. But most often, the relationship between EMS and law enforcement officers on the scenes of emergencies is positive. It's beneficial. It helps patients. It helps the public. It helps the first responders. But sometimes, as we will see in these cases and others that have made national news, that relationship does go sideways, and it can lead to bad patient outcomes. And at the end of the day, that's what we're really here to focus on, and that is improving the care and saving lives of people who have medical needs who are in law enforcement custody. So we're going to look at 4 cases today, and these are, as you can see, Big Bang Theory inspired names of each of these cases, but we'll do these each in turn here. So the first case is one that we named the ambulance ejection collaboration, and this took place in Rochester, New York in November of 2023. So on November 30th of last year, it was a basic life support crew was transporting 48-year-old Julian Coleman to the hospital. So the transport was already in progress. The patient had called EMS for a report that he had difficulty breathing. At about 2:15 in the morning, the crew had allegedly contacted the city's police department and asked for their assistance in having Mr. Coleman removed from their ambulance mid-transport. And the crew reported that the patient had assaulted a crew member during the transport. The ambulance pulled over on the side of the road and met police officers, and you'll see this on the body cam video. You will hear Mr. Coleman say, "I was freaking out." You'd freak out too if you can't breathe. Then you'll hear this interaction where a police officer says, "Sir, that's a wrap. Looks like they want you out." He repeats, "I can't breathe. I couldn't breathe." He says, "They want you out, sir." The EMT then says, "We tried to help you, honey, but the way that you got in here and jumped at us is no way of somebody asking for help." And you'll hear all of that in real time. Mr. Coleman was removed from the ambulance at the direction of law enforcement, and as you'll see, soon after he collapsed on the sidewalk. He was seen lying motionless on the sidewalk for about 2.5 minutes until EMS reinitiated patient contact. They noted blood on the patient. You'll hear them observe that. And although this was a basic life support level transport, a paramedic supervisor arrives in a fly car or a non-transporting unit, as all of our EMS folks know, and you'll see this unfold. So this is a couple of minutes. Let's take a look at this case.
I don't know what's wrong with him, but he will not get out of our truck.
Okay.
And he's got to go.
Sir, it's a wrap. Looks like they want you out.
I couldn't breathe.
They want you out, sir. No fight at this time.
We tried to help,
We're just trying to get him
but
out.
the way that you got in here and the way that you just looked at us, that was no.
All right, sir. Come on.
way of
Come on.
somebody asking for help.
No games. Get out.
All right, I'm getting out.
Thank you.
Oxygen.
And you told us you had pain from drinking water, and then you came in and you jumped at me and my brother and demanded oxygen. You would not let go of me.
247, same traffic. 47, same traffic.
He grabbed my phone,
I was freaking out.
All right.
You freak out too if you can't breathe.
I hear you. I probably try to control myself a little bit better. I'm not going to grab on anybody. You know what I mean?
No, I'm trying to grab for the doors. I'm trying to get out of here.
Okay.
Try
Okay.
to
Now's your chance. All right. All right.
Oh, thank you. Did you take me to the hospital, man?
No.
We tried to take you, but honey, that was unacceptable. There was no reason for that. You
Okay.
want your water?
Sidewalk's right over there.
So, I don't know what this. I don't know.
Is that blood or is it?
Yeah, it's blood. Oh, I don't know what the hell happened. He was laying on the ground. I'm gonna find out now.
Okay.
Bye. Boss.
Oh.
Storm breathing. All right.
I grabbed your phone.
Just roll him over. What happened? Just like, I'm starting to lie down.
Oh my God.
Grab my monitor.
Is your car locked?
It's unlocked. Monitor and drug box.
So you heard the first statement on the video, "I don't know what's wrong with him." Sorry for a moment of levity, but that's because you failed patient assessment in EMT school, right? So that it's a pretty damning admission to start out with, to say, we don't know what's wrong with him, but we don't want to provide care to him any longer. Please take him out of our ambulance. And the outcome here is sad. That the patient, what we call coded, suffered cardiac arrest. and not to get too EMS terminology here, but they did achieve what's called return of spontaneous circulation, which meant they got his heartbeat and breathing back, but the patient never did regain consciousness. He was taken off life support a couple of weeks later, and according to his family, the cause of his death was anoxic brain injury, meaning he was deprived of oxygen for too long to sustain his life. And what happened after this is that the ambulance service fired an employee, disciplined 2 others. The state EMS office in New York opened an investigation. We have no public record of what the outcome of that was. No criminal charges were filed in this case. A civil suit was filed this spring, or summer, I guess, by the estate of Mr. Coleman. There were 5 counts. Counts 1 and 2 were what we call a 1983 action, which is a federal civil rights action, both against the city, the police department, and the EMS personnel. Count 3 was common law, just regular negligence, malpractice, so to speak, gross negligence and wrongful death against the ambulance service and its 3 personnel who were on the scene. Count 4 was a claim against the ambulance company, which is a private service, for negligent hiring and retention. And then count 5 was a similar claim of common law negligence, gross negligence, and wrongful death versus the city and its police officers. So this is a mix of federal statutory civil rights claims as well as state common law negligence or tort claims. And again, since we have a mix of legal and EMS professionals, I'll try to clarify the terminology on both sides whenever necessary. So note that, interestingly, the defendants did not bring a separate cause of action for patient abandonment. That's certainly a fact pattern that is raised here. But patient abandonment is really a negligence claim. And the plaintiffs did mention patient abandonment in the context of their negligence claim. And this is a snippet from that complaint that says, as a direct and proximate result of the negligence, gross negligence, reckless indifference, and intentional abandonment by the ambulance service and its employees, that the patient suffered this harmful outcome. So abandonment is an issue. Now, most lawyers in the room are very familiar with federal section 42 USC 1983, which is the so-called 1983 Civil Rights Action, which essentially says any person acting under color of law who deprives a person of rights that are guaranteed to them by the Constitution, in other words, deprives them of civil rights, which is why the name of this program is the Medical Civil Rights Program, can be liable to that person. That is the federal civil rights statute from where these federal claims arise. This civil case is still pending as of today. I checked the dockets the other day, and this case is still pending. And that's just a snippet from the docket. Now, what we want to do, again, is take the lessons and get some discussion going as a result of this case. And the first question, more for our EMS audience, is this. And we do have a couple of mics, and Ryan and Matt, or Scott, if I could press 2 of you into service to be our roving moderators with the microphones. They're right over here. We'd appreciate it if anybody does have any questions. But the first question is this. We talk a lot in EMS and in law enforcement about scene safety because we do not want our responders to be injured in the course of providing services to the public, or they're of no use to anybody. Does the principle of scene safety allow the EMS practitioners in this case to have this patient removed from the ambulance? Let me do a quick show of hands. How many people say, yes, that principle of scene safety justified the action in this case? How many in the audience say no? How many are not voting by hypothetical questions posed to them by lawyers? Okay, a couple of you, smart ones. So I think we had unanimous response, at least of the live audience, that that principle of scene safety would not allow or justify the conduct that we saw here. Let me ask Chief Wolfberg what he thinks about that, also being an EMS responder.
Thank you. Can you all hear me now?
Well, we need to hear you on mic, so you can come up here or you can use that mic, your choice.
Just hold it or just...
No, you can sit, or if you want to stand. Why don't you come up here if you're going to stand?
Okay, so the first thing I want to know is, where's my backup? Do we have any law enforcement in here?
Oh, no. We got law enforcement? All right, awesome. So I know I've got backup. So the position that I come from is kind of unique, I suppose. I did, by the way, I just got my recertification on my EMT, so I'm good now for another 3 years, okay? Just came a couple days ago. So I've been doing that a long time. But the unique experience that I have is that I've been in the back of an ambulance for many, many years, and I've also been on the other side with law enforcement. So I see that interaction. I've done that in my career for 40 years or so. You know, the thing about it is this is not a unique scenario. You know, you all read it, you all watched it, and have you had the need to contact law enforcement because you have an unruly patient or something? So definitely, once that, at least so what you're going to hear is, you're going to hear the law enforcement, maybe EMT side of me coming out, and then Doug will correct what I've said. So that's kind of what you're going to hear from me.
Payback for 50-some years of, just kidding.
Yeah. So I'm going to give you what my experience has been, and then, you know, we'll go from there. But so it's not a unique situation. I've been called many, many times to assist law enforcement or to assist EMS in a patient. When I first watched this video, my first reaction was, you can't just kick the guy out of the ambulance. I mean, that was just so wrong. You assumed, you know, that initial responsibility. You can't just kick him out because he's being unruly. Now, when you watch the video, when the police arrived, you know, he certainly did not appear at that point to be combative or unruly. A lot of times the presence of police will take care of that, but a lot of times it doesn't. So my take on that is that there was definitely other ways that incident should have been handled.
We're going to get into that.
Which I know we're going to get into that. So my take is, you know, we will assist, but not that way.
All right, well, stand by, because this next one. Well, first, feedback from the audience on that issue of scene safety, and go ahead, sir.
Thank you very much for the opportunity to speak. So in the context of this, and unknowing what the protocols are in the state of New York, would the ability to contact medical command in this scenario have avoided any type of neglect, depending on what the medical command physician would have stated to the EMS providers at that time?
Well, it's a great question, and I think we always advocate to get medical command involved in clinical decision makings, and we'll have Dr. Kupas and Dr. Miller here with us later. But you know, even if we had consulted medical command in a case like this, and if medical command would have signed off, medical command, by the way, is when EMS communicates by phone or radio with a physician at a hospital to help with clinical decision making on a scene. If medical command would have signed off on, yeah, it's okay with us, kick the patient out of the ambulance, I think all that would do is would have added another defendant to the civil lawsuit, because I don't know that we can say because a medical director told us to abandon the patient that we were justified in doing it. That's my opinion, both as an EMS provider and as an attorney. Ryan, down here, Chief Schmidt.
Thank you. Just a quick add-on to that, and that is the standard different in New York? I mean, in our practice, cops get in the ambulance with us, they go to the hospital, and we'd be done.
Right.
Expectation would be different in New York for any reason.
I'm also admitted to practice law in New York, and I have not yet found a statute, protocol, or regulation that says this is okay. Go ahead and kick patients out of the ambulance in mid-transport on a sidewalk. So there's no special rule or protocol in New York that would expressly allow this kind of conduct either. We have time for one more comment from the audience if there are any more. If not, that's fine. In the back, Scott, right to your right.
Are the EMTs trained in handling combative patients? I'm an attorney, so I don't know.
Well, it's a fantastic question, counsel. Yes. And that's one of the things that Chief Wolfberg mentioned, that there were other ways to handle this. And we might as well talk about that right now, because EMS practitioners have within their scope of practice patient restraint, dealing with agitated and combative patients. If they are basic practitioners, they can use soft restraints and things like that to help control the scene. If they are paramedic level practitioners, they can also use certain pharmacology, which can also go sideways. We'll hear about that later today with the Elijah McClain litigators. But yes, that is within the scope of practice and the standard of care for EMS practitioners to handle agitated and combative patients. I will note, however, as Chief Wolfberg pointed out, the patient at the time that law enforcement arrived and began recording on the body cam, we don't know what he did prior to that engagement with the police, but what we do know is that by any objective standard, he did not appear combative and he did not appear to pose a threat to anyone at that point. And as Mark pointed out, oftentimes the mere presence of law enforcement, and I think any EMS responder here knows that, can change the patient's disposition and achieve compliance in those situations. And that, none of those techniques or none of those alternative approaches were used here. But let me pose this question to my colleague here, and that is, were the police obligated to remove Mr. Coleman when EMS asked him to do that? I think we have to address the question of whether they had a legal duty to do that. Do you want to get on, Mike?
Yeah, definitely. The short answer to that is no, we're not obligated to remove them. The police officers, when they get on the scene, are going to make a determination based on the totality of the circumstances. So if I get there and I see that, my observation is important, I find out what happened, I look at what's going on now, I don't have that requirement. In other words, the EMTs can't direct the police to get this guy out of our ambulance. We don't have to comply with that. There's no requirement that we make that arrest or forcibly take somebody out because somebody else says they want him out of there. So that's my answer.
You know what? I agree with that.
Well, thank you.
It's nice when we agree. Okay, here's a question that I think I know the audience's response, what it will be, but did EMS breach a duty of care to the patient in this case? Quick show of hands. How many say yes? How many, does anybody say no? Because you are in the wrong seminar if you say no. Okay. And here is another, this is more of a legal question. Anybody is free to have an opinion on it, because if this was a jury trial, right, jury of her peers, everybody would get to weigh in on this. But did law enforcement violate the patient's civil rights here? Did they deprive him of a constitutional right under color of law? Show of hands. How many people say yes? How many say no? How many need more information to make a decision? So certainly that is one of the key questions, and that's one of the questions that will come up in the civil case, because the plaintiff, the estate of Mr. Coleman, will have to articulate a constitutional basis for the alleged deprivation of those civil rights. And, the duty for law enforcement to provide care is very narrow. But what I see as a differentiator in this case is the fact that nobody was asking the police to provide care, but the police actively deprived the patient of, I'm going to put the word care in air quotes here, because a patient whose chief complaint was shortness of breath did not even appear to be on oxygen. So we don't know what care was actually being rendered, but a transport to a hospital was in progress. And we can presume or hope that he would have received appropriate care, at least at that destination, but he was delayed and ultimately deprived of getting that care. We do not have body cam video of what transpired prior to the law enforcement interaction. But what we do know is at the time of his removal from the ambulance, he was at least appearing to be calm and compliant, and importantly, posing no active threat. And we talked about the term abandonment, but in my view, this does constitute abandonment. That is not as common of a tort as I think a lot of folks in EMS think it is. But in this case, I don't know what else we could call it, because care was in progress, that care was stopped without any justification, and it was not turned over to any other providers, and we saw in real time the outcome. And Chief Wolfberg talked about this, but we talked about whether or not the police were under a legal duty to remove the patient when requested by EMS. And I think the chief correctly said that they were not. But my second question for the EMS professionals is, was it appropriate for EMS to ask law enforcement to do that in the first place? How many folks say yes? How many say no? Where are our non-voters on hypothetical questions posed by lawyers? All right. So in that case, and I think that goes to what Mark said here a minute ago, and it really is staying in our lane. We shouldn't be directing law enforcement activity. It's their standard of care. Just as we would not want, on the EMS side, law enforcement to say, give this person ketamine, or provide this treatment, or do that intervention, right? We can ask for assistance. We need EMS help, could the police say. We need law enforcement assistance in securing the scene. So could, EMS say. But to direct those other professionals who have their own training and their own standard of care is where we sometimes veer out of our lane. And I think that's one of the lessons we'll talk about as well. Law enforcement certainly may have violated Mr. Coleman's civil rights by actively depriving him of care that was already in progress. And I think that draws a distinction between their duty to provide care and what happened here, which was the deprivation of care that was actually in progress. Mark, why don't you talk about this one? Some of the other things that EMS and law enforcement could have done instead of just kicking him out to the curb.
Yeah, so, and then I do want to, at some point, change the scenario up just a little bit to kind of get the crowd's reaction. But in any way, so many other things that could have been done here, right, in the back of that rig, okay? They called the police, they asked for assistance. We're here now at the direction of EMS. The first thing out of their mouth was, get this guy out of here, right? We don't want to get him out of here. And, the police kind of said, well, you guys are the EMS professionals. He doesn't look like he's in any kind of duress right now. All right, buddy, let's go. It's a wrap. Get out. All right? That's kind of the way it happened. But he's already being treated. He's needed some EMS stuff there. So other ways that this could have been handled. Okay. Could they have asked the police officer to ride along? There was more than one officer there. Could they have asked the officer to maybe, jump in the rig just to make sure this guy remains calm till we get in the back of the, till we get to the hospital? Would that have been a possibility? Could they have done that? Yeah, absolutely, right? They most definitely could have asked an officer to go along in the rig. What about following us? If we, could they have done that? Could the officers have suggested that? We're not going to ride in the ambulance, but we're going to follow you. And if we have communications with you or whatever, or if you have a problem, pull over and we'll be right there. That could have been done. At that precise moment, I didn't see a need to restrain the individual, but if he was actively combative at that point, there's many other ways that he could have been restrained, both with law enforcement using handcuffs, which then you'll hear some people say, well, that means he's now in custody, and that'll be something else that we're going to talk about. But the ambulance also has restraints that they could have used as well, if that would have arose. So there's many other options that were available rather than saying out.
Yeah, well said. So to put a bow on this, I think we have one question or comment up here. Go ahead, sir.
Do we know if this guy was a frequent flyer?
We don't. So just to translate EMS lingo, frequent flyer is what we in EMS call a loyalty customer, somebody who calls 911 often, and we do not know that. Yeah, it's a good question. Ryan, over here. We'll take one more, and then we're going to jump to the next scenario.
Good morning. Thank you. I'm just curious, most of this happened before the paramedic supervisor arrived on the scene. And it appeared to me that as soon as he got on the scene, he walked up, he assessed the situation, and he started giving care. How does that fall into the civil suit that they are placing against all three of the EMS providers? Because he did what was appropriate when he got there. And he probably didn't have, just like us, had no idea what occurred prior to the incident itself.
Yeah, that's a great point, and it proves that not everybody brings the same level of culpability or guilt to a scenario. He is named as a defendant, but certainly the defense will be able to raise the very points that you say. There's no prohibition against the plaintiff suing for those facts, but the defense that you can mount certainly will be different based on how each defendant acted or participated in this. And I wouldn't want to be the first EMT that we saw whose first words on the video were, "I don't know what's wrong with him," and last word on the video when she was told to go get the medic's monitor was, "Oh shit," right? So that does not frame the facts very well. Corinna, did you have some no from online? Okay. Okay, let's go ahead. We're going to jump into the second scenario. That this one's called we call it the handoff passivity. This was in Springfield. If you were in last year's program, I talked about this case a little bit last year. This was December of 22, where 35-year-old Earl Moore was suffering from alcohol withdrawal and hallucinations. It was a private residence. It was initially a police call, and they arrived within 2 minutes of the call. Let's first take a look at the video. And by the way, these are all edited. These are not real time. So please understand that these are edited, and we tried not to edit them in a way that would make any party look better or worse. So you won't hear every...
There's no one here with guns. Okay. He's hallucinating. He's having alcohol withdrawals. He's having drunk hallucinations. He called you guys for no reason.
Do you want us to talk to him?
He's seeing stuff that's not there.
Do you think he needs an ambulance?
Every time I take him to the hospital, all they do is release him.
Earl? It's the police. You called us, my man? You need some help?
48.
I'm sweating.
248 North 8th Street. 24.
Ambulance.
Someone get the phone.
What's up, bud? This is Earl. Haven't been able to get much out of him. It's day 3. He was up on his bed and he just rolled off onto the floor after he's been slowly stripping off of his clothes.
Earl.
What's your birthday, man?
Hey, it's your birthday. You know what? I am not playing.
Come on, Earl. Let's
Sit up.
my man.
What happened? Stupid.
Stop.
Sit up. Sit up now. I am not playing with you tonight. Sit up. What is your birthday?
Earl, do you want to go to the hospital, man? We need to get up.
You're
All
gonna
right.
have to walk because we ain't carrying you.
So let's get up on your feet.
Because I am seriously not in the mood for this dumb shit.
You can walk. Come on. Let's stand up.
Walk.
Help me up. Let's go. Come on. Help yourself. All right. 1, 2. There you go. There you go. There you go. Come on, buddy. Keep it moving. All right, we're moving. We're moving. Let's keep going. 1 foot in front of the other. Come on, buddy. We got you. We'll hold you up, but you gotta walk forward.
Come on, Earl, man. You gotta help us out a little bit.
It's right there. Right there.
Keep going, buddy. Push. Now get up on there, man.
Come on, get up on there, old bud.
All right, Earl, this is getting a little silly, man. Here you go. There we go.
Highlights that you saw and heard. You're going to have to walk because we ain't carrying you because I am seriously not in the mood for this dumb stuff, said paramedic Peggy Finley. Now, the transport here was a very short distance. It was only a mile or two to the receiving facility, the hospital. But we have radio communications between paramedic Finley and the hospital, even in that brief transport. And I want you to listen to a brief clip of that. So another quote that you heard, "I'm not messing with getting vitals," which means vital signs like pulse, blood pressure, respiratory rate, because I'm not going to poke the bear. And this was after they chose to restrain the patient in a prone, face-down position, and then, as you saw, pretty tightly secure the straps around Mr. Moore. So we have EMT of the Year, Peggy Finley, who we saw in action here. And again, not to make light, but the patient was in cardiac arrest when he arrived at the hospital, and he was pronounced dead about 75 minutes after police first came to the house. Cause of death was found to be compressional and positional asphyxia due to prone face-down restraint on a paramedic stretcher. By the way, the autopsy report also found evidence of recent hemorrhagic rib fractures, meaning fresh bleeding from new rib fractures, not old ones. And the location of the fractures was consistent with the place in which you saw EMT Cadigan place those straps and tightly secure them. So based on that evidence, these two EMTs were charged with first-degree murder, folks, first-degree murder. And it's important, I think, for us to take a very quick look, since this is also a legal CLE program, to take a quick look at the statute that allowed the prosecutors to charge in this case at that most serious level. And it says, person who kills an individual without lawful justification, like self-defense, for example, commits first-degree murder if they perform acts which cause the death, if they intended to kill or do great bodily harm to that person, or know that what they do will cause death to the individual or another. I do not think that is the relevant provision here. There's no evidence that they intended to kill Mr. Moore. But the second part of that charging statute says, he or she knows that such acts create a strong probability of death or great bodily harm. Do you think a prosecutor can prove that these two EMS clinicians knew that restraining a person face down and then tightly securing straps creates at least a strong probability of death, or if not death, of serious bodily harm? Right? It's kind of a rhetorical question, but this is a very serious charge. It's not negligent homicide or reckless manslaughter. It's first-degree murder. But as this statute is written in Illinois, it seems to me that the prosecutors at least have a case to see if a jury agrees. There was also a civil case filed in January against the EMTs. It's also a private company and their employer. They also interestingly named the hospital that provides, it's a medical resource hospital that helps the ambulance service with its clinical issues and protocols, named them in the lawsuit, but the court granted that hospital's motion to dismiss in November of last year, ruling that that hospital had no liability in this case. This is a clip of some of the court's reasoning in dismissing the hospital, and you can see that in your handouts just in the interest of time. The criminal case is pending. We checked, again, that docket. There was a hearing last week. The case has been continued, is still on the trial calendar. Of course, we know, folks, that a criminal case could result in a plea agreement. It may not go to trial, but it certainly may, and it is still on the court's calendar. The civil case settled in May of this year because this was a settlement with a private company, not with a government agency. The amounts paid are confidential. We do not know what they were. My bet is that there was a couple of commas in the amount, but again, that is confidential. All right, here's our questions for the audience. This one we'll just do show of hands. Was EMS negligent in this case? Were they grossly negligent? And the more controversial question, was their conduct criminal? How many people believe it was? How many believe it was not, or at least not at the level charged? And I think that is a question. I think some folks do believe that this case was overcharged, meaning that a negligent homicide charge may have been more appropriate as opposed to a first-degree charge. But certainly we saw the statute, and the prosecutor, I think, does have a case that they can make the way that statute is worded. All right, here's where I want to get into the topic at hand, and that is, after EMS arrived, or we could even say before, what do we think about the conduct of law enforcement in this case? Was their conduct, just in a very general manner, appropriate? How many people would say yes? How many would say no? So I'll set the table here and then turn it over to Mark to add some color commentary here. But I have a few thoughts on that, and that is that, the police were not charged, by the way, or brought into a civil case. And the reason for that is if you're a prosecutor and you see the comparative conduct of the EMTs and the police are the only ones being helpful. They're the ones who help move the patient to the stretcher, not EMS. They speak courteously to the patient. They treat him with respect. Earl, my man, what you didn't see on the video, can we get you some water? Earlier, we edited that out just for the sake of time. They were courteous. I have a different view, however. If you charge these EMTs with first-degree murder, didn't law enforcement stand by and watch a first-degree murder happen in real time? And in my view, even though they were cooperative, courteous, and respectful to the patient, this was a failure of interagency accountability. Was there any reason at all that a police officer couldn't take EMT Finley into another room and say, yo, Peggy, I don't know who, whizzed in your Cheerios this morning, but you're obviously having a bad day. Why don't we take another, collect our breath, collect our thoughts, go in and try this again and take care of this person, right? You don't have to be medically trained to see that what was happening in real time was simply not appropriate. So I don't think legally there would be a case against the police. My quarrel is more ethically and morally, that failure of accountability that we saw in real time. Let me turn it over to my law enforcement brother, literally.
So I differ a little bit.
Of course.
Remember what we heard earlier, stay in your lane kind of thing? So as a police officer, one of the questions I would have to these police officers, did they have any medical training? Were any of them EMTs? Or did they just have CPR and basic first aid? I think that's important, right? So whether or not they, agreed with the way it was being done, if they lacked the advanced medical training, at least to the level of an EMT, I think that would be very, very important in this case. But second of all, what was the response by the police? Did they act appropriately? They got on the scene, they assessed it. The first thing they did then was they contacted EMS. EMS showed up. We've got the people who are supposed to be medically trained taking care of the patient now, and it's up to them to make that determination. We will assist you if you need help lifting or any of those kind of things, but that EMS decision then is kind of handed off. And the way I look at it is, if I have standard first aid and an EMT shows up, I am able to transfer that level of care to somebody who has more care. And I think that's what the police did here.
Does your answer change if any layperson could look at what the healthcare provider was doing and know it was inappropriate?
Well, again, here, we're talking about, when you have somebody showing up that does have that advanced level of care, that is critically important. They're the ones who are making that assessment, whether they did it right or wrong. That's I think what you're getting at. But I think once those individuals are on the scene, and just the way it is, I'm an EMT, if a paramedic shows up, you've got the advanced level of care, okay? I will assist you, but you're now in charge.
Chief Mark Wolfberg, expert witness for the defense. All right, so I've already shared my view about the legal and moral duty and the differences, I think, in this case. Just very quickly, again, we mentioned there were no criminal charges filed against the police officers in this case, and it would be a tall order to bring criminal prosecutions against them just based on the way they acted, right? Which tells us a lot about the power of body cam video and the people who don't appear courteous and respectful and treat a person with dignity. The police did. I wouldn't charge them, honestly, if I was a prosecutor, but the moral failure of accountability, I think this was apparent to any layperson. And as I said, if these EMS providers committed first-degree murder, police officers watched it happen in real time. And I think the more important lesson here is the failure of accountability between these agencies. They're not medically trained, but I think most lay people could see what happened here and conclude that this was inappropriate care. And to the chief's point here, this is, I think, a telling piece of evidence This was the Springfield Police Department's press release, released on the date that the criminal charges were filed. The Springfield police officers who responded to this incident recognized the patient's need and requested medical assistance. This is true. When those personnel acted indifferently, I'm sorry, how did you know that that was indifferent care? Oh, because a layperson could see that and recognize it? Sorry, I'm adding color commentary here. They took steps to assist the patient, true, to get him the care he needed, even waiting on scene to ensure the medical personnel loaded the patient into the ambulance, even though they didn't do a damn thing elsewise. The officers, who are not trained emergency medical professionals, are not trained or equipped to provide the necessary treatment or transport patients in this type of situation. They turned over care to the licensed medical professionals at the scene in accordance with our policy. So if you're an EMS provider and you feel slightly under the bus, then obviously the Springfield Police Department sees it the same way that Chief Wolfberg sees it. And of course, that is the contrast in this case that ultimately juries would have to decide. Okay, let's turn it over to audience. We have two over here. Real quick, since we are a little behind on our cases, but go ahead, sir.
I have to agree with the chief. The other thing is the fact that I guess you could call him the victim since he died, was alive and well when they put him on the litter. We don't know what happened between the time they put him in the back of the ambulance and that short drive to the hospital. So I would have to agree with your colleague and your brother from the same mother, I believe, but anyhow.
Thank you.
Just a question. The police aren't trained in understanding the complications of prone restraint. And if they would recognize that that's happening in front of them, they wouldn't say anything or object?
Well, I'll ask Mark to weigh in on that. First of all, I'm not sure how much training is needed to know that, but in this day and age, with the number of high-profile prone restraint deaths in custody, to not know that, I think, is negligence in both law enforcement or in EMS. Do you want to quickly be heard on that?
Yeah, I mean, as a police officer, there's very few times, if any, that I can even remember ever subduing somebody and transporting that way. It's just not a standard of care that we have as police officers. But, again, the question is, did they stand by and let that happen? Again, I think once that handoff is kind of done to medical personnel, then they're kind of relying on their expertise and their professionalism, or lack of it, to do the right thing.
Yeah, good questions, good points. By the way, we're going to come back to prone restraint, unintentional prone restraint. I know that sounds odd, but we're going to see that in the fourth case. So we'll revisit prone restraint here in a couple of minutes. Again, in the interest of time, I know we're picking up the pace here. I do appreciate the feedback. I want to talk about the third case, what we call the inactivity conspiracy involving Tyree Nichols in Memphis, Tennessee in January of 2023. Mr. Nichols was stopped by a unit of the Memphis Police Department known at the time as the Scorpion Unit on suspicion of reckless driving. There was a struggle, and after about a minute of that struggle, Mr. Nichols broke free and fled on foot. About 7 minutes later, he was apprehended. Then for about 3 minutes, both in a standing and seated position, he was severely beaten by the police. Following that, EMS from the Memphis Fire Department, the first unit that comes in is a fire engine that has advanced EMTs on it. You'll see that they prop Mr. Nichols up against a vehicle a few times as he continues to slump to the side. And then there's about 16 minutes. You're not going to see the whole elapsed period, but it was, according to the body cam timestamps, about 16 minutes when Mr. Nichols is unattended by any medical providers at all. And then an ambulance pulls up and he is ultimately transported. Let's take a look at the excerpts of that video. I'm sorry, let me set this up by saying this is very graphic.
Get the fuck out the fucking car! Damn, I didn't do anything! Hey, I didn't turn your ass around! Alright. Hold the ground. Hey, you don't do that, okay? Lay down! Okay, you guys are really doing a lot right now.
Bro, lay down!
I'm just trying to go home!
Lay down.
Man, if you don't lay down... Oh, I am on the ground! Put your hand on your stomach! I got it. Here,
the fuck back up! I'm not doing it! Please!
Give me your fucking hand. Give me
bro.
your fucking hand. Give me your hand.
Hey.
Give me your hand. Give me.
Come on, fuck over here.
That motherfucker high.
He high.
Come on.
He high as a mother. Hey, sit up, bro. Sit up, man.
And here you go, screen.
What the fuck wrong with my radio, bro? Shit. My shit off the channel like a motherfucker.
I see bean chasing right here. I ain't want my light in.
Damn, where my light go, bro?
He got me. I was high as a kite. Yeah, I'm a you sit up for us. Bro, I hit that man with so many pieces and he's
Trying to get you straight, man.
Time I'm gonna skip ahead, but eventually the ambulance pulls into the frame of the video and he's transported. But there was that 16-minute gap in which they sort of approach Mr. Nichols, but there's really no assessment or care provided during that 16 minutes. Mr. Nichols died 3 days later. Cause of death was blunt force trauma to the head, and the Memphis Fire Department terminated 3 employees. 2 of them had their licenses suspended by the EMS agency in Tennessee. 5 police officers were charged both with federal and state crimes, including second-degree murder. Recently, there was a verdict in the criminal case just a few weeks ago. It was a mixed verdict. 2 officers had pled guilty, and 1, I believe, testified against the others. 3 went to trial. That verdict came down just on October 3rd, about a month ago. 2 officers were acquitted of the most serious charges in that federal case, and they were convicted on lesser charges. 1 was convicted of civil rights violations, but only in causing harm to Mr. Nichols, not in killing Mr. Nichols. And there were acquittals on excessive force and what we call the deliberate indifference to serious medical need, or 1983 action, which we talked about earlier. There's a civil suit pending brought by the family last spring, 25 counts against Memphis Police and Memphis Fire EMS, including civil rights 1983 actions and a range of tort claims under state law. And some of those claims that you see are listed here as well. These are excerpts from the complaint. Just very quickly, they allege that the EMS providers disregarded Mr. Nichols' condition. They allege that they were milling around, which the video does support, and that the officer in charge, who was also an EMS provider, never left the engine to assist or supervise on scene. And here's just a litany of some of the allegations against the EMS practitioners in this case: that they didn't assess Mr. Nichols' breathing, that they didn't get vital signs, they didn't do a head-to-toe physical exam, they didn't uncuff him, not that they could, but they didn't ask for him to be uncuffed. They didn't attend to obvious wounds, provide high-flow oxygen, start an IV, place him on a cardiac monitor, or promptly transport him. That case is pending, as of at least the other day, according to the docket. First question, was Mr. Nichols in police custody at the time EMS arrived? Yeah, very little question of that, I think. But the follow-up, which is more important, is does the patient being in police custody in any way change the EMS standards of care that are expected to them? I see lots of head shaking no. Does anyone say differently? All right, we can dispense with those first 2 questions easily. But was there an active deprivation of care here? Was EMS being prevented from accessing Mr. Nichols? The video does not appear to show that that's the case. He wasn't locked in the back of a squad car. He wasn't being detained in a place where EMS couldn't access him. And that's why we call this the inactivity conspiracy, right? Because there was just no activity. There was no assertion of EMS control over the patient care aspects of that scene. And that is really one of the significant shortcomings here. And the reason I ask and tee up this scenario with the question about whether he was custodial or he was in custody at the time was because there are certain decisions that EMS would have to make that are impacted by that determination, right? For example, if a person is in custody, they're not free to leave. And if the police say take the person to the hospital, the person's custodial, they can say that. But that would be the end of law enforcement's involvement in the clinical decision making. Which hospital EMS goes to is going to be determined by the clinical condition of the patient, whether he needs to go to a trauma center or other specialty care destination. What care is provided is up to EMS. But if the person is not in custody and they're competent mentally to make a decision and say, I don't want to be transported, they have the legal right to say that. When they're in custody, they don't have that legal right. So it's important for law enforcement in these very gray cases, sometimes gray areas, to clarify that status with law enforcement. And our treatment decisions have to be clinically based. But whether they are in custody or not, that does not relieve EMS of their duty of care. And if police had deprived EMS of the opportunity to assess or treat the patient, none of which apparently happened here, then EMS needs to be assertive in demanding that access to the patient and promptly intervening and assessing and then treating the patient. If EMS is denied access, then those body cam videos should show EMS advocating to get that access. And if ultimately law enforcement denies it, that liability may be on them. But for EMS to advocate is really one of the lessons that comes out of this case. Nowhere does our standard of care change or allow us to delay care simply because a person is in custody. All right, let me take, we did this one very quickly, but first let me open it up to Mark for comments on this one that you may have from a police perspective.
So up till this point, I think there was a pretty good backing for law enforcement until we showed this video. There's no way that I can at any time support what these guys did, all right? My entire career, never did I act like this. You know, there was enough law enforcement there to subdue this guy, get him under control, end of story. There was no reason for the beating. There was no reason for that brutality, ever. So that's the first thing. But let me ask you guys real quick. How do you know he was in police custody? How do you know?
Wearing handcuffs.
Oh, he's wearing handcuffs. So now you as an EMS provider say, we need to assess this patient. Okay, go ahead. I need you to take the handcuffs off. And what do you think the police are going to say at that point? Nope. Is that going to change your standard of care?
But again, I think if the police deny that access and don't remove the cuffs, and I need him to be uncuffed to treat as an EMS practitioner, then I don't want to passively the first time say, okay, officer, we're just asking. It should be, officer, this patient appears to be seriously injured. I need to assess and access him. I may need to start an IV. I'm going to need his arms. I'm going to need him uncuffed. You can stand by and make sure that the scene doesn't de-escalate or escalate, but I need him uncuffed. That's the advocacy that I'm talking about that we need to practice in these videos. We'll get back to that in a minute. Quickly, anything from the audience before we do our fourth case? Okay, let's do this last one called the positional acquiescence. This was Baltimore in July of 23. On July 25th, it was 4 in the afternoon. Someone called 911 to report a man lying in the street, trying to kill himself and fighting everybody. 2 Baltimore City fire medics arrived, were the first to arrive. They got there before law enforcement. They found 29-year-old Trey Ellinger speaking incomprehensibly and flailing. EMS requested police assistance. The patient had lunged at one of the medics, then they attempted to speak with him. And over the next few minutes, officers from 2 different departments, Baltimore City and Metro Transit, arrived on the scene. You will not hear this on the video, but there was a discussion between 2 of the officers that they say that the medics had asked for the patient to be cuffed because they wanted to try to sedate him. Police officers then physically restrained Mr. Ellinger, placed him in handcuffs. One officer says, "We don't want him face down." Great, good, nice to hear that. About 16:27, about 4:30, the medic from Baltimore Fire injects the patient with a drug called Versed, a sedative, and at the medic's instruction, the patient was then lifted on the stretcher. Again, you will hear one of the medics say, "As long as he's not face down, that would be great." Police say, "We don't want him in the face down position." EMS say, "We don't want him in the face down position." Everybody agrees. Let's make sure he's not in the prone position. After flailing around, the patient shifted himself into a prone position. He was moved to the ambulance about 2 minutes after the Versed was given. The crew assessed the vitals while Mr. Ellinger laid in the prone position. After about 4 minutes inside the ambulance, they had a discussion about repositioning the patient, and a medic says, "I'd rather he be on his side." And a police officer says, "Yeah, absolutely." The straps were loosened. The patient was moved to a what we call lateral recumbent on his side position. They observed that the patient's lips were blue. The police officer asked the medic if he could release the handcuffs. The medic said okay, and they initiated resuscitation. Let's take a look at some of the excerpts of that incident.
Hey, relax. Calm down, bro. Hey, what's your name? Hey, Alex. All right, listen, we gotta put your arms behind your back, all right? You're good. You're all right. You're all right. Okay? You're all right. Yeah, calm down. Did you take something? You're good, man. Calm down. All right?
Alright, sir. It's okay. We're here to help you, darling.
Yeah, just kind of put him in a daze. Okay.
This is his, right?
Yeah. Okay? You're all right. Yeah, calm down. No shackles. You don't have any? Nah. Okay. Thought I did, but. Yeah. As long as he's not laying face down, it'd be great. Yeah. 605.
We're trying to help you, darling. It's the police and the medics, okay?
That was like gabapentin.
It's okay, darling. It's all right. It's okay.
I don't know what that is.
It's all right. All right, y'all must get him.
Am I riding with the knife or just following? No, you ride. You get your vehicle. I'll ride.
I got a wallet.
And that graphic basically says that the state attorney general redacted the video once he got in the ambulance because that was a private patient care area, which props to the attorney general for recognizing that. Mr. Ellinger was pronounced dead later that day. Cause of death was mixed drug intoxication. There was a state attorney general investigation. No criminal charges were filed against either law enforcement or EMS. No public disciplinary action against any EMS providers in the case that we were able to find. No civil suit filed by the patient's family, so no legal outcomes. But, and I think we've sort of touched on this earlier, was it appropriate for EMS to ask law enforcement to use handcuffs? How many say yes? How many say no? So we have some mixed opinion on this, but I think one of the issues here goes back to what we talked about earlier, and that is, I think we can ask for assistance if we believe a patient needs restraint, but the manner of that should be up to law enforcement if we're asking for their help, just as that we wouldn't want them to say, I think he needs ketamine instead of Versed, right? We would not want law enforcement directing patient care because that's our wheelhouse, right? So I think that's at least how I see it. Mark, real quickly, do you want to weigh in on this? Was it appropriate for law enforcement to put the patient in handcuffs because they were asked to do that?
Yeah, and again, this is something that is not unusual. We're there to assist. That's our job. If we're being asked to put the patient in handcuffs because they need to continue medical treatment by administering medication with a needle, and they can't have them flailing around, I see that as a way to assist. It doesn't mean I won't ask, well, don't you guys have restraints or something? Because, you have that thing in the back of your mind. Well, once I put the handcuffs on him, now he's my responsibility. But, I've done that to assist, get him in the ambulance, and then take the handcuffs off, and he's restrained.
Thank you. Now, here's another question, and we'll visit this later on the panel discussion as well. When Mr. Ellinger was moved to the cot, he had handcuffs on, and you saw him reposition himself into the prone position. He was on an EMS cot. He was in law enforcement handcuffs. Whose responsibility was he? How many say it was the police's responsibility? How many say it was EMS's? How many say both? I agree. I believe both had duties of care to Mr. Ellinger in this case. And it is clear that no law enforcement officer or EMS provider physically placed Mr. Ellinger in the prone position. The video does clearly show he positioned himself in that position. However, Mr. Ellinger's hands were cuffed behind his back and not in front of him, which some have said facilitates easier rolling into that prone position because of the position in which his hands were cuffed. Mark, real quickly, do you agree with that?
Yeah, absolutely.
Okay. And the thing that's so troubling is that there is evidence that both the police and EMS recognized the imperative not to put Mr. Ellinger in a prone position, yet when it happened, through nobody's fault, which is probably why there's no lawsuits or criminal charges in this case, nobody promptly acted. And as we all know on the healthcare side of the audience, 4 to 6 minutes can be a very pivotal period of time, and that was all it took here for Mr. Ellinger to go into cardiac arrest. Once Mr. Ellinger maneuvered himself into the prone position, it was the failure to promptly respond to that and promptly reposition him that is the teachable moment here. And I think most of us saw that he is both a person in custody and an EMS patient in time, which is why both agencies had legal duties. Very quickly, so I can respect our agenda and get you to your break, I want to just whistle through these takeaway lessons, many of which we've already talked about. But the first is that EMS and law enforcement agencies need to conduct collaborative, scenario-based training. We need to develop the muscle memory of appropriate access and timely treatment to patients, and both agencies need to be accountable to make sure that happens. Live role play, virtual VR technology, whatever we use, all of those scenario-based trainings really are what will help to address that. The training also, in my view, has to include training and recognition on implicit bias. All humans have implicit bias. You're not a guilty mind to have them, but the key is to recognize them and be able to neutralize their harmful effect when providing care to patients. Some people in custody are bad people, some are good people, but at the end of the day, it doesn't matter when we're healthcare practitioners with the duty of care to human beings. Second is we have a duty to access patients who are in custody. That is part of our duty to act, and we should be seen and heard advocating for that access when it is not promptly offered to us. Number 3, this is more on the clinical side, but patient assessments are foundational to everything we do or don't do as healthcare practitioners. If we're going to give a patient ketamine or Versed or restrain them or not administer oxygen or administer oxygen, all of that flows from a foundational patient assessment. It's the patient's clinical needs which drive the care we provide. Lesson 4, we cannot subordinate our judgment to that of law enforcement as EMS practitioners. Always our treatment has to be clinically based and not directed by law enforcement. And related to that is Lesson 5. We've talked about the need to stay in their lanes. Police can ask for EMS help. EMS can ask for the law enforcement help. But how that help is provided is within the standard of care of police and of law enforcement, and each should be allowed to make their decisions in the best interest of the patient in accordance with their own standards of care, but collaboratively to promote patient safety. And we've talked about this. Lesson 6, if we're not clear about custodial status of a person, we need to obtain clarity in that because certain decisions, as I've said, are not up to the patient at that point. Lesson 7, if a patient is in handcuffs, you heard Mark say that they're the police's problem. If they're in handcuffs, the person with the key to those handcuffs should be accompanying EMS during transport. If they're not willing to do that, we can't legally make them do that, then those handcuffs should be removed and soft restraints or other chemical pharmacology should be administered as clinically appropriate. Lesson 8, EMS needs to practice patient-centered advocacy in all cases and be seen and be heard practicing that advocacy. Lesson 9 is related to that. We all need to act at all times as if cameras are always on us. Police body cams, EMS body-worn cameras, bystander cell phone cameras, surveillance cameras in a home or a workplace, traffic cameras, you saw some of those, overhead cameras. And we have to practice what we call performative EMS. Our first role is to be competent clinicians. But when these interactions are being recorded, we have to be seen and heard being patient advocates. And I think if you would have seen and heard different things on some of these body cams, some of those providers would not be facing the criminal charges they are. And I think that's just a simple reality. Prosecutors are human, and when they see the parties involved acting as humans, it's going to be a lot harder to bring criminal charges when they're acting in the best interest of the patient and being seen doing that. So we want those body cam videos to show the tools of the trade being brought promptly to the patient's side, first in bags, cardiac monitors, pulse oximeters, whatever we need to have, prompt access of the patient and a thorough assessment being done, rapid response to any life threats that we detect, not deferring to law enforcement on clinical decisions. We want those body cam videos to be showing those things. And then finally, EMS needs to update, revise, and then train on new protocols for people in custody and law enforcement situations, use of restraints, use of sedatives. If you're an ALS agency, we should be scrubbing the term excited delirium from those protocols. That term is no longer recognized by any of the national clinical organizations. The American College of Emergency Physicians has replaced that with the term hyperactive delirium with severe agitation. I will tell you though, folks, it doesn't matter to me what you call it. If that term is invoked only as a pretext to give a drug or to do something inappropriate, you could call it pink fuzzy bunny slipper syndrome. And if a paramedic says, yeah, he's got pink fuzzy bunny slipper syndrome, I want to give him ketamine, that's the wrong reason, right? So whatever we name the syndrome, the clinical interventions always have to be based on an appropriate assessment. Okay, with a couple of minutes behind, we have a 10-minute break. So we will start back here in 10 minutes and start with the next session. Thank you all so much. Thank you, Chief. Okay, ladies and gentlemen, as everybody's getting seated, I want to introduce our next presenters here. And we are so fortunate to have them with us here today. Let me, a moment there. Now this should work. Okay. This is a group from the Medical Civil Rights Initiative. They will tell you a little bit more about the initiative, but I want to introduce the three presenters. First is Leonore Dluhy, who is the Executive Director, Co-founder, and Principal Investigator of the Medical Civil Rights Initiative. Her interest is in health equity and access to care. Led her to co-founding the Medical Civil Rights Initiative with Drs. Robert and Deborah Dluhy in 2019, after having studied under judges in both the federal courts and with courts of appeals in the First and Tenth Circuits. Leonore is a creator and drafter of the Medical Civil Rights Act, just a groundbreaking piece of legislation, which we'll hear a little bit more about, and the principal investigator for the Medical Civil Rights Initiative, focusing her current research into custodial deaths, the delivery of care during law enforcement interactions, and amending data reporting requirements. Her long-standing goal is to ensure that over 70 million people who currently do not have an affirmative right to EMS care are promised such a right, and that the prevalence of emergency medical conditions during law enforcement contact may be studied in order to prevent avoidable deaths and poor medical outcomes, some of which we saw in the last session. She is the one who identified what's called the statutory gap under which the Medical Civil Rights Act seems to resolve, and the lack of relevant reporting requirements surrounding the delivery of emergency care during law enforcement interactions. This led her to authoring 2 New England Journal of Medicine, one of the most prestigious journals in healthcare, as many of you know, manuscripts that were published in 2021 and 2024 with other members of the initiative. During the same period, she assisted law enforcement with multi-jurisdictional criminal investigation involving falsification of clinical and non-clinical records, and this work opened discussions about policing leaders about the existing laws and policies related to the handling of medical emergencies during police contact. Leonore earned her BA from Harvard College, summa cum laude, and was awarded the Deter Book Prize, one of the oldest prizes at Harvard. With Leonore is Dr. Deborah Dluhy, who is a co-founder and director of strategic planning of the Medical Civil Rights Initiative. She is also the Dean Emerita of the School of Museum of Fine Arts in Boston and a trustee emerita of Wheaton College in Massachusetts. After retiring from her career as an educator and art historian, Debbie joined her daughter Leonore and her late husband, Dr. Robert Dluhy, in co-founding the Medical Civil Rights Initiative and is a co-author of the Medical Civil Rights Act. She served as secretary and member of the executive committee of the National Association of Schools of Art and Design, and an experienced evaluator for that organization, and was named an ASAD Fellow in 2008. And since 2010, she served as a trustee of the Maine College of Art in Portland. Debbie received her BA cum laude from Wheaton and received a Woodrow Wilson Fellowship for Graduate Studies in Fine Arts at Harvard, where she earned her PhD. Last but of course not least is Dr. Stephen Wright, an active member of the Medical Civil Rights Initiative, contributing to both the authoring of the Medical Civil Rights Act and to research into the delivery of care in jails and prisons nationwide. He is a retired physician specializing in gastroenterology who served for 19 years as chief of medicine at the Brigham and Women's Faulkner Hospital, a part of the system of patient care delivery and medical education for those teaching hospitals, and the training programs affiliated with Harvard Medical School. In 1992, he was appointed clinical professor of medicine at Tufts University School of Medicine. Since retiring in 2017, he's been adjunct faculty in Boston University's College Behind Bars program at Massachusetts Correctional Institute in Norfolk. His teaching in the biological sciences contributes to the ultimate eligibility for inmates to gain a 4-year college degree from Boston University. Amazing. He is a graduate of Harvard College and he received his medical degree from the University of Virginia School of Medicine with postgraduate training on the Harvard Medical Service at Boston City Hospital. We are so honored and so grateful to have the team from the Medical Civil Rights Initiative here with us. Please welcome, join me in welcoming them. Thank you. All yours.
Good morning. I'm Debbie Dluhy, co-founder of the Medical Civil Rights Initiative. I also have a cough drop in my cheek here when I speak, having recovered from a cough. If I suddenly go silent, I know it will be in a place where I can get some good help. Thank you. Let me begin by thanking all of you for the invitation to speak today about our work. I hope to offer just a brief background into the origin of our initiative. Our work began in April of 2015. My late husband, Dr. Robert Dluhy, our daughter Leonore, and I watched the evening news, which showed the arrest in Baltimore, Maryland, of Freddie Gray. Mr. Gray pled for medical attention numerous times while in police custody. We questioned why he was not given prompt access to emergency medical care when he begged for it. Among his last words was the word help. While the medical experts raised questions about when and how Freddie's injuries occurred while in custody, as you all know, by the end of the week, Freddie Gray would die from the injuries he had sustained. We're going to try now with the technology here. Bear with me. That event was the catalyst for us to examine why a person injured, asking for help, under arrest by the police, would be left without immediate medical response. Leonore and her father began to explore the issues surrounding the rights that persons in contact with law enforcement officers have when a medical emergency condition arises. This research discovered that currently there is no statutory right to emergency medical care during law enforcement interactions, now with one exception, Connecticut, which enacted the Medical Civil Rights Bill in October 23. Under some state laws and through court decisions, officers have a duty to render first aid or summon care in certain circumstances, such as when a person is injured. However, there are no relevant statutory protections ensuring access to emergency medical care when a person experiences a medical emergency condition. In turn, law enforcement officers are not required by law to immediately summon medical care when requested by a contactee or when an officer observes that a person is experiencing an emergency medical condition. We have described this situation as representing a gap in the law. It became clear to us that absent statutory change, the right to emergency medical care during law enforcement interactions is governed primarily by the constitutional protections, which only extend to those who are under arrest or otherwise held in jails and prisons. As we discovered, those constitutional protections do not extend to the earlier encounters with police officers. We get this to work up in here. Such as initial encounters or temporary detention. Moreover, even when the relevant constitutional protections do apply, it is important to note that they do not establish a right for a person to request and to be provided access to medical care. The relevant constitutional provisions do not guarantee the immediate provision of medical care, and they do not ensure that care is provided by a medical professional. Our continuing work, which has involved a study of deaths in custody and some poor medical outcomes, although here the data are limited, together have underscored the need to bring about change that could provide clarity in the law and ensure prompt medical responses. And so we began the work to draft a bill that would offer such clarity to protect all persons involved, from the persons in contact with the officers to the officers and the medical personnel. At this point, we can report that Connecticut enacted the Medical Civil Rights Act, as I have said, in October of 2023, and this is the first state. Moving forward, our hope is to take the bill to state legislatures across the United States and to file federally. While my husband did not live to see the Medical Civil Rights Act pass in Connecticut, I know he would have been heartened to see that happen. He always said quite simply, "This bill will save lives." We share that hope. We have two cases to lead with here. One in the field, Randy Cox, whose injury in New Haven, Connecticut, was a stimulus for the Connecticut legislature to effect change. And the other, the death of Sergeant James Brown, who experienced a sickle cell crisis while held in an El Paso, Texas jail. Both involve delays in the provision of emergency medical care, and both families are in support of the Medical Civil Rights Act. Thank you. So, this will.
Looking for a black male, skinny, in his late 20s. He's wearing a white, red, and a black t-shirt.
Buddy, hey, can I talk to you? Can I talk to you for a second?
Hold up real quick. What's up? Hold up real quick.
Just hold up, bro, okay?
All right, what's up? Is there anything on you?
Anything on you?
I'm on my phone, what? I'm on the phone with the girl. Cover my mouth.
All we're doing is detaining you right this second, okay? Done. Done. Sarge, 75.
All right.
All right, step right in there. Got it?
One leg at a time.
One leg at a time. Watch your head. Watch your head, all right?
Yo. That's right.
You felt? All right, hold on. What happened? What? You fell. What happened? Can you move at all?
I can't move.
Wow, how your leg is all the way up there?
Understand me, listen, brother.
All right, I can't move you, so I have to, hold on, I'm gonna have to go get an ambulance. You started a signal 1, the subject in the van, he said he fell inside the van and he can't move. So I'm on my way to detention right now, so please, can you start me signal 1 over there? All right, I call for an ambulance. When on the way here, somebody calls me over, so I stop in the brakes, but I don't know, he said he fell inside the van and he's all, you know, I opened the door and checked, I was talking to him, and he said he can't move. So if he really fell, and we're not even moving until the ambulance gets here, we could just in case.
Okay. I cannot move.
Move your leg. Sit up.
Why not listening, bro?
Sit up.
I can't move.
You're not even trying.
What's the hand? Almost there. Get your shoulders out. Ready? 1, 2, 3. Stand up. Here we go. All right. How you making up? Ready? Actually, go get that shit. Get the. I was fine. Listen, he was fine walking. All right. Like I said, he was kicking that door, no problem. Hold it tight, door. Hold it tight, door. Hold it. Sit up.
Oh my God, no.
Sit up. You're doing extra shit. Sit up.
Yeah, I fucking broke my neck cover. I can't. I can't read.
No, we don't want you to do anything. Don't worry about it. The other arm, just grab his other arm.
A little pissed. Huh? A little pissed. He's perfectly fine. You want to put these on? Yep. Hold on, Ron. Hold on, Ron.
All right.
Can I get the key?
Second. I need to cue the second. This is the second video Sergeant James Brown. This is a difficult, very difficult video.
Stand up and let's show.
I can't breathe. Dude, I can't breathe. You guys, help me. Help me. I can't breathe. Oh, this is it. I can't. I'm bleeding. I'm bleeding. Oh, shit.
Take the boots off. If you can't get the strap on, take the boot off.
Dude, I'm choking on my blood. Help me. I'm choking on my blood. I'm choking on my blood. I'm choking on my blood. Look at it. I'm choking. Let's go to the press house here. I need a spit mask. Spit mask.
Let it repeat. So those were the two first cam videos we have. Are there questions before we move on? Right. Before we proceed to a more granular discussion of the Medical Civil Rights Act, let me take just a moment to read to you the language of this bill. Any person who experiences an emergency medical condition or is medically unstable while in direct audio or visual contact with or under the custody or control of a peace officer, shall have the right to be provided with emergency medical services, except as provided in subsection D of this section. A peace officer shall immediately request emergency medical services for any person who is under such an officer's custody or control or otherwise in direct audio or visual contact with the peace officer, when such a person has, 1, has communicated to the peace officer that the person is A, experiencing an emergency medical condition, or B, medically unstable, or 2, has been observed by the peace officer to be A, experiencing an emergency medical condition, or B, medically unstable. It's a very short act.
Good afternoon. We really appreciate you all coming today to learn more about this legislation. So this is the central provisions of the bill. And we wanted to just go over that. We began drafting this language in, as we said, 2015 after the death of Freddie Gray. We have an expanded provision that we'll go over for 2025. But importantly, when you look at this language, right, B is the right of the person, right? So we're establishing a right to emergency medical care, and we'll go over some of the terms and definitions in a moment. Again, during all contact with law enforcement officers, and we'll go over in a second how we're defining contact. Also importantly, the affirmative right is under what would be paragraph C1, right? So it's not just a right to care, but it's an affirmative right, a right to request and to be provided immediate access to emergency medical services. The duty of the officer is also in paragraph C, and that duty of the officer is both when a person states they're in medical crisis, communicates, and also when a person's observed to be in medical crisis. Any questions on the bill language yet before we get to the next? Okay. So in the terms and definitions, in the first paragraph, right, we have the definition of an emergency medical condition. In the Connecticut bill, And I think we explained that we're reviewing right now, we're doing this analysis of the bill that was enacted in Connecticut. We have similar language for all states, but some of the state terms definitions will vary. When we file federally, obviously there'll be variances as well. And we have to do this kind of state by state legislative approach because Congress doesn't have jurisdiction over state and local officers, right? That's clear. So we'll file in all 50 states, we've been through one, and then we'll file federally. So in the Connecticut bill language, we rely on an existing statutory definition of an emergency medical condition. Some states don't have one, like New York does not have one. In Connecticut, that definition importantly includes behavioral emergencies, and in the states where the definition doesn't include behavioral emergencies, we'll expand the definition to include a behavioral emergency, okay? And it's really important to understand that in the bill that we're relying on this, basically a prudent layperson standard is incorporated in this term, right? We're not expecting officers to make clinical decisions, we're expecting them. We're framing the bill basically kind of in the eyes of an average layperson, right? So that's important to understand because some people question that. How will an officer know if a person's experiencing an emergency medical condition? They're held to the same standard, again, as a reasonable layperson. Medically unstable was a term that Dr. Robert Dluhy had wanted incorporated in the bill because he felt it was so important in medicine to look at the direction that someone was trending, right? Because an officer might make contact with someone and the person might be becoming, right, they might be deteriorating toward a medical emergency condition, and he wanted to incorporate the importance of being medically unstable, right, because things obviously evolve quickly in these encounters. The definition 3 of a peace officer, in some states they'll use the term law enforcement officer. In Connecticut, peace officer includes both police officers, officers in the field, and it includes correctional officers. Our objective in all states is that the bill both apply to interactions with officers in the field and officers in correctional settings. So, some states will use peace officers, some will use law enforcement officers, some may state peace officer and officers in the correctional setting or correctional officers, okay? And then as far as contact and under control, let's look at the following slides. I know Doug's already done some of this, so this may be duplicative, but we'll go there for a second. So what's contact? I'm sure most everyone here already knows that, but this diagram, which was for the New England Journal of Medicine, gives you a good sense of what contact is, right? So there's contacts in the field, and then there are contacts in the correctional setting. And the contacts in the field are really defined by 3 types of encounters, right? They're initial encounters, temporary detention, custodial arrest. And then the contacts in the correctional setting will occur in jails and prisons, right? So the first, if I need to put this on, right over here, right, would just stay on for a second. You'll see this is jail, right, primarily over here, and prisons over here, right? So the bill is applying, obviously, to the whole series of contacts that occur. Connecticut more explicitly defined contact is direct audio or visual contact. The Department of Justice usually calls contact a face-to-face interaction. So Connecticut sort of tuned that so that people understood that the officer has to be able to hear the person or see the person and vice versa. The contactee has to be able to hear and see the officer, okay? And I just want to make clear for this diagram, because we're going to get into some of the data, the 3 custodial hold categories, because we found a lot of times when we're looking at the state data, it's aggregated, and some states are not collecting all 3 custodial hold category data, which we'll get into. But over here, right, our first category, that's police custody. Over here is the custody of the jail, and over here, persons in the custody of the prison, right? So all 3 custodial hold categories. Any questions? We will get into some of the data that's on the slide. Yeah.
Hold on, let me get you on mic. I don't know what order to answer that.
Thanks. I was just wondering about the proviso in subsection D, I think it was, the carve-out.
We're about to do that, yeah. Yeah, we're covering that in a minute. Any other questions? Yes.
Where did you get this data from?
This data, we'll go over that in the next slide.
Okay.
Over here, right here, this is from the U.S. Department of Justice. This is from the PPCS survey, which is the Police Public Contact Survey. And we'll get into that in a second. The data over here in the CARS, we don't have this on the slide, but we'll have it in a subsequent slide. And in the subsequent slide, we'll go over it's all either Department of Justice, FBI data, and I'll address that point by point.
With regards to the police contact, does that basically mean that police that person that is basically taken into custody?
That's a brilliant question. No, and we'll get into that into the next slide. So I can do it quickly. Of the 61.5 million residents that have at least one contact, and again, the Department of Justice only could survey people who are residents. So we don't know the number of non-residents who have contacts. But of those who have contacts, right, of the U.S. residents, the FBI said in that same fiscal year, so this is 2018 that we're citing because the pandemic data is slightly irregular,
Right.
the FBI said that 10.3 million arrests were made.
Well, and that's where I was going to go.
Mhm.
Because in a lot of cases, as far as a police contact, that can be an officer actually taking a report.
Yes, and we'll get into that in the
Okay.
next slide. That's brilliant. And also important to understand is that of these 61.5 million people, some will have had two types of contacts, so the numbers will not sum to totals. So people may notice that as we get into that. No, these are great questions. Anything else before we move to the next? Okay. So one of the terms in the bill, which is sort of implicitly defined, we don't explicitly define because it's usually a well-settled definition, is under control. And I think Doug touched on that already. Like a person must be under the control of an officer to allow medics to enter the scene. We're going to address this at length when we get into the psychiatric crises at the end because it's a very important component, obviously, of the handling of the psychiatric crises. On the issue of how does an officer place a person under control using objectively reasonable force, which is the standard set forth by the Supreme Court in 1989, we defer to the Police Executive Research Forum. And they have policy and training, the ICAT, which is phenomenally sophisticated. I ask you all to look at that. They first published on that in 2016, and it really goes through a very detailed set of recommendations and guidance to give officers using objectively reasonable force to place a person under control. Okay. Any questions on that before I turn to the next? Okay. So, to your question on D, this is what let's call it the qualification of the affirmative right. Some also call it the safety valve of the affirmative right. This was language that was drafted by Connecticut. And let's just read it through. It says that a peace officer shall not be required to request emergency medical services when such officer, one, has made a reasonable determination the person is not experiencing an emergency medical condition or medically unstable, and two, note that there's an and between them. Okay, knows that such person has been seen by a medical professional within the previous 24 hours and was released. Okay, so, and again, that person must have been determined to not be experiencing an emergency medical condition from the medical assessment. Okay, so that language, which was drafted by Connecticut, most people assumed that that language was to address people who would quote unquote fake a medical emergency. Right, but it really addresses a much broader set of circumstances than that. Can anyone think of the reasoning for this language? I'm my favorite person up here.
How would a police officer, or a peace officer in this case, know that the person was actually under medical care 24 hours before you contacted them?
Exactly. So how does anyone have an idea why Connecticut put that in? I put it a little bit in the notes, but because obviously you're right, that information. So one, a person would have disclosed it. And we were going to show the body cam today, but I'm going to refer you all to it because it's 90 minutes. And when we edited it down to try to get it to 5 minutes, we didn't want it to look prejudicial, right? That we had only selected 5 minutes. But it's a really important case, and it's Lisa Edwards. And it was her death in custody in 2023 in Knoxville, Tennessee. The officers were picking her up after a hospital administrator walked out and wanted her criminally trespassed and claimed that she was medically unstable. I mean, that she was medically stable. They had cleared her and that she was a faker. So the officer had knowledge through the hospital personnel. So one situation could be the person discloses it. The other could be that the officer had accompanied the person, right, while in custody to an emergency department. As the person's leaving, they're like, I have a right to request EMS, right? They didn't want people kind of backlogging back into the system, right? But also it could be that the officer has medical training. The officer could have been the person to have made the assessment, right? We can't rule that out. So
Unless there's some other statute within the law in that particular jurisdiction with regards to that 24-hour thing. Maybe there's something else within regards to, I don't know, somebody help me here as far as a coroner case, basically if the person was under medical care 24 hours or something, maybe that's what, I don't know.
I mean, this is Connecticut's language, this was not ours. And as the bill gets filed in a different state, some people will not adopt this provision, right? They will say, no, we don't want this qualification, because we had argued in Massachusetts that there's existing law to deal with those people who are faking medical emergencies, right? Officers can charge people with obstructing an investigation or making a false statement. And the officers had said, we don't need this. That was their statement to us. And they were never concerned about abuse of the affirmative right. But in Connecticut, this is the language that they incorporated. So as states go forward, they may say, no, we won't adopt this. But the importance of the Lisa Edwards case, and I think everyone should watch it. She is a remarkable civil rights attorney, Devin Jacobs. And he's based in Harrisburg, so you should reach out to him. You should watch the body cam. But that's an important case because they had knowledge through the hospital that she was medically stable from the hospital. She was not, as you'll see in the course of the 90-minute interaction. But importantly, as the judge said, because we do have one retired appellate judge on our initiative, I should say, another who conferences us weekly and another joining us, so we have a lot of judicial review. It's important to understand that there's an and clause there. So while the officers had knowledge that she'd been seen within 24 hours, they did not make any determination. And she was pleading for access to care. So she would not be an example of an applicability of the safety valve, right? She's a good example of one prong is satisfied, the other is not. Okay? And that's why we wanted to show that body cam, because most people had felt, well, under that safety valve, the officers were clear. They would not have been. Okay. Any other questions on the language right here or the terms? So for 2025, we're adding this provision, which will really clarify, as Doug got into, these issues when there's simultaneous involvement, right? So the issue isn't always just summoning EMS, but medical personnel may be present on the scene. They may be waiting, right, for officers to say, it's clear for you to begin rendering care. So we wanted this provision to go in, and it also addresses co-response, because most people assume that there's statutory clarity around co-response models, and there's not. Okay? So this language is basically to just expand on the previous language to say, in circumstances where we have multiple first responders on the scene, that once it's safe to do so, officers must transfer custody of that person or that contactee over to the medical personnel if the person's experiencing a medical emergency. Okay, so I think what we're going to do right after this is we're going to turn to two cases, and one of the cases, you've just seen two cases with Randy Cox and Sergeant Brown that really illustrated well the importance of the affirmative right. And the affirmative right is very important because a lot of medical needs are not visible or obvious. And if you look at the Department of Justice's investigation into the death of Freddie Gray, the case that we discussed at the outset, they said, well, his medical crisis wasn't visible or obvious to the officers because it was an acute neck and spinal injury, right? So the affirmative right is important in the fact that many of these medical needs are not visible or obvious, okay, to the officer. So as the judges have said, the affirmative right will protect the officers, not just the contactees, by ensuring that the officers have clarity about the medical status of the patient. And in the cases especially where that medical need is not visible or obvious, it will also reduce the liability for decision-making of officers through the affirmative right, okay? But now we're going to turn to two cases. One is going to show you the importance of having a person under the control of the officers for the safety of all persons involved. And then we're going to turn to a case that illustrates well, I think, but you all tell us, a person who reasonably appears to be in a medical crisis to a lay person and a delay in care there. And often there's time for the audio to kick in, and with Sergeant Brown, I should have said there was a redaction on the audio, which you heard in the jail.
Gentleman in the back on the right side in the green. Oops, sorry, bud.
Hi, guys.
Oh, the police are here now.
Hey, buddy.
All right. All right. Thank you. So the bus got here, and he isn't responsive.
Okay. Were you on the bus?
Sir. I work at the bus station here.
Okay.
So when the
Sir.
driver.
Sir.
So when the driver came and he's like, I have an unresponsive person, and then he's like kind
Sir.
of gasping for air.
Yeah. They.
Does anyone know him? No one.
Were you guys on the bus?
Yeah.
Was he having like a seizure? Did you guys? Was he act? You know what a seizure looks like?
Yeah, no.
Okay, just sitting quietly. Okay.
And the crappy thing is the seats don't go back.
Okay.
And you put him on the floor because he's a bigger guy.
Sure. No, absolutely.
The driver,
somebody else?
no, the driver has his duffel bag
Okay.
with all of his information.
How long has he been on the bus?
I would say since I called 911. Well, he's been
Well, he was riding the bus. Where was it coming from?
Milwaukee.
Has he been talking to anybody on the bus? Here. Oh, okay. Okay. Any signs of drug use at all? Just the fact they came here, went to the bathroom? You say yes? Oh.
No, I don't know any of that. I'll take a pen like that when you're ready.
What do you need from me? I said get out of your way, but I'm kind of trying.
No, you're good right there.
Do you have anything on you that can hurt these guys at all?
No, sir.
Okay. How come you have a problem with that?
Because I don't know what I have.
Well, here's what happened. You went unresponsive, and you're agonally breathing, which means like laborious, like pre-death breathing. They gave you a little bit of Narcan, which treats opioid overdose. I'm not saying that you did anything intentionally or illegal, but because of that, that makes me think needles. Even though you're telling me it's pills, I just want to triple check that before you lay on that cot. Is that cool? How many pills do you think you took?
About 4.
Okay, and they're your prescription pain meds?
No.
Listen to pen, Steve?
Are they prescription? I just don't want you to fall over. Prescription
No,
pain
I'm not
meds?
gonna fall. I just gotta get my.
Okay. Prescription pain meds?
Yeah, they were my wife's pills.
Okay, all right. Do you have more of the bottle so we can see what we're working with?
I just had the 4. I'm not gonna
All
fall
you
over.
need to do is go to the hospital, get checked out. If they say you're okay, then you're on your way. I don't want you to go
get home though, man.
You'll get home. Listen, I talked to my boss. The only other alternative to you not going voluntary, if you go voluntary, you hop on the cot, you ride down there, you get checked out, it's done. If you don't go voluntarily, here's what I have to do. I feel that you're not making a safe choice in your best interest. I'm not making.
I'm consciously talking.
You're not making a safe choice in your best interest. And I have to involve crisis. We have to go to the hospital anyway to start that process, and we have to have them evaluate to make sure that you're making safe decisions for yourself. I don't want to go
Houston,
there.
real quick, do you have any weapons on you?
No, sir.
Okay. You kind of have a bulge on your right side.
That's my phone.
Okay, don't reach for anything. Just kind of
That's
put
my
you down
phone.
real quick.
I don't want. Look, man, I have a problem with officers touching me, man.
Okay.
Lift up your shirt then.
Sure.
I get
Lift up
nervous
your
and
shirt,
stuff.
bud.
Can you lift your shirt up a little so
We
I
want
can
to
see
make
your
sure
back?
everybody's safe.
Look, this is my.
Oh, whoa! Oh, fuck! Shots fired! Now anyone know what shots fired?
go automatically to the next slide. So now we're going to show the one that should fit within the parameters of showing a person who reasonably appears to be in medical crisis. Let's all look at that.
Hey, you got to help us get you in here, man. Or you're gonna go. Let's come on. We're gonna help. Just lay across. All right. Sit up. Go back that way. Come on, keep scooting.
Get out of that shit.
Okay.
Come on, please.
All right, stay down.
Yes, you do.
All right, I'm gonna have to sit up. All right.
Oh.
Yeah, there we go. All right. I'm gonna push your legs and pull you at the same time.
Lay that.
Come on.
You want to say my shit? Just break it off. Please don't do this shit.
What's your date of birth? Hey, when were you born? 2489.
Right.
What's your name?
All right.
Okay. What's your name? What's your date of birth? Huh?
Oh, Britain.
What is your name and date of birth?
The book of God.
What's your first and last name? Huh?
Please.
What is your first and last name?
My real uncle got to report. They were reporting they drove him behind
Hey, man,
me.
listen. If you don't cooperate with us, the longer you're going to stay in jail. So what is your name? What's your name? What is your name? Hey, focus. What's your name? What's your name?
No, always behind you. That next to the next. But that made me know that. Let me see. Come out.
Hey, bud. What's your dad's name? Hey, what's your dad's name? Huh? Pete what?
Sarah.
Go ahead.
Sit up. No, that's not.
Hey, what's your name, man? Huh?
Okay. So, you look like fucking dog.
What is your name?
The wolf thing. No.
Hey, dude. What's the active?
So I was honest.
With the active.
I do got to read one.
With the active.
You can't hear this stuff. You get out there, simple thing.
With the active. With the active, dude. Okay. What's your name?
I was second to play.
You what? Hey, what's your date of birth? Huh? Hey. 12190? What? 12390? Is that what you said? 123 of 90? Hey, sit up. Hey, hey, sit up. Sit up. Hey, sit up. Sit up. Sit up. Hey.
We know that's a difficult video to watch, and we didn't want to put edits or cuts in it because here's the point they come back,
Yes,
but we
hey.
wanted you to see the whole
Get him out and
entirety
get
in
him in a
real time.
recovery position. We got to get him out of this unit. Get another one. Let's get another one.
So that's a case in Arkansas. That's a recent case. The family is in support of the legislation. Any questions? I know Dr. Wright is going to handle some discussion of the body cam. Anyone have any questions before I turn it over to him?
When we look at, thank you very much. So when we're looking at patients refusing medical care, as in the case of the first incident with the gentleman on the bus, we often try to determine capacity for patients and their ability to sign off. Is that something that law enforcement officers look at as well to determine if they're capable of refusing medical care so that it doesn't escalate into certain situations? What is the provisions on that?
Yeah, that's a really good question. So, I mean, our bill doesn't deal with involuntary treatment. I know there was legislation in Connecticut that was about if Narcan had been administered, that that there was a requirement that the patient be submitted for a clinical assessment to protect all personnel involved. I'm not sure in this state whether or not there are such protections. That was in Wisconsin. He was transient. He was going in a bus, I think, through from Florida to Wisconsin. I can't answer that question, but I do know that he had not been searched, and that was really why we wanted to show that, which is that the medical personnel began rendering care, right? And then obviously he did have a firearm on him, and the medical personnel were killed. So that was really the illustration of that. But I can check on that under that state law. I believe state by state it's quite different in that area.
Good morning. Thank you for inviting us to present this important work. These videos are very stark, as were Doug's as well. I think it's underscores a number of points. One, of course, is the tremendous lost amount of time between the peace officer stabilizing the situation and activation of the EMS service. In some cases, it's 20, 30 minutes. And as we all know, the time in these situations with the patient in arrest or looming arrest, they're losing neurons, they're losing heart muscle from oxygen deprivation, and it occurs very quickly in 10 minutes. The most common, two of the most commonly stated remarks that are made by persons in these circumstances are, "Help me," and "I can't breathe." When they hear that, that should trigger the affirmative right to get emergency medical care. I think this illustrates the tremendous delay between the two. I have to attest to the fact that in my work in the prison, as a volunteer, a faculty member, if a man in my class, I have 25 men in the classroom, if one of them goes face down, isn't breathing, or is pulseless, we are not allowed to touch it, in spite of our training, not allowed to touch that person until a guard comes and says it's okay, clears the scene. And this is inside the prison. Now these are protecting us from a hostage situation maybe, or some kind of a weapon that the inmate has crafted. But it's very painful to witness the absence of clearly indicated resuscitative efforts. And I've asked, fortunately it hasn't happened to me yet, I haven't seen any of that in my classroom, but I've asked the men what happens next, and they say it is chaos until the guy arrives, and then they call EMS, and once EMS arrives, there's a compliment to you folks, the situation is stabilized. And but again, the gap between the incident and the arrival of clearly life-saving kinds of things that were withheld from these gentlemen. I think in the first one, Reuben Houston, he refused to go to the hospital, which is his rights to do, but he had been medicated. And their protocol was that once that someone is rescued pharmacologically, they need to be evaluated, because he could lapse into a coma again later, depends on what he took. But the thing he really pushed the buttons on was if he was going to be transported against his will, he had to be frisked. And they were looking for the weapon that ultimately they didn't find in a timely enough fashion, and it was a fatal outcome. So we're going to speak a little bit about psychiatric emergencies as well, and the challenges of differentiating medically determined bad behaviors and psychiatric bad behaviors. So let's see now, the slides, where are we in the slides? You can do the data now? Okay.
I think we're going to do some of the data before we get back to the psychiatric crises. Okay, so that'll answer some of your questions as we get into that, because I know that the data is sort of, it's quite, the numbers are quite large, so obviously we need to prove that they're from valid sources. Okay, so when you looked at that slide before, that was from the New England Journal of Medicine, that had that depiction. It was both the depiction of the constitutional protections, and also it was to give you a kind of a visualization of what contact is. On that slide, you could see that for the field contacts, right, there were 61.5 million residents, as we said, who had at least one police contact. There was only 1 year that the Department of Justice looked at how many contacts, and I think it came out to about like 1.7 contacts per person in the field. So if you do the math, right, we're looking at 61.5 million residents, not including non-residents, but that could total to well over 100 million contacts, okay? And then in that same year, and again, we're back to the pre-pandemic data because the pandemic data was slightly irregular and the Department of Justice is still cleaning the data for 2022. The FBI said that 10.3 million arrests were made. Now, those aren't unique persons, but that just bears mention that you're looking at that that ratio, right, of how many people were taken into custody versus how many contacts, right? Importantly, that we'll get into in the next slide, but when you look at the people who were detained in carceral institutions in that same year, there were 2.1 million people in carceral institutions. I think it was 1.46, just under 1.5 million that were in prisons, state and federal prisons. The rest are in jails. But it's really important to know that those jail numbers, those people are cycling through all the time, right? So the government has estimated that about 9 million people. In the pandemic, it went down to about 7 million, but about 9 million people cycle through the jails annually, and there were 10.7 million jail admissions in 2018. Okay, so that's all Department of Justice data and FBI. Okay. So now the question that I think is important is, how do people come in contact with police officers? We've had a lot of misunderstanding in state meetings where most people assume that the contacts are police initiated. And I think it's really important to underline this, that of those contacts, the Department of Justice showed that about 60% were resident initiated. So these are people seeking help, okay? And of the police initiated contacts, 80% were traffic stops. So that just kind of gives you a sense for how people come up in contact, but that sort of disabused lawmakers of the concept of, which has been very important in the conversations around psychiatric crises. People don't want contact with law enforcement officers. When you look at the racial data, which we have in the New England Journal, it's important to recognize that it's generally split about 50-50. So white people generally 50% are police initiated, 50% are initiated by officers, and the same with black persons. So that's just important to know for when people said, in underserved communities, we don't want police contact. Those people were not just disproportionately contacted, they were disproportionately contacting officers. Okay. Any questions on that? So in the data, we've been studying, all of us, the data, both the custodial death data and some of the pre-mortality data. The pre-mortality data is extremely limited, and we'll get into that in a minute. But of these about 70 million people who experience law enforcement contact per year, we don't know anything about the prevalence of medical emergency conditions. We don't know much. And it also is important to mention that we don't know anything really about poor medical outcomes or injuries. There's some scant data. There was 1 year where the Department of Justice looked at injuries, but the fatality rate of contacts is 0.002%. The injuries are estimated 1 year by the Department of Justice to be about 250,000 people per year. And those were use of force incidents. And I will mention, as it's not on this slide, that the Department of Justice found that use of force was 2% of the 61.5 million contacts, and 50% of those respondents said that use of force was reasonable. So that's just an important understanding, really, where we're looking at 1% who are citing that it was not reasonable use of force, and lethal force was about 0.002%. Okay, so under what do we know? Most of the knowledge we have about the poor medical outcomes, which is really limited to the deaths, is through the Death and Custody Reporting Act, which was enacted in 2000 and then was reauthorized. And when it was reauthorized, the data now is not, it used to be accrued and reported by each state. It would be collected and then reported to the U.S. Attorney General, and then it would be analyzed by the BJS for the Department of Justice. Now the data goes up to the BJA, and that change is important to understand because that's not a statistical agency. So the data goes up unverified. There's a lot of problems in the data. It's incomplete, it's irregular, it's when we look at our data sets, generally we'll get 3 data sets from a state, and they're all different on the prisoner deaths. The jail deaths, generally there's only one agency that will provide it. And many states can't stratify their data into police deaths or police-involved deaths, jail deaths, and prison deaths. So the Death and Custody Reporting Act is, while it's a helpful benchmark, right, to give you a sense for the number of deaths in custody, really aggregated data and then trying to deaggregate it to look at these deaths in each custodial hold category, it doesn't tell us that much, especially because the data is so incomplete. What we do know, and that's why we're going to give you rough numbers without getting into the kind of breakdown of each state, is that about 7,000 people die in all 3 custodial hold categories per year. It's usually just over 1,000 in the jails. police-involved deaths. Now the Justice Department had used an open source methodology, so it's not just looking at use of force-related deaths, because mainly those were the deaths that were being reported. But it's about 1,000. Sometimes it goes up to kind of close to 1,500, and then about 4,000 deaths in state and federal prisons, yeah.
Is the 4,000 including old age?
Yes, yes. These are all, so exactly. So these are just all deaths in custody. The Department of Justice also said we technically are asking for deaths in a pre-arrest context as well. So, but most states aren't reporting their police-involved deaths. And if they are, they usually are more narrowly focused on use of force. Okay. So it's important to understand that while it's required under that act to report the data to the U.S. Attorney General, it's voluntary that all the law enforcement agencies and the jails and prisons report the data. So it's a fact-finding mission, right? Some states have statutes where they attempt to, but many states are not able to collect any of the police-involved death data. So we've sort of covered this, but the one takeaway from this slide was that when we study data sets for all 50 states, we don't see any state where the custodial deaths are downward trending, okay? So most of them look like, if you were to graph them, and it's too unreliable to do so, but if you looked at it, you would basically say the deaths spiked in the pandemic, and if you look at calendar year 2019 and 24, you're back in the same place, right? And they fluctuate in between. Yeah. We're almost done.
With regards as far as, and I don't know if you can figure this one out either, how many people actually have issues before they're incarcerated? I mean, I understand in some cases some of that occurs because, and that's, you know, and unfortunately, in some cases, the population of prisons are older.
Yes, and we'll get to in the later slide one of your questions, which is that a lot of the jail deaths involved, if you really drill into the individual level factors, people who pled for care while they were in police custody. So to speak, we would say the states are blowing it, right? Because those lives could have been saved if an ambulance had been summoned in the field. And the cost of the ambulance falls to the contactee, but not once they make it to the jail. So the state is now paying for, beside the loss of life, right? The state is now paying for the ambulance, they're paying for the medical care, and they're paying for the litigation for the death in custody. Okay. So we will be drafting, or we are drafting right now and finishing legislation to amend data reporting requirements so that you can study the prevalence of emergency medical conditions. That's beyond the scope of this presentation, but we will be expanding or attempting to expand the NEMSIS data dictionary. Just quickly, to your point of these field contacts of these 61.5 million people, we don't know how many experienced medical emergencies or how many ambulances were summoned. That data can't be stratified. There's no element in the NEMSIS data dictionary. We can look at ambulance runs to jails and prisons. That data is contaminated in that those runs could be for people who are not inmates, they could be for staff, they could be for visitors, and they're aggregated. So it's limited also because you're looking at jail and prison deaths together. So quickly, we know that between 2019 and 23 in this country, there were between 34 million and 54 million EMS activations for the US population. Okay, the cumulative frequency is just totaling the numbers in the left column. Okay, and then when we get to that, when we take that data and we stratify it through the EC9 data element, we can say that, 2019 there were about 178,000 ambulance runs, goes up to about 222,000 or 23,000, goes up again, and we end up in 23 at about 308,000 ambulance runs. The data that was pulled this year looks like we'll probably arrive around 340,000 ambulance runs to jails and prisons for the entire United States. Okay. So the data from NEMSIS, they would not identify the state or territory associated with that data, so we had to go and then seek that data from every single state. Okay, so we now have ambulance runs tallies. We're obviously not going to bore everyone with those tallies, except what's important to understand is the activations don't show that they upward trend with the custodial deaths. They don't really seem to fit a pattern with the number of inmates. They really seem to stay reasonably constant in each state across the time we studied of 2019 to present. which sort of implies almost like a cost containment or an administrative issue in terms of when the ambulances are summoned, not as much the patient. Clearly, right, if there was an affirmative right, we would expect to see that the ambulance runs would have more fluctuations around the medical needs of persons. Okay. I'm just going to show you one example of how, you can see the ambulance runs. You can see for Illinois, right, you can see there are the deaths at the top from the state administering agency for the Death and Custody Reporting Act. You can look at your ambulance runs, right? We're about 5,500 per year, going up or down with an inmate population of 53,000. In Massachusetts, we have about those same numbers of ambulance runs for a population of 5,000. Okay, but then you look at Ohio, we have about 200 EMS activations with an inmate population, look at 71,000. So we just don't do it. We don't roll the ambulances out in that state to those people, right? And the custodial deaths in Ohio, you can't just look at the numbers, but if you look at the litigation, you'll see that these are people imploring for medical care and getting medical care far too late. In Texas, you'll see, again, we have quite a lot of ambulance runs, and most of them are dominated by Tarrant County. Okay. So the only takeaway that we want to get to is that the importance is not looking at the number of EMS activations, but the timing of them and the competency, right, of the response, because the US DOJ said in 2024 that when they evaluated inmate deaths, 48%, so nearly half of the inmate deaths were due to insufficient emergency medical responses by BOP staff, right? That means obviously they couldn't handle these medical emergencies. They were too late. They didn't have batteries for, they didn't have ability to cut people down when they were hanging. This is also why the bill is important, right? We want to get competent emergency medical care in promptly, right? Because these delays show that you could possibly prevent nearly a half. And these are federal BOP facilities, but importantly, when you review the data, whether or not it's police custodial deaths or deaths in jail or deaths in prisons, we see the same patterns, that 30 to 40% or up to 50% are due to delays in care, right? That delays in care are very instrumental in the deaths. Okay, and to your last question, before we get back to body cam, and Dr. Wright, is that that 40% of the jail decedents died within a week. In Maryland, it was even quicker, I think, when they did a study, and that's from the Department of Justice here. So these people are dying quickly, and when you really look at the cases and then you look at the litigation, you'll see that a lot of these people pled for care while they were in police custody. Had they gotten their care earlier, you would have prevented a jail death. So looking at the deaths in the custodial hold categories can be deceptive, right? Because people are held for such a short duration in police custody that generally the deaths, really to look at police custodial issues and medical needs, you really should be looking at the jail deaths often. Okay. So our last section we're going to just turn to quickly are the psychiatric crises. And these are complicated for officers, right? Because there's a lot of people have a lot of antisocial behavior. There's a lot of issues in police contact. People are not always happy to be arrested, right? And so, the issue here is that it's important with the psychiatric crises to understand that, again, we're relying on the reasonable layperson standard and understanding that it's a psychiatric crisis. But where there's gray area, the affirmative right will help the officers, right? Because a lot of those people will say, I have a, and they'll name it, I have schizophrenia, I'm off my meds, et cetera, which will be helpful in the officers discerning the issue between, again, let's call it antisocial behavior or combative behavior and people having a medical need, okay? And in the psychiatric crises, it's important to understand that there's kind of these four elements. One is whether or not a crisis was reported to a 3-digit crisis line. Most lawmakers have assumed that people who have mental health disabilities and experience a mental health crisis will call 988. The data did not show that. Yeah, and that's important, right? If we looked at the fatalities in Massachusetts, and 60% of the fatal mental health crises were not reported to a 3-digit crisis line. They were just encountered by officer on patrol, or there was a report, and the report omitted the medical need. So it's, Fred's in my backyard, he's breaking into my shed, and an officer has to arrive and then pivot to understand what do we do about care. That's the purpose of the bill, right? That once that officer makes contact, that the person has a right to care either when they appear to be in medical crisis or they state they're in medical crisis. Okay, we were not going to get into the issue of continuity of care, but that's important to understand that some of the co-response data and other data that's not EMS data never makes it to the electronic medical record. So officers, you'll hear them say, I don't really know how effective we've been in some of the co-response models. Okay. The last issue before the 2 body cam we're just going to show is kind of 2 important realities of the psychiatric emergencies. One, again, as we said, is that a lot are not reported. And next, there's been misapprehension. People assume if you call 988, you can say, I don't want an officer present. And people have assumed that the person making the report will not get a police response if it's a call to 988. And they've also assumed that by calling 911, they can also stipulate that an officer will not respond. You all know that that's the determination of dispatchers. And so contact can't always be prevented. The flow chart at the right is only to show you the complexity of this kind of dynamic bidirectional flow between 911, 988, dispatch, and first responders. Okay. So we want to get to showing 2 psychiatric crises to end, and then have Dr. Wright say something that's, one of the psychiatric crises is going to show you a person who is going to illustrate the affirmative right. Okay, a person who's having a medical need, who's clearly under the control of the officers, he's not armed or threatening, and you'll look at the delay in care to him, and he's clearly articulated in his 911 report that he has a psychiatric issue. And then the next body cam will be a person who's not under the control, but we want you to think about that kind of interrelationship of the ICAT training that we mentioned, right, of the Police Executive Research Forum and our legislation, and how over time those 2 can work together to prevent deaths such as you'll hear on that one. Okay.
Leonore, sorry to interrupt. We're down to about 6-7 minutes on the session. Just quick time check. Thank you.
Help me! Hey, what's up? Hey, look, Tony. Look at me, bro.
Hey,
Tony.
Chill out, man.
Get me. Please get me. Just take me down.
No, you're fine.
Don't hurt me.
We're not gonna hurt you, bro. We're not gonna hurt you, bro.
We are.
Relax, man.
No.
Get you some help, Tony. Relax, man. Just stay down.
Hey,
Tony.
No!
Tony.
Ah!
Stop it.
Oh no, please.
You're gonna be all right. You're gonna be all right.
What's your last name, Tony? Please!
We're not gonna hurt you, okay? But you need to relax. Okay? What'd you take today? What did you take?
Oh God, I can't feel!
Hey, what did you
Help
take?
me!
Hey, what did you take today?
Help me!
Tony, what did you take today? What did you take?
I'll tell you, but you gotta let me go a little bit.
Hey.
Help me!
Well, he was trying to get on the bus. I was trying to stop him. Hey.
That's all we got. Help me! No! No! Help me! Don't do it! Okay, I'm down! Please don't do it! Please
You're all right.
don't do it!
Hey, you're okay. You're okay. You're okay.
Don't hurt me!
Yeah, don't jump back. You got paramedic behind you.
Okay.
You want to twist your body out to the right.
No, that's good. I'm just worried about him.
I can't live! I can't! Go! Oh God, this sucks.
You're gonna be all right.
Tony, relax. Tony, relax. You don't need to be squirming, man.
Stop.
We're trying to get you help, man.
Stop.
All right?
Okay, stop. Stop. Please let me feel a little. Please.
That has 2 call sheets on this one. Hey, what's this might have come out of his pocket. What the hell is that? This blue, what's this do?
Yeah.
Tony Temple seat.
He finally said.
So because we're short on time, I think what I'll do is ask you to watch this on your own. This goes on for quite a long time, and by the time he's turned over to medical personnel, he's dead. It's an important case to watch, but I'm going to turn to the next one because we're running to time. So. Oh, it's not embedded. Oh, there it is. Okay. All right. Hopefully the next slide is embedded, which is an 911 audio. Doug, is that one embedded, the 911 audio? Yeah. There we go. Okay, so we're going to end with this. There's no video again. This is a call for service.
What is your emergency?
Yes, I need an ambulance at 725 West 4th Avenue, apartment 3.
What's going on?
My son, they've been here before on him. He's getting ready to have an episode. It's mental, I guess.
So it's a mental health issue, or is he going to have seizures, or what kind of episode
Well,
are you
yeah,
referring
he's
to?
going to have seizures because that's what he has when he gets into this.
Okay, and is he going to need law enforcement assistance at all, or just medical?
No, just medical at this point.
Okay.
Okay, thank you.
And what is your name, sir? Stay on the line, please.
My name is Dave Phillips. I'm his dad.
Okay, and just confirming 725 West 4th Avenue, number 3, correct?
Correct.
Okay, and your phone number is 916?
Yes, ma'am.
Okay, how old is your son?
He just turned 25.
Okay.
They,
is he going to be cooperative?
Yeah, that's why I'm calling now.
Okay, if anything changes to where it's not just a medical, it's going to need law enforcement, give me a call right back, okay?
Yes, I definitely would do that.
Okay, very good. Thank you, sir.
Okay. Thank you.
Bye-bye.
Adjunct 2, Beat Medics, Medical Seizures, Knoll Manor Apartments, 725 West 4th Avenue, Unit 3. Adjunct 2, Beat Medics, Medical for Seizures at Knoll Manor Apartments, 725 West 4th Avenue, Unit 3, cross of Lorraine Court, map page 26, Lincoln 5, timeout 1914.
Requesting PD. Probable 5150, uncooperative.
Copy. Do you need code 3 for physically uncooperative or just verbally?
Code 2 priority would be great.
Copy. 911, what are you reporting?
Yes, could you tell the police to step it up here at 725? Because my son, he's mental and he has a knife. And he's walking around. The ambulance is here, but they're outside. We need the law enforcement.
Are you saying 725 West 4th Avenue?
Yes, ma'am. Yes.
I have officers there now. You're saying your son has a knife?
Yeah, he had a knife in his hand a minute ago.
Where's the knife now?
They're in here, yeah. He's walking back this way, but I see the flashlight.
3053. Okay.
Okay,
they are there now. Okay.
Okay, thank you.
Copy. Subject may have a knife in his hand. 911.
He just tried to stab me.
Okay, are you able
and
to
he locked
exit?
the front door. I'm locked in the room, and he locked the front door.
You're locked in the room, and you're not able to
Yes.
exit the apartment?
No. And I got 2 grandkids in the other room. Stop it, Desmond. The police are coming.
Are the grandkids able to exit the apartment? How old are they?
They're 14. One's 14, one's 11.
Okay, are they able to get out at all?
No, they're in the other room.
There's grandkids inside too. We have Dad 1021.
No, with him, I guess. I don't know.
42 medical criminal violence respond to stage 8.
10-4, keep 10-9 about the grandkids.
Yeah, this still
Dad's advising his grandkids inside also. We're trying to find out if they can leave safely.
Get him some help. I'm trying to get him some help. It's my son. I love him. Stop, Desmond, please.
You can cancel.
Stop it, Desmond. I'm going to have to shoot you. Stop it.
Do you have, sir, I need to know, Do you have a gun?
No, I don't. No, he's trying to kick the door in. He's trying to kick the door in.
Sounds like
and he's almost doing it.
inside.
Come through the window or whatever. He's trying to stab me now.
He's trying to stab you.
You were on the phone with Dad. Dad's advising the 5150 subject trying to kick the door in where he is with the grandkids. Stating he's trying
Tell
to
him to
stab
bust the window. I don't care. Just come in here and get him.
We need a ram to the front door.
Where's the window that's closest to you?
7-9, do you have access?
It's in my back. It's in the back
we have a
room.
glass
It can come
window
through
with
the front. It was
semi-aggressive dog we're going to try and take care of here.
Right now.
I don't know. I'm locked in the room.
So he didn't get in your room?
I think they got in.
You think the officers got in?
79, you make entrance to the back?
I heard him say, let me.
Okay, I want you to stay where you are, okay?
Okay. Okay, they getting him.
Okay, just stay where you are, locked in the room, okay? And were your grandkids locked in another room? Stop!
No, don't kill my baby!
Shots fired.
Sir, I need you to stay where you are.
14, shots fired.
Shots fired. 4th Avenue.
Oh my God!
Sir?
Oh no!
I need you to stay where you are.
Taking call.
Yeah, shots fired. Suspect here.
Shots fired. Suspect down. Fired.
I told you he was mental. Did you kill him? Is there anyone else in there? Sir, did you kill my baby? In there, my grandkids. Sir, do not move. Stay in the room. Oh, God. Take him out. Oh, God, no, please. Sir, where the baby's at? Sir, they're in there, man. Did you shoot my son? I told you he was mental. I told you he was mental. Sir, police department there. Sir, relax. Not my son, man. Let's get the baby back. Oh, God, no. 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 No.
So that's a case for further thought, right? To discuss the placing a person under the control safely and access to medical care, but we wanted to end you with a case to contemplate. Mr. Phillips is also in support of the legislation. We know you're running tight. We thank you for the time today, and we hope you'll look at the Tony Timpa video, which is important case about delays in care.
Well, thank you all for that really compelling presentation. So we have lunch provided. There's box lunches right outside the room. There's some tables set up here. What we're going to do is you can grab lunch, take about a half hour. We're planning to start right around 12. If not everybody's had a chance to go through the line and get their lunch, maybe a couple of minutes after, since we are a few minutes behind. But if you want, you can feel free to bring your lunch back in here and eat. If you want to go outside, it's a beautiful day. There's some benches and stuff out there, but feel free. But the idea is grab your lunch right outside the room here, and then we will reconvene in about a half an hour. Thank you so much. Okay, folks, as we get started here, I want to introduce our next presenters. So we're very privileged to have with us again two of the litigators from the defense team in the Elijah McClain case. If you're like me and any of you watched the trial, it was live streamed, or if you saw excerpts from it, it's kind of like having rock stars, right here. For those of us that were glued to the trial and watched nearly all of it, as most of us at PWW did, we're just delighted to have them here. I want to say, in full disclosure, we did reach out to the prosecution team as well, and they declined citing the pendency of the appeal in this particular case, but we're very honored to have with us two members of the defense team. So let me introduce them here, and then I'll turn the mic over. So first, Shana Began is a partner at Alonzi Pello Began LLC, where she and her partners Mike Pello and Steve Alonzi have earned exceptional reputations as criminal defense litigators, civil litigators, and practitioners in the area of administrative law. She and Mike have also spent over a decade working as independent contractors for the Office of Alternate Defense Counsel, where they provide defense work for indigent defendants. Shana grew up outside of Chicago, was raised in a large family of public servants, And she moved to Colorado for law school, and upon graduating from with honors from law school, she went to clerk for the Colorado Supreme Court. And after her clerkship, Shana returned to working at the Denver District Attorney's Office, where she specialized in appellate work, prosecuting violent juvenile offenses, prosecuting felony crimes against children, and felony domestic violence and homicide cases, and prosecuting gang cases. She also taught at the police academies and with the Courtroom to Classrooms program. Shana volunteers with numerous organizations outside of the law, ranging from Habitat to Humanity to Intercambio to Pulse Line and the Autism Society. Shana also volunteers with numerous legal organizations such as the local bar associations, Colorado Legal Services, and the Our Courts program. Shana is married to a police sergeant, and true to their inherited family values, they've raised 3 daughters devoted to public service. All 3 work as first responders. When she is not working or volunteering, her time is spent reading, enjoying time with her family, her dog, enjoying sports, or doing any form of outdoor activity that allows her to play in Colorado's amazing natural playground, followed by a nice drink, enjoying same. It's right here in the bio, ladies and gentlemen. I am not gratuitously adding that she likes to enjoy a drink. All right. Mike Pello is a partner also at Alonzi Pello & Begin, LLC, where he, along with his partners, focuses his work on criminal defense, civil litigation, and administrative law. He has also worked continuously since 2013 as an independent contractor for the Office of Alternate Defense Counsel, also providing defense work for indigent defendants. Mike is a consummate litigator and is highly respected by fellow attorneys and members of the bench, so much so that he was asked by the Colorado Supreme Court to present a case law update at their statewide judicial conference. Mike also comes from a large family, originally heralding from the Upper Peninsula, the UP in Michigan, but primarily grew up in Colorado Springs. After completing his undergrad studies at the University of Colorado in Colorado Springs, Mike went on to excel in law school at the University of Colorado in Boulder. Following graduation, Mike went to work at the Denver DA's office as a prosecutor, and for the next 2 decades, Mike would devote himself as a public servant to the city and county of Denver as a deputy DA and then as a chief deputy district attorney for the DA's office. As a prosecutor, Mike specialized in handling cases involving violent crimes, gangs, and homicides, and Mike was also called upon to teach and train both new deputy district attorneys and police officers at the Denver Police Academy. When not working, Mike loves being with his wife, their son, and their dog. He loves reading, watching sports, and enjoying Colorado's beautiful scenery through hiking and running, rounded out with celebrating all of the same over a cold pint. I'm sensing a theme. I'm thinking I need to look for, so I shouldn't say that in front of my coworkers at Alonzi Pello & Begin. So sounds like a great culture, and we're so honored to have you both here. Please join us in welcoming Shana Begin and Mike Pello.
Good afternoon. We get the lunch crowd, so hopefully you're not all going to fall asleep on us. I'm going to ask, can I just by a show of hands, who here is involved in first responder work? Okay, vast majority. Who here is involved in law? Okay, nice split. We hope to bridge kind of all of that in a short presentation today. I know I'm not exactly sure where I've landed in Pennsylvania, so I'm going to go out on a limb with where I'm going to start by saying maybe some of you follow the Baltimore Ravens. So maybe we have Philadelphia Eagles or Steelers fans. But I think oftentimes in first response, my heart feels for you because you kind of are the Lamar Jacksons. You show up, you've been trained, you've got your guidebooks, your playbooks, and sometimes you have to make a call. And boy, are the pundits talking from the second you're on that screen until the next mistake. And they're telling you, they're stopping the cameras, they're zooming in, they're seeing the plays, not from where you are as the quarterbacks, but from overhead, from every possible other angle. And they're talking about what an idiot you were for that pass or that fumble or missing the open person. Until somebody makes the spectacular catch and you're the hero. When maybe your coach is yelling at you because you broke the playbook and that wasn't the play, but you made it audible. So I think in the land of first responder work, I want you to know that we really, really understand and our hearts are heavy with this case. But I say that also against the backdrop that I will never forget Elijah. This case will always be on my heart. Because the one thing that we all know is prior to any contact with Elijah, there is no reason to believe he wouldn't be alive. And that's really hard. And there's not a one of you that undertakes your job not wanting to help. And we know that.
So I would like to start by asking a question as well of all of you. Is there anyone who has not heard of the Elijah McClain case? Is there anyone who, one person? Okay. Hopefully you will figure out what's going on here as we talk about the case. I think we're going to provide a lot of perspectives. We can't go into everything in the greatest detail. As the prosecution noted and Doug noted in our introductions, it is on appeal. There are certain specifics of the case we may not be able to talk about. We do encourage questions as we go, if you have any. If we can't answer, we'll take the fifth or whatever we need to do. So this case, Doug entitled it for us and gave us a slide, Litigation Perspectives from the Elijah McClain Case. It could just as easily be called, frankly, the criminal ramifications of going to work. And I want to start with kind of a hypothetical situation and then go to something that you all observed just today. The hypothetical is I'm a criminal defense attorney. It's what I do. Let's say I have a client in my office and I'm short on time, which is always true. I'm stressed, which is always true. And I'm trying to explain to the client exactly what he is looking at. In a rush of trying to catch up with what I need to do, I misadvise the client. And I tell him, wow, I looked up your case. Boy, they got a great case against you. And you're facing 30 years in prison. I don't really see how you're going to get out of that. So my client goes home and, just feeling horrible about the whole thing, takes his own life. Am I responsible for my malpractice in telling him what he was facing? Maybe. And to what extent does that extend? Is it just administrative? Is it civil? Should I be on the hook criminally for him taking his own life? We heard about, in the last presentation, sheriff deputies, correctional facilities, who may be slow in cutting somebody down when they're trying to kill themselves. Should they be civilly liable? Should they be criminally liable for that? To what extent should somebody be criminally liable for that? Or say I have a client and I tell him, you're going to beat this case. There's no way in the world they're going to convict you. This jury will never convict you. Well, we go to trial and the jury, sure enough, convicts him. And he goes home and does something terrible to his wife or his kids or himself. Am I liable for that? Am I liable for that criminally? Those are hypotheticals, but I want to talk about also something you all saw today. The video of Mr. Houston, the gentleman on the bus wearing the Aaron Rodgers jersey. Who's liable for what there? I almost feel like it's a law school question, and we're in a law school, so that seems appropriate. Discuss all possible ramifications and all parties you saw in this video who may face either civil or criminal liability. Is the police officer criminally liable because he wouldn't arguably invade Mr. Houston's Fourth Amendment right to not be searched? Because that officer did not have reasonable, articulable suspicion to search him, which is the Fourth Amendment standard, and then somebody got killed. Is the cop on the hook for criminally negligent homicide? Are the paramedics on the hook? They had hands-on contact with Mr. Houston. They administered Narcan. They were doing the sternal rubs. Hands-on contact, and left a gun on him with which he used it to shoot and kill people. Are they criminally liable, responsible for that? Prior to the Elijah McClain case, I probably would have adamantly said, no, of course not. Now, I don't know. I don't know. The landscape has changed somewhat. Or what about the paramedics who waited outside for the poor gentleman who's calling about his son? He's trying to break down the door. My grandkids are in here. Stop or I'll shoot you, he's saying to his own grandson. And yet when the police come in and apparently do shoot him, he says, and you could kind of expect this, those of you who work in this area, that he, at that point, says, I told you he was just mental. But that's your issue, and that is the issue here. Scenes can go from 0 to 1,000 in a split second. Scenes can become intensely chaotic in a second. Part of the real problems that we're going to talk about with the Elijah McClain case, and the last presentation talked about trying to structure, trying to have communication. When does the person become a patient? Not a suspect, but a patient. When does that transition go from police to paramedics? Because it has to occur. But police have their concerns, and paramedics have equally important but very different concerns than the police do. You're all concerned with you all go home at night. Scene security, safety. But how does that work? What does it look like? Unfortunately, in Aurora, at the time of the Elijah McClain whole incident happening, there was no such guidance as to when the transition occurs. And police did not want to let Elijah McClain become a patient before they were certain he was no longer a threat. And that's part of the issue, as we'll talk about.
And before I go to the next slide, one other thing I want to just have you thinking about is, as you were listening and looking at those prior videos, and we heard people say you should be judged against a reasonable layperson standard of care, and my pushback on that is you are not lay people. What you do every day, what you see, how you experience it, I submit you should be judged against other paramedics, other first responders, other EMS providers, because that's extraordinarily different. If you take one of those videos in isolation, of course it's going to hit all of us, and it should. And if it stops hitting you, you need to get out of this line of work. None of you go to work every day to hurt somebody. That's not what you're doing. But you need to be judged against those that do your job. So, first responders, media, and the law. We didn't want to be in that. I absolutely can tell you our clients didn't want to be in that. These are two decorated first responders who had no prior complaints and who were highly respected within their department. How did we get there? Today's world for all of you, you're not just being first responders. This is a performative and performance-based profession now. What do I mean by the role of optics? You've got cameras everywhere. You've got, this could be a traffic cam, this could be a halo camera, this could be building security. You've got cell phones. It is going to be the extreme exception. Maybe if you're responding to somebody on a rural farm in the Amish country, you might not have a cell phone, but that's about the only time. You have dash cams, GoPros, new cars, Teslas, they all have cameras. You have building security. You have neighborhoods, ring cameras, door cameras. You have surveillance, both in and out. When you go into apartment buildings, when you go into 7-Elevens, when you go into malls, all of that is recorded. Even at banks, ATM card readers. Why do I tell you all this? Because who's the one person on that scene that's not having a camera? You all. For HIPAA, you don't have cameras in your ambulances. You're not wearing cameras on your person. And yet all of these cameras are going to be used to judge what you did. And they can't possibly bring to life the scenes you're on. And when you went through your training, I guarantee you did not have a class about how to sit on a stand and bring to life what you do every day. And oh, it might be limited to just that call, so you better make sure you bring it to life well. I don't think any of you had that class, nor should you. It's not why you're doing what you're doing. Here's the biggest one. What?
Okay.
Body
cam. the interplay of media and cameras being everywhere, and that's why Shauna started with Lamar Jackson. You all make split-second decisions. That's a comparison that may seem like it diminishes what you do, because after the end of everything, what he does is just a game. You know, God willing, nobody dies as a result of playing football. And Lamar Jackson, though, makes split-second decisions. Is that safety going to come over in coverage this time? He didn't the last 3 plays. I think I have a window. I think I'll do it. Split-second decision. What is this person suffering from? And if you come on scene and you have inaccurate, inadequate information, how are you going to make a good call yourself? You depend upon witnesses. Sometimes there aren't any witnesses except police officers. Sometimes police officers may have their own incentive to tell you what went on before you got there. How do you know if it's true or not? You've got to make your own assessments, obviously, but it's going to be covered by what you get told. What's the nature of the call that took you to the scene? And what we're talking about is the media here got a video. You all saw other videos. Many of you may have seen the video in this case. The thing that makes the videos, all the videos you saw today, and the video in Elijah McClain's case so horrifying is you know the outcome. You know somebody dies at the end of it. And with Elijah McClain's case, as Shauna said, Elijah McClain was an innocent young man. He had his life ahead of him, and he is no longer here. And that's a tragedy. No matter what else you believe about this, trust me, that's a tragedy. And neither one of us takes that the least bit lightly, and neither do our clients. That weighs heavy on all of our hearts. And it's important to remember, to keep in mind, you will be on camera. People may pick apart what you did, not just to challenge your ability to be a paramedic or your ability to be sued for civil malpractice, but any more the possibility of criminal liability as well.
So some of the ways you can prepare yourself, we tell you all this, part to scare you, because it's a reality. But more importantly, to not scare you and to tell you that you do have the power to do something. And the biggest one is just when you're on these scenes, keep talking. One of the things that was so ingrained in our clients was their job was to calm the scene down and to not add to the chaos. But oftentimes what that translates to is standing by as a strong, confident person, not intervening, but being present. And you would be shocked at how that was turned against them. It's not that they weren't doing anything. They stayed right by Elijah's side. They never left his side. They believed and agreed with the people's prosecution witnesses that he was in an emergency medical situation. They followed what they believed their trainings and protocols told them to do. And as soon as he was turned over to them and the handcuffs were off and he was on their gurney, they raced to the ambulance and he had lost his pulse and had stopped breathing. And they did incredible first responder work and got his heart back, beating back, but he never regained consciousness. And he suffered another tremendous cardiac event and ultimately died a couple days later. Is that the narrative you all hear? No. This got stacked against that this case had to do with Elijah's race, and it had nothing to do with Elijah's race. And if you sense my frustration, it is real. My children are all in diverse relationships. I will be a grandmother one day of interracial children. That offends me. Our client, one of our clients specifically, comes from a family where race is part of his family. Mike has siblings that are Black. This is not about race. There's a time and a place to make a case about race, and this is not it. And that has to hurt all of you, because that's what you're being judged against, because the cameras are on. and they're thinking, they look like white men, and he's black. And the assumption was it had something to do with that. It didn't. It had to do with a ton of breakdowns in communication and a ton of things that can and need to be changed to make this job safer for Elijah and for each one of you. Here's a few more coming on the horizon. And I say that kind of funnily. Drones. They're starting everywhere. This is your future. Satellites, AI. It's not going to go away. It's going to become more difficult. There's even discussion about sending drones in before you all go in, which sounds like that may be amazing. Think about a school like shooting. You send the drone in until somebody dies and you were standing outside and didn't go in quick enough. This is stuff you need to be thinking about. So, are these our friends, our foes, or somewhere in between? If you haven't had a case where news has shown up yet, if you stay in this business long enough, it will happen. What do? You do your job. You do it for your patients. Don't do it for the media. Don't do it for the cameras, but adapt. Even if your patient is unconscious, keep talking to them. Keep speaking out loud, because while it doesn't change your care, it changes their perspective of you.
So Shauna mentioned breakdowns. One of our themes at trial, because it's the truth, is there were lots of miscommunications here. There were misperceptions. And it starts back with the training of paramedics. It starts with the protocols developed by the medical director. Oh, I'm sorry.
That's okay. Go ahead.
I'm a little bit ahead of us. That's where all of this begins, and training matters, what people take away from things. One of the things that words matter, one of the things that was emphasized at trial is too much ketamine was given to Elijah McClain. And that goes back to the training for those of you who watched the trial. Even beginning with how this case began, as the presentation right before ours went over, lots of police contacts with individuals are not initiated by the police. The majority are not initiated by the police. It's initiated by somebody else. And here, it was initiated by a young man, 17-year-old man, who saw Elijah McClain walking down the street wearing a mask. This is pre-COVID, and it's a warm August evening, and he's wearing a mask. He's kind of veering close to traffic. He's waving his arms, and he's about to go into a convenience store. And this young man doesn't know what's going on. He calls 911. In his conversation with 911, he says, I don't know if this is a good guy or a bad guy. I don't know. But he's acting weird. He's acting strange. He's wearing a mask. And rightly or wrongly, you assume, well, that's not a good thing, somebody wearing a mask and going into a convenience store. That could result in almost anything. So unfortunately or not, Aurora at the time had a policy. If they get a call of a suspicious person, they send 2 cars. One of the cars happens to be a 2-person car, so 3 police officers descend on Elijah McClain. Elijah is walking down the street. Here's another misunderstanding. Elijah is a young man who likes listening to his earbuds, and he's demonstrative. He's waving his arms because he's listening to his music. Lots of us do that. I run with earbuds in, and I run to the music. Elijah's doing basically his thing the same way. A police officer pulls up. The first one says, stop. Stop. He doesn't because he doesn't hear him. Show me your hands. He doesn't because he hasn't yet heard him. And so the officer goes hands-on. And here come his backup, and they see an officer going hands-on. What are they going to do? They assume there's a real need to go hands-on, so they go hands-on too. This escalates when one of the officers says he just went for your gun. That's red flag, immediate red flag. Police officers don't take a chance. Unfortunately, a man was treating Mr. Houston with human dignity and respect, and they were repaid by that gentleman pulling a gun and opening fire. And cops never know when that's going to happen. If this is somebody they haven't had experience with before, they don't know. But these are what we mean by the misunderstandings, the miscommunications, the misperceptions of people that just starts to snowball and rolls down the hill.
And with respect to the handoffs and the words mattering, the scenes you're on and the information you get needs to be translated to you. But you're often not the only ones on scene, or when you are on scene, oftentimes people are frantic, scared, inebriated, under the influence, unconscious, and they maybe can or can't translate what they're trying to say to you. What I want to focus on is what you can say to them and to each other. Because believe it or not, that will really help you, at least in Colorado. Allegedly, it would have. When you write your reports, I don't know what your policies are, but at the time Aurora Fire, one person, it was a 4-man crew showed up, or 4-person crew, one person wrote the report. It didn't get submitted to everybody that was on the scene. Not everybody has to sign off on it. One person wrote it with the best of their intentions. Sometimes they wrote it right after the call. Sometimes they wrote it at the end of the shift. It had to be written by the end of the shift. Does this sound familiar? Yes, I see a lot of head nods. Probably okay 99.999% of the time, until it's not. Until you're called upon to answer for this report. That may be a month later, 100 calls later, 200 calls later. It could be 4 years later, when you're on a stand and having to answer for a report you didn't write, you didn't author, and the person who wrote it tried their best to get what they thought at the time was relevant into that report. And if you're like my daughter on her rig, her training is less is better. They don't want her putting a lot in her reports. They don't want her being a star witness on anything. And the number of domestics you respond to, oh my gosh. Defense attorneys like us would love to bring you in to contradict what somebody else is saying if your reports say differently. So I get it from a policy perspective, but I'm worried about you. I'm worried about you all and the exposure you face. So when you write your reports, you might want to consider at least taking a gander at each other's. At least making sure you've each checked in with each other about what was important. Because believe it or not, on our case, 2 of the 4 people on the crew had different information and never spoke about it to their partners. Never told the paramedics what they knew. There were 2 EMS, 2 paramedics, and those poor 2 EMS providers didn't know enough to know how important it was because they weren't the paramedics yet. And they didn't hand it off. And if they didn't hand it off, how the heck is it going to get into a report? But even more, for Elijah, if you don't hand it off, how can it be addressed? So, when you write reports, who authors it, but who can it all be used against? When was it written? Go ahead and put the timestamp in there, because if you forgot something and it was written, I know this never happened to any of you, but you might have another super urgent call that took you away from this one, and you went on another call, and then you went on another call, and at the end of your shift, you're trying to write maybe 10 reports. That's important, because it might explain why not everything made it into that report, right? So go ahead and timestamp it. It's fine. Or if just one of you authors it and you're not going to have time to check with each other, make that clear. This is written by Lieutenant X. This is written by Captain C. This is written by Paramedic Z. Whoever, and timestamp it. That way, your rest of your team doesn't have it used against them, and you don't have what you don't know used against you. Who approved it? Who viewed it? If somebody that wasn't on the scene signs off on it, this happens more on the law enforcement side, that's important too, because sometimes it changes what gets in or taken out of a report. So those that are climbing ranks and are more policies and protocol writers, be thinking about this stuff. Be thinking about how it can impact your teams. What words were used and why were they used? This sounds so silly, but again, oftentimes the people that will be judging you do not do your work. And they don't understand something as simple as when you're referencing a pulse, all you mean is you can feel their heart, right? Your heart beats. You don't necessarily mean I'm hands down, I'm taking it, it's 137/83. That is different. But you can't be sloppy when you're referring to it because that will get used against you. If you didn't get a formal, like the rest of us think, because we're educated by OTV, as to what this means, break it down. Or use simple language like you'd be talking to your kids. Because this isn't being kept only within the medical realm. Or if it's going to be, and you're going to assume it's going to be in the medical realm, just have a disclaimer on there. This is being used, I'm using these medical terms. Something, a simple disclaimer so it can't be turned around against you. Because the lingo you all use and the shorthand you all use, anybody that has any prior military, it's like they're speaking a foreign language with all their shortened words, but they understand it. You all understand each other. But don't assume we will. And even more, don't assume we're going to give you the fairness of what you meant, that it might get twisted around for whatever reasons. Sounds again silly. Is that report accurate and complete? Do those two words mean the same thing? No. Your reports might be accurate, but that doesn't mean they're complete. They might be complete and not accurate. Those words don't mean the same thing, but often we think they do. And we just quick glance, and we're just trying to get down what was relevant, because 99.9% of the time, it's not going to matter. You handed off that patient, or you left that scene, and they're fine. But you've got to practice, and you've got to keep in your mind. And I'm not saying to be scared. I'm just saying write it for the sense that, God forbid, you're ever having to answer for it, you can. No different than what happens when law enforcement officers stop being protective on a traffic stop. 99.9% of the time, not a problem, until that one time it is, and it's the most dangerous position for law enforcement to be in. I don't want to say it's complacency. I don't think that that's fair. I think it's crunch of the job, it's repetition, and it's what you do day in and day out. But when you get a little not as diligent, that could be the time it hurts you. And this is why I care what you put in the reports. Are you going to remember what you said in a month, 6 months, 1 year, 4 years? Why? Those timelines were exactly what happened to our clients. They didn't have to answer for any of this for a month. Think of how many calls. They are in a city on the busiest station. How many calls they went out on. And all they were allowed to review was that little report that one person from the team wrote. Then they had to answer again for it 6 months later, over a year later, and then 4 years later. And we won't even talk about how your day-to-day work and the vicarious trauma that comes with it helps you survive by filtering out what you think is critical and what's not, right? You got to be able to do your job. You got to be able to let it go and go on to the next call. But every time you do that, you're going to forget stuff. And what becomes cemented in your brain may or may not be accurate. And that's tough. So,
interviews. You may be interviewed. You may be called to talk to people, let's start with informal and work to formal. Friends may want to talk to you about stuff. In this case, the media was all over this. Our clients were deluged by requests to talk about what had occurred to friends, to family, fellow paramedics, fellow firefighters. All kinds of people wanted to pick their brains about what had happened. Once they were looked at criminally, they got lawyers. Shauna and I represented Jeremy Cooper. And then, our advice is don't say anything to anybody, and you stuff it and you hold it inside. But these interviews are what we're talking about. And one of the things we're talking about that Shauna just mentioned is the importance of a report. If you don't have officers' body cam footage, and you won't have your own body cam footage because most departments say you can't because of HIPAA, you either would want to see it or you want a good report that you can refer to that will really refresh your recollection of what happened. And you may say, well, how would you forget something like this? Because sometimes the worst happens when paramedics go to scenes. Sometimes, despite your best efforts, people die. And like Shauna said, if you're anything like trial lawyers, you try to put the really hurtful, harmful crap you've seen behind you because you've got to move on and keep doing your job as well as you can. You have to. It's like the defensive back gets beat for a touchdown, another sports metaphor. You got to put it behind you if you want to play well. If you want to do your job well, you have to. And so it's important to think you might get interviewed about all kinds of things. Your medical director may say, well, you didn't exactly follow protocol here. Or you could get civilly sued and lawyers will depose you and want answers to questions. Or, heaven forbid, the top right one, you're sitting on a stand and some lawyer is asking you questions. A lawyer who doesn't do your job, a lawyer who doesn't fully understand what you do, but who has a prior report that maybe you didn't even write to impeach you with, to cross-examine you with.
And another thing to think about for those of you that are writing the higher up policies and procedures and protocols, is there a way to have as part of your team's situation, if they're called in for an interview, to have a union rep with them or to have access to any body-worn cameras that were at the scene? None of you are trying to get it wrong, but if you're going to be asked to answer for what happened on a scene with specificity, when maybe you don't even know, from the time you showed up to the time you handed your patient off. You don't know what happened before. You don't know what happened after. And now you're being called upon to answer for it. So see if there's a way to protect your team by seeing what you can get for them, just so that they can have that information before they go in, or preface it in the interview. This is based on, what I can recall. This occurred a month ago. I've been on 300 calls since. I didn't write the report. I'm going to try and do this from the best of my memory. That sounds silly, but you have no clue how much that could protect you because it's humanizing you. You think you're just going in for an interview. You've never had any reason to suspect it's anything other than that, and you're trying to answer. Oh my gosh, that may become your worst nightmare, and people accusing you or making statements about you that couldn't be further from the truth because it doesn't fit whatever the reason for the current narrative would be. And you can't fix it. So think about how you can protect yourself in these scenarios. The most common are just informal, talking to each other, but answering to your boss, the licensing board, then attorneys, police, judges. But every call could be, just think about that when you're writing those reports, and think about that if you're ever asked for a statement, have somebody you check in with first. To just hit the pause button and make sure you're as prepared as you can be, or that you explain what your limited preparation is and why. Mike started to talk about this, and he's going to step in a second, but protocols, training, directives, and standards. This is going to impact from top to bottom. But as we all know, there's an adage that shit rolls downhill, and my gosh, is that true. And those of you on the rigs, those of you on the calls, it stops with you. You didn't write the policies. You didn't write the protocols. You probably didn't do the trainings, but you attended them. But you're the one whose conduct and actions are being looked at. So how do we make this work for you?
One of the things we talk about with the training, and some of you may know this if you followed the case, is there was training done not by medical director, but by fellow paramedics with another paramedic company, basically a different ambulance company. And there were shortcuts, let's say, with the administration of ketamine. And that was a huge issue in this case, the administration of ketamine and the amount of ketamine that was given to Elijah McClain given his weight. For those who have seen the video, you can't tell from the video, it was dark at the scene. It's artificially lighted to some extent. And then there's an issue with he's wearing a jacket, he's lying on the ground. Paramedics observed him with police on top of him. They have no ability. I don't know what your ability is at a scene to estimate somebody's weight. And if you're giving a weight-based medication, talk about putting you all in an untenable situation. You've got to give a drug consistent with the weight. You don't have any ability to really get an accurate weight. You have a person who doesn't seem to be making sense speaking, so you're not asking him the weight. You're waiting for police to transfer this person to your care so you can take it over, and yet you're trying to come up with a weight. And so one of the training said, well, you can estimate. If it's like a child, you can give them 300 milligrams. If it's a medium-sized adult, you can give them 400. Large adult, you can give them 500.
Well, and I'm going to clarify that. In Colorado at the time, child was 15 for the ambulances. They treated, our first responders treated on this protocol 15 years old up. So it was 300 was for your child, 15 years old, small adult. 400 was for your average size woman, and 500 was everybody else. 400 was small male or average woman. That's what they were taught. That was not okay.
And that's not okay. And it's a shortcut. It's a shorthand. It's a miscommunication, misperceptions by the people on scene, trying to follow the protocol to the best they could and trying to implement their training to the best that they could. And Shauna mentioned regarding standard, one of the big issues is the legal standard. And you may say, I don't understand, why is that important? Jeremy Cooper was found guilty of criminally negligent homicide, which basically says he failed to comply with the standard of care. What does that mean? That should mean for a reasonably trained paramedic, a professional, you should be under a medical standard of negligence. In other words, similar to a doctor, because you're operating under a doctor's license, your medical director. You're not the same as just Joe the ragman, reasonable person. And what would Joe do? That's not your job. You get called upon to do different things than a regular guy standing at a scene going, oh my God, that's terrible. Well, okay. What would a reasonable person do there? It should be a reasonable paramedic in Aurora, Colorado at 2019 who received this training. And we went round and round in this case trying to impress that upon people, and now we're appealing on that issue as well.
And that is the standard in your civil cases. In your civil cases, it is judged against a reasonable medic. Locality standard. I guarantee you were all taught that. You thought if you were under your standards, most protocols say this sets the standard. That was not what the jury got. They were told reasonable person. They asked, what does standard of care mean? They were told over our objections they could apply the plain and ordinary meaning. Gross deviation. Well, does gross mean a reasonable person? As a mom, I thought when my kids picked their nose, that was pretty dang gross, right? But is that a gross deviation from your standard of care? We saw all those videos of how quickly your scenes change. You should be being judged against each other, not against what I might do with no training on the street. But that didn't happen. And that's why this jury struggled and struggled and struggled, and up against Christmas the next day, well, then that weekend, they returned a compromised verdict at the end of the day after they weren't allowed to hang. This can happen. So how do we fix it? You fix it with your protocols, you fix it with your policies, you fix it with your directives, you fix it with your training, develop relationships, figure out. And I'm not blaming the higher ups, I'm just saying be aware of how it can be turned around and work together to fix it. Don't be afraid of the attorneys, but figure out what's at issue and figure out what you can do to be within what's going to be used against you.
And one of the things we want to emphasize is lessons. Well, here comes politics. We're not going there just yet. Lessons you can learn from this case. We talked about or touched on some of them. One of the most important is communication at a scene with your partner, partners if there's more than one, with the police. One of the great things about the medical civil rights is having that transition point from police. It's not fair to police or paramedics that nobody knows when it switches. It's too dangerous to the patient, to you all, to the police. It's inherently risky to not have those kinds of communications and the lines drawn. And here we did not. So that's a lesson to take away from this. As Shauna says, talking to your higher ups, making sure you understand training. Lots of people approach training as, okay, I've been in trainings where I sat in the back of the room and tried to avoid paying that much attention.
This might be one of those trainings.
When is this going to be over? You know, but I encourage you, ask questions. Ask questions when you go to a training. If somebody had said, you know, that 3, 4, 500, I don't know. I guess that's a shorthand way, but aren't we going to be missing people? Aren't we going to be giving too much or too little? Seems like a reasonable question to me.
Do hypotheticals in those trainings. Estimate. Do huddles. If there's 2 of you on the scene, hey man, very, very, very few of your medicines are going to be weight-based. And let me just say, we don't even know that Elijah died from the ketamine. That is not clear. We know he was given ketamine, and we know he was given too much ketamine for the protocol. What's ironic is nobody has ever died of the amount he was given, 500. And every single one of those kids that were rescued from the cave in Thailand under the water were repeatedly dosed at 500 to get them up and save them with nothing monitoring them. They had oxygen being given. We weren't allowed to tell the jury about that. They were allowed to only know about this case in isolation. They weren't allowed to know about what an average day looks like for you all, what other calls you've been on. That wasn't allowed. And it really changed how you could assess it. So what can you do and what can't you do? Our case was completely driven by politics. That's completely out of your control. But you have to be aware of them. More importantly, your bosses need to be aware of them. Because when the tides change, when things shift, when new laws are coming, they need to be telling you about them. Because if you're like me, I've got, well, right now, almost 25 years of practicing with Mike as a DA and then in defense. We're in certain habits. We do things certain ways. We work together. We don't articulate a lot of things. We make certain assumptions, but if something changes and we keep doing it our way, that could end up a problem. So be aware of what's going on in your community. Be aware if there's something getting ready to change. Don't only respond to the bad outcomes. I guarantee all the trainings are changing now, post Elijah, post our case. But if you are the higher ups, try to anticipate it to protect your crew. The news was huge. You have no idea We've done a lot of media cases, but in this one we had jurors being followed to the grocery store. We had media camped outside people's homes. We had media camped outside jurors, kids, schools. We had them follow our clients' spouses into the bathrooms. They had their phones dropped in bags and they would wander between all the fire and rescue people in the hallways and just try to pick up conversations. How can we have a fair trial against that?
We even had a reporter ask one of our clients whether he was going to testify in the case or not, which of course you have an absolute right to testify or not to testify, and it's none of the media's business.
Social media. For the lawyers in here, you better be checking social media and Googling, and it's a simple thing. Have an investigator if you don't know how to do it. I was shocked. I've been litigating for a quarter century longer now. When we asked our jurors on a questionnaire where they got their news, over 97% said social media. That's your news? I mean, it was staggering. And we weren't allowed to kick them all. We weren't allowed to kick the ones that said, yeah, I saw stuff about this case. The judge would not let us kick them until we established actual bias. So be watching it. Be thinking about it. And again, if you're the higher ups, be aware of it. Use it to your advantage to humanize your teams. Have a dialogue. Protests. Our clients weren't charged initially. The case was investigated by the local district attorney who handles all the cases. It was declined for charges. Then 2020 happened. And a terrible case out of Minnesota happened. And protests happened. And the governor got involved. And the governor turned to the attorney general, who took the case away from the local DA and hired people from all over the country to come in and opine on the case. To what you all make in split-second decisions, they had well over 120 hours of expert review to say what that split second was they were trying to say reckless. You make it in minutes on a scene. And they spent over 120 hours with experts to get these experts to say it was reckless. And all of that gets distilled down into the most sensationalized 30-second headline or news clip. To this day, I have people coming up to me telling me what our case was about, asking me. I had a judge, I'm a judge for a municipal district part-time, and I had another judge come up to me and say, I just don't understand why the medics let the police tell them to give them ketamine. That never happened. And this is a judge. It's driven by the news, and it's driven by the media. And you can't control that, but just know that's what you're up against these days. This is us. We're always welcome to take calls and talk to you and answer any questions. I know we're after the lunch hour. I know you're probably letting that food digest and it puts you to sleep. So we're going to turn it over to you now for questions, because if I was doing your job, either as a lawyer or as a first responder, I might have questions, and we'll answer if we can, if anybody has questions.
Good afternoon. I kind of have two. First off, why wasn't the jury allowed to hear the other evidence from Japan, for example, from the Philippines? Why was that?
The judge's philosophy was he was going to define standard of care, and that it was a legal definition, and that it didn't have anything to do with why these paramedics used it on this day.
Okay. That sounds rather biased to me.
And to follow up on that a little bit, This was the third of 3 trials for the judge. The two of the police officer trials went first. So he's in weeks 7 through 9. Unfortunately, sometimes implicit bias seeps in and you think you know what it's going to be about, and that's not what it's about. He believed from the police officers obviously said it's the paramedics' fault, and we went third. He had been hearing that over and over, and a specific distillation by police officers' attorneys as to what the case is about. And so he wanted to focus on not being distracted by all these other things that go on in the world, basically saying, well, the dispute isn't whether ketamine is safe or not, it was how it was administered in this case. And actually the answer is both. It's how safe is ketamine and what happened in its administration in this case.
My second question, and I already have formed my opinion, I'm not sure you'll be able to change it, but how, with social media, how can anyone in this country anymore, possibly in the world, actually get a fair trial?
I've really puzzled with this because I am very passionate about believing in our country and passionate about believing in each other. And I believe we have the best system of law, but it's far from perfect. And so, you know, under today's filters, I think it's horrific that it biases people, but I reckon back to equally horrific prior to cameras and prior to being able, the abuses of the process and the railroading of justice to people. So I struggle with that dichotomy because the reason we're here is because of the abuses of the past. And as the pendulum so often does, it went from here to way over here. So I'm also an eternal optimist, and my hope is because of the people in this room and because of your caring, we'll help get it back to the middle because people will realize, whoa, if the good people leave these professions, then the narrative that's been perpetuated wins. And we saw a mass exodus after Minnesota, and our poor departments in Colorado right now, the weekend, so this happened, the verdict came in Friday night, and I was driving overnight to Wisconsin, and I was fielding calls all night long from medical directors because they were out that weekend because nobody now knew what to do. The police, hands off, we're not doing it. The medical teams, the paramedics that were on scenes, we're not doing it. 5 separate psychiatric emergency calls, but nobody knew what to do because God forbid they weren't going to follow their protocol. And so the medical directors were trying to jump in the cars and race to the scenes. And then we say, oh, okay, well, law enforcement, you have to make sure you know if it's a medical emergency. Well, how can they do that? They either call the ambulances to the scenes or they get the person to the hospital. The hospitals are being inundated with, we need medical clearances because everybody's looking for somebody to cover them right now. The fallout from this is tremendous. And I say, weather the course, keep being the good people you are, but start talking. Don't let this define the narrative, redefine the narrative by being who you are. All of us can do better. And God forbid our worst day becomes what everybody looks at. I sure as hope it doesn't happen to me. But I know what I bring to the table every time. And my A game looks different every day because of my filters and everything going on in my life. Keep eyes on each other. Talk to each other, support each other, but also talk to your communities. It's a lot less easy to judge if you have to talk to people. And I firmly believe social media has exploded this because we've stopped talking to each other. So just get in your communities. You do it every day. Just keep talking. I think it'll come back.
So if I could follow up on your question real quick, you just got the optimist's answer. Let me give you the cynic's answer. That's a damn good question. Oh my God.
He's Irish.
I'm showing my Irish. That's a wonderful question because What you have is people who come in with their own implicit biases. They've seen a video. And if you see that video, and if you know at the end of it, a totally innocent young man is going to pass, it'll touch you. You can't forget it. You can't unsee it. And so we are stuck, Sean and I, we're good trial lawyers, but we're not mind readers, obviously. And okay, sir, you said you watched this and it profoundly impacted you. But you also say, but I will have no problem being fair and listening to the evidence in this case. Well, we've got to follow up on that, and we've got to try to tweak out whether there is some suggestion of unfairness. That's the best we can do. But it's a good question. How can we ensure fairness happens? We can't. It's a human system. It has failures, unfortunately. Yeah.
Has your case been reviewed on appeal and the status of it?
In fact, serendipitous as everything about this case has been, the appeal, our appeal is due today. So it's being filed today, the first brief. You know, it will be a case that redefines first responder care, but there's ways we can also learn and make things better from it.
On the legal side, if I understand correctly, the local district attorney passed on lodging charges in this matter. How do you advise your client when that happens about this unknown political change that might happen later on? How do you do that?
You know, Mike started kind of facetiously saying if we misadvised our clients, because at the time, you would never, ever, ever have advised your client. The DA's office has reviewed it. They've declined all charges. It was a public letter. No attorney would have advised their client, but you still need to be scared. They just wouldn't have. Yes, there's always the potential for federal. In Colorado at the time, that's why if you know your politics, it just hadn't happened. They don't step in and do that. And on an investigation into a single homicide, it had never been that the Attorney General's office steps in. So moving forward, you cautiously advise them. But what if you over-advise them then? What if you over-advise them and you have them so scared that they take their life? I mean, when we say it's stressful, it is super stressful right now, because the last thing I want to do is under-advise any of my clients. But before I got on the plane to come out here, I had to advise a very young client that he had the potential for a life sentence. And I was terrified because I don't know his mental state and I don't know if he's okay. I knew listening to it, this thing is ridiculous, but I'm not going to say that. So am I going to over-advise him and then run the risk that he can't process it? So the answer is right now, stay connected and have your leadership stay connected so you have some finger on the pulse. That's very bad for this case, but that you have some gauge.
So my question is, I was going to wait for Dr. Kupas to ask him actually, but he's here, so I'll put it in front of all of you if I could. And that is, we're working in our county to, between the Police Chiefs Association and the EMS Association on this exact issue. And one of the points is the transition of responsibility. And we kind of borrowed from the aviation sector with the challenge and answer format that EMS to approach, say, my patient, and the response is either yes, your patient, or no, not your patient, to try to make that very clear and for the body cams, essentially. You know, just what are your thoughts on that?
My gut check on that was I love the idea in principle, but it terrifies me because, as we saw, there's people that want to know whether that decision is reasonable. So you walk up and you ask the officer, my patient yet? They're like, hell no, we haven't even patted him down yet. No. And now they have a heart attack while you stood there.
The follow-up to that would be that if the answer is no, that doesn't mean you stop the approach. It's drawn a line in the sand. You know, you've attempted to take care of the patient over, but it doesn't mean you walk away.
And I think historically you would have stepped back a little bit, but I think now If I was training the teams, I'd err on the side of developing that relationship with law enforcement and being, hey, can I just do a quick? Can you hold him there? Can I just do a quick? Like, I haven't patted him yet. I haven't done it, you know. One of the big things, I think, that the buzzwords we hear today, which is an amazing response to the community, is de-escalation, and it's why I work with Pulseline, because Pulseline is a nonprofit, meaning their entire focus is on teaching the communication skills between first responders, but between first responders and specifically our disadvantaged communities and our vulnerable communities. In Colorado, we had some sad cases because of mental health and autism and things of that nature. So it's very passionate to me, but you all aren't experts in it. So it's opening the dialogue, and I would encourage your crews to keep talking, because even if you're standing there, you might be getting additional information from those officers, and while you're talking, it's gonna naturally de-escalate. If you stand quietly and maybe your inside is going crazy, there's nothing calming them. And I am not anti-law enforcement. My husband's a police sergeant, but we have to work together to calm it down, because the person that's completely vulnerable is that person on the ground that is going to be your patient, and they can't perhaps in that moment do anything. So we all have to work together.
Can I offer something there regarding your question as well? It's a hard line, you know, and we can set lines and say, well, this is when, let's take Mr. Houston on the bus example. The paramedics go up and are doing the sternal rub and all that and getting the Narcan ready. He hasn't been patted down. That's not the paramedic's job. But it's not like a person we heard about in a prison situation where everybody goes, stop, till the guard has a chance to pat him down and search him. This isn't a man who's in prison. This is a man on the bus having a medical emergency. He has Fourth Amendment rights that people in prison don't enjoy. And so what's the officer supposed to do? Start searching him, violate his rights, subject himself to a 1983 federal action for a civil rights abuse? It's a hard question to answer. It's a hard situation. In hindsight, and unfortunately hindsight is always 20/20, and there's cameras on these people, what are you going to do with the police officer? Why didn't you pat him down? Well, he's got good reason not to, but if everybody's going like this, nothing is going to happen. So,
but if you're talking on those scenes, if you're saying, you know, we've already got this is what we responded to, we've Narcaned them, you know, coming out of Narcan, coming out of diabetic situations, people can be even more violent. So you talk about it. Hey, can you guys stay close? Can your team stay close? He might be still. I've had interactions with this patient before, they might need ABC. But I think if you stay talking and you let the world through the media see what you're doing, it will also have a de-escalation effect, right? Because they're seeing, and so often many of the people on the scenes are of that old adage, outside I'm that smooth, cool duck, inside I'm going crazy. Don't let them see you going crazy, but let them hear, hey, can you give us the, tell us what we're coming in. Don't assume somebody else got it. Ask it again. What's the harm? Introduce yourself. Calm that patient if you can, even if they're unconscious. It sounds so silly, but that's where the performative side comes in. But it's also just human. Anybody else? Over. Yep.
Do you feel this would have been as high profile of a case if any other sedative agent was given?
I think this was not because of the sedative agent. I think this was because of the outcome. If Elijah had survived, I don't think we would have ever heard about this case. You know, and other things. I think there's so many, but that's one variable. There's other factors as well.
I share that opinion. I don't think it was driven by the use of ketamine. Things happened while our trial was going on, including a famous person dying after
Matthew Perry.
Yeah.
During our case.
Yeah, while it was going on. And we were like, should we have the judge ask the jurors whether this influenced them or not? That's a tough call. If they haven't heard of it, we don't want them hearing about it. And it's a totally different situation. Apparently he's got alcohol and ketamine on board, and he's in a hot tub, and he sinks in and he's gone. So I'm not sure how that case turns out, but we definitely didn't want our jurors thinking about, oh my God, ketamine really is a dangerous substance no matter what. So, but I don't think the filing decision was driven by the ketamine.
Somebody over here had a question. Yeah.
Okay.
This is from one of our online participants. If we could get past the HIPAA concerns with body cameras, would you recommend implementing them? Would they have changed the course of this case?
Two parts to that question. The first part, you're going to get the answer that probably would not be something that most of you would think. I was advocating for body-worn cameras way back when I was a DA in Denver. I think that they can only save you because I know that 99.999% of you are amazing day in and day out. And without the cameras, it becomes somebody's word versus somebody's word, or you get diluted perspectives from somebody else's cameras that may or may not capture the full entirety. And frankly, if somebody is dropping racial slurs, if somebody is being abusive to a patient, if somebody is being sexist to a patient, you don't want them on your department or on your rigs. So I would advocate for body-worn cameras, and I've been an advocate for them for multiple decades, and I think they've proven to be only helpful.
Back when I was in the Denver DA's office, I advocated for police having body cams, dash cams, because it does a world of good for good cops. And cops get disparaged way too much. And if you actually see what they do, most of the time they're doing exactly the right thing we want them to do. And not only does it subject bad cops to being off the force, but it protects good officers too against false accusations. I feel the same way at this point with paramedics. If you could get past HIPAA concerns, I would definitely advocate for body.
But it's not only HIPAA concerns. For those higher ups, that this sounds great, the big pushback in Denver, your budgets, what are the storage constraints? How long do you have to maintain them? What if they glitched and went down? What if it was, oh my God, we raced to a school shooting and we forgot to turn them on? You have to be just, there is more variables you have to be thinking through. And the nice thing about it is law enforcement across the nation has already vetted a lot of those. Lean on each other. Find out how to do that. But I think they would be amazing for you.
The second part of the question was, would it have changed the outcome in this case? Here's a lawyer answer, maybe.
I think what would have perhaps changed it, it depends, but I think.
There's another lawyer
answer. It's our favorite answer. Exactly. But I think some of it would have been being able to see our clients for who they were, and that couldn't be as quickly disparaged or disregarded. I think being able to see them from the time they leave the station to the time they're on the scene to the time they're in the hospital. We, for example, submitted videos. You know, all the videos came in from the prosecution. We submitted 2, which were our clients actively still resuscitating, taking him in and standing, watching as at the hospital they're getting him back. We were allowed to admit but not play ours. The jurors were told they could watch him in the jury room. It was taking too much time because defense goes second, and we had a juror with COVID, so we had a delay. We were up against the holidays, so we couldn't play those videos, which were so powerful because it offset the optics of they're just standing there doing nothing. And I will say one thing to you all too. You're human and you're gonna judge. All of us do. How many times I wouldn't have done that? Pause and make sure you get all your facts. Because I guarantee if you knew all the facts, you won't as quickly say that. And I saw somebody over here with a question. That was it? Oh, wow, look at that.
Real quickly, I want to jump in quickly for a HIPAA resource to let folks know about. Our firm, PWW, published jointly with NEMSIS, you heard Leonore reference NEMSIS earlier today, which is the National EMS Information System, the National Data Set. EMS people are well aware of NEMSIS. They call it Nemesis. But anyway, we co-wrote a paper, a white paper with NEMSIS on EMS body cam usage, and that's out there. If you Google, you know, NEMSIS body cam paper or PWW body cam paper, you will find that. HIPAA actually doesn't say EMS shall not use body cams, but it doesn't speak to it. But how it's used and disclosed, secured and maintained, if those HIPAA procedures are followed, it's almost like having a patient care report, and it can be done consistently with HIPAA. There is a white paper out there on that. So there's I's to dot and T's to cross, but it's not an impossibility.
Secure.
And well, let's not forget about that. Yeah. Other questions from the audience, because I've been making a whole list here, and somebody made a big mistake of giving me a microphone. So, but you guys come first. No? Okay. Okay, I do have a couple. One, you talked earlier about the politics of this. And, you know, I really want to emphasize to the audience that this is not defense attorneys belly aching that this was all political. Folks, when a county district attorney declines prosecution, they usually do it with a whimper, not with a bang. This district attorney wrote a detailed report on the reasons for declination of prosecution in the case. Then George Floyd happened in 2020, and then the prosecution was taken up by the state. Now, that is not to necessarily excuse the defects in patient care, right? But the fact is that if we don't recognize we operate in a political environment, then we're not, you know, we're kidding ourselves, really. But so my first question is really just to emphasize the overtly political nature of this case. It doesn't necessarily mean everything was done by the book medically, but the politics of this were absolutely inescapable, and I think that's important for the folks to know.
I think that's a critical thing to realize, and I know there's a word, at least I'm listening to my nieces and nephews and younger generations using this word a lot, but it comes to mind here is we live in a fluid world. And what I mean by that is today's reality might not be tomorrow's reality. So just recognize that. The politics behind this were incredible and something I've never seen. But that's also set by my own filters and my own parameters. And I am confident there were equally political decisions made other places. And when I say that, I'm not saying it was done to be, oh, I'm going after this person. I actually, frankly, think that they were looking at law enforcement and our paramedics got caught up in it. And I would totally break apart from it. As a defense attorney, I am not saying there's not a ton of things to see in this case and fix. Oh my gosh, watching one of those videos earlier, the first thing I wrote down was, why aren't there seatbelts in this police van? Like, that's, medicine evolves through horrible, tragic blood being spilled. I don't know how many people here have ever had broken ribs. It used to be taped. They don't tape them anymore because that shows that you might get pneumonia. Lobotomies used to be the way we dealt with people who had mental health issues. This is medicine, but we have to make sure we're talking about it and fixing it. And don't be afraid of saying, hey, let's fix this proactively moving forward, because I think if that can come to the front, maybe that can offset some of the politics.
And I would just say politics is like social media and cameras anymore. You can like it or hate it, but they're everywhere. It's prevalent. So
great point. So if and when we run out of time here, I have the luxury of moderating a panel discussion that you'll both be on. So I'll save some of these questions. But one other one that I really want to visit and hear your thoughts on for a second is, you talked about the standard of care issue that came up in your trial, and having watched the trial, if anybody would have tuned in mid-trial and listened to the proceedings, I'm pretty sure they would have thought it was a medical malpractice case, right? With all the discussions about protocol compliance and deviations and tort standards of care informing criminal liability. What that really raises to me is the prosecutorial judgment or discretion of criminalizing medical errors. And I'd really like to hear your thoughts about that. Are there guidelines? Are there things that prosecutors should be guided by? Or does this case itself, and they got convictions, but does this case illustrate the folly of trying to prosecute medical errors criminally when the line between tort standards of care, and sorry I'm nerding out for the lawyers in the room here, but the lines between tort standards of care and criminal liability are as blurry as they've ever been. And that's one of the most troubling things about this case, and I'd really like to hear your thoughts.
That is the scariest part of this case to me. And let me start with a very personal situation. The day before my first daughter was born, I lost my 5-month-old nephew to a doctor's mistake. And it's a confessed medical malpractice case in the state of Wisconsin. It made law. My sister's son had what turned out to be meningitis, and very, very, very treatable. And the on-call doctor had gotten a blood test result confirming meningitis and never called anybody. And my sister sat holding her baby all day, all night long. And meanwhile, I'm in the hospital in labor with my firstborn. And so Jared died on August 8th, and my daughter was born just after midnight, August 9th. So I am extremely empathetic to people who lose their loved one at the hands of another, even when it's not intentional. And I remember I was in law school and my sister was, why isn't this doctor being charged? Can we go to the DA? And I was like, no, I mean, there was no intent. The doctor was trying, she was on a date, she was on call, and she in her mind, I'm gonna age myself, had confused which color-coded file it was because she thought it was a baby in the hospital, and it wasn't, it was a baby at home. But there was no intent. And I personally feel like we need to be very candid. If society has decided we're going to criminalize medical mistakes, I think society needs to make that decision and make it clear and forward-looking. So people that are in medical jobs know what they're signing on for. I don't think it's fair to do it backwards looking because you have a tragic outcome, not when somebody's not doing something that's intentional. These people went to work trying to help. They raced to a scene trying to help. They tried to follow their protocols. Can we fix that? We can fix those things, and we need to fix those things. And Elijah's death should never be forgotten and needs to be fixed. But there is a strong line between that and criminalizing these two providers who showed up and tried to do their job.
So in answer to your question, I would say this. When I was a prosecutor, I had a case where a doctor had 3 times had his hospital privileges suspended. He was an anesthesiologist who had a propensity to fall asleep during surgeries. And he had an 8-year-old boy. They were putting tubes in the boy's ear. He had a genetic condition called malignant hyperthermia, which is pretty easily treated if you give a shot. But you got to be awake and watching the patient, and if you're not, that kid could die, and that kid did die. And I prosecuted that for criminally negligent homicide, and I would do it again if it happened again and I was still a prosecutor. So I am not saying doctors are God and are not subject to the laws all the rest of us are subject to if it's bad enough, if it's negligent enough. I'm not saying create a total exclusion, but I am warning everybody that we can take this too far. And that's why civil negligence exists. That's why administrative sanctions like licensing exist, is so prevent doctors or paramedics from doing crazy wrong stuff. But I don't think this falls into that camp. And I think this sets way too dangerous a tone, as Shauna says, that you got to worry about what you did back there when you were never on notice that it might be a crime.
And I don't think in your case, I think Mike and I, both in his case, would have, and I think conceded that it would be the same standard. It was a professional standard.
Correct.
It was not, it wasn't a situation where civil had a higher standard than criminal. In his case, they applied the civil standard in the criminal case. And that's fair if you're going to do it.
Do you mind telling us how that prosecution of the anesthesiologist came out?
He walked.
He walked.
He was found not guilty.
Probably ran. I knew you'd come through.
Unfortunately, and this is just me looking at this whole situation, you guys faced the perfect storm. The whole Floyd thing, and then they decided, well, we're not going to attack that end. We're going to go the other direction. And unfortunately, and what you said, I mean, it was media and politically driven, and it wanted to make them look like that doesn't happen in Colorado. We take care of it. And unfortunately, you had a terrible, I mean, the whole thing as far as intent, how did they prove there was no intent? Yeah, it's crazy.
But I will say, I agree. We were up against the perfect storm of things none of us can ever anticipate. But again, the dichotomy is not lost on me. Elijah was up against the perfect storm of things as well. It took a 17-year-old just going to see his girlfriend, calling 911, Because Elijah, what his 911 call is, by the way, is not the totality. He did testify before the grand jury and said much more. And he said Elijah had walked and he'd almost hit him a couple times, and that his girlfriend had been carjacked. And so that's why he was worried. And it took him calling 911. It took the dispatcher getting the little you heard if you listened to the 911 versus the testimony to say that that's a suspicious person. It took pre-COVID, this mask being on, the dark clothes, the coat, and Elijah having earbuds in. Oh my God, that terrifies me because that could happen any day with hats on, especially as we head into winter months. It took officers not realizing earbuds were on. It took then the scuffle, and then somebody thought a gun went for or it got knocked. I don't know which, but that changes the entire altercation tremendously. It took the sergeant handing off the information to the EMTs about the carotid being used, about Elijah vomiting. That never made it to the paramedics. It took the EMTs not passing it off to the paramedics. It took the ambulance that was supposed to be there in 2 minutes taking 8 minutes. It took the fact that ketamine wasn't there sooner. He would have gotten it sooner and they would have been out of there. So Elijah also had the perfect storm, and so the foil's not lost on me. It's the dichotomy of life we're in right now.
Ladies and gentlemen, please join me in thanking Shauna and Mike for being here and sharing their insights. They will be back for our panel discussion a little bit later, so thank you both. Okay, folks, so what we're going to do next is we are going to take a break until 1:45, and then we will reconvene then. So enjoy. We'll see you in a few. See if I get there we go. If everybody wants to find their seats again, I'll introduce our next honored speaker as we get started here again. So, ladies and gentlemen, in a day full of people that I've been proud to say that we're honored to have here, here is one that we are extremely honored to have here, and that is the Attorney General of the Commonwealth of Pennsylvania. Michelle A. Henry is a lifelong public servant and a 26-year veteran prosecutor. She is Pennsylvania's Attorney General. She is widely recognized for her work ethic and singular dedication to public service. Michelle rose from intern in the Westmoreland County District Attorney's Office to now serve as the Chief Law Enforcement Officer for the Commonwealth. Michelle was raised in Westmoreland County, graduated from Greensburg-Salem Public Schools, and remains a proud Golden Lion. Her life and career have crisscrossed and impacted all of Pennsylvania. She is a graduate of Allegheny College, and I'm very proud to say the Widener University Commonwealth Law School. She worked for Westmoreland County Legal Aid Office and clerked for the now retired Lancaster County President Judge Michael Georgelis. Before serving as First Deputy Attorney General, and I'm sorry, this says Michelle, but General Henry dedicated over 20 years of her career to the Bucks County District Attorney's Office, taking on critical jobs, including Chief of Major Crimes, Chief of Child Abuse, and First Assistant. She was appointed Bucks County District Attorney with a bipartisan vote in 2008. She was instrumental in helping start the county's Children's Advocacy Center and took a leading role in educating junior prosecutors from across the Commonwealth. As First Deputy Attorney General under former Attorney General and now Governor Josh Shapiro, Henry was responsible for overseeing all of the office's legal matters, including criminal cases to seek justice for victims, civil suits representing the Commonwealth, and public protection cases fighting for the rights of Pennsylvania consumers. During her tenure as First Deputy, Attorney General Henry was admitted to the American College of Trial Lawyers, one of the premier legal associations in North America. She was also awarded the Widener University Commonwealth Law School's 2017 Excellence in Public Service Award for her extraordinary contributions to public service. Please join me in welcoming Attorney General Michelle Henry.
Well, thank you so much for that nice, kind, long introduction. I have to say, it's great to be back here. As you heard, I went to law school here many, many years ago. And, you know, as I move forward in my career, starting out as an intern and assistant district attorney, and now as the Attorney General, I can say that this law school really gave me a great foundation for my legal career, and I love to come back here. And ironically, right before I was leaving my office to come over here in Harrisburg, I was chatting with the soon-to-be Attorney General Dave Sunday, who also is a proud alumni from Widener. So you guys churn out attorney generals here, and I think that's a good thing. But first of all, I'm really happy to be here, and I have to say, as I was thinking about what I wanted to talk about here, I looked at you know, the speakers that were going to be here today, the panelists, and what an amazing group of individuals with the talent, the expertise in this particular area. This area is so important, I think now more than ever. And so hats off to this organization for putting this on and having this group of experts come here. I certainly don't pretend to possess the kind of expertise that all of the individuals that you heard from this morning and will continue to hear from this afternoon have, but I can speak, I think, from my perspective as a longtime prosecutor. And let me just say, so that people understand sort of the background that I'm coming from, the Attorney General's office, because a lot of people, and even myself before I joined the office, didn't really understand what the AG's office really does. I mean, pieces of it, yes, but the whole sort of setup. So I'm just going to spend a couple minutes on that. So in the AG's office, we have 3 legal divisions. there is the Civil Law Division. And that division, when I think about it, is a group of attorneys and support system. And what they're really tasked with is defense, civil defense. So if a state agency gets sued or the litigation is brought, say PennDOT or Department of State, their job is to defend those lawsuits and to look at those lawsuits. Or if PSP troopers get involved in a situation and there's litigation filed against them, they're looking at those cases to decide how best to handle them. In addition to that, they're tasked with defending the constitutionality of the statutes, of our statutes. So if you followed, we had a lot of are coming off a really busy time with our election laws and the election process, and we were very much involved in a lot of the litigation that was in there, and that is all out of our civil division. Our other legal division is our public protection division, and that I think of as more the active litigation. So it's exactly what it says, public protection. So that division really deals with cases that can come up and things that we see that is happening to the citizens of our great state and taking action. So our consumer protection section in that division is really large and deals a lot with, say, scams. We see a lot of elder scams going on, a lot of different kinds of scams, and they're in charge of that. And it can be anything. It can be you bought a T-shirt online that was supposed to change color in the sun and it doesn't, to, we did have that case, to really big cases, and or people, contractors that are ripping people off, romance scams, all those kind of things. It's about taking action, litigation, as well as education and awareness. We also, under the Public Protection Division, we look at healthcare mergers to ensure that when we're thinking about healthcare mergers, we make sure that our charities division is looking at nonprofit going to profit. We look at mergers that happen and whether or not it's anti-competitive, and should we be blocking those mergers. So there's a lot of different things we do in the Public Protection Division. They do a lot of great work to protect the Commonwealth. The final division is our biggest division, and probably one maybe you're more familiar with, which is our criminal division. And under our criminal division, we have a lot of different sections. We have a child pred section that goes after child predators. We, of course, have a large narcotics section where we're dealing with guns and narcotics. We have a corrupt organization. We have insurance fraud. And so we do a lot of different things. We also handle all kinds of cases throughout the Commonwealth that come from district attorneys' offices. So we take any case that they refer to us for a conflict or a lack of resources. So that's really the layout of the office. And so you can see how there's a lot of different overlaps in the areas that we're talking about. And when we think about this, and I think about these cases, you talk about these encounters that you have, and I'm looking up at the next topic, and you have first responders, police officers that have to respond, and they have certain duties and obligations. They have to protect the safety of the public, they have to protect their own safety, and then the public has rights, whether that's a suspect who's in custody or bystanders, they have certain rights that need to be protected. And then often, of course, we have EMS that are involved in responding to that, and they have a duty to carry out, and they have to make sure that they're following what they have to do. And, the hope is, of course, that it all works well. But we know so often and have seen recently that sometimes those things are very difficult. They either come into conflict or there's confusion. And, when I thought about coming here today, I thought back to my days as a prosecutor trying cases. And I had one particular case that I think sort of shines a light onto this. And what I thought about, I had a case, so you'll have to indulge me. It's hard to get a prosecutor up here and not tell one more story. But I had a case that involved a married couple, and they were from a affluent area of Bucks County, and they had been married, they had no children, and the wife decided that she didn't want to be in the marriage any longer and was going to separate from her husband. And because of the conflict and the sort of things that had been going on with the husband, she talked to her father and had decided that she was going to have the movers come while her husband was at work in an effort to sort of it not to be so confrontational. And so that was all arranged, and the movers showed up on the day and time that they were supposed to, and she was not there. And then her father tried to reach her and couldn't get a hold of her, and then ultimately she didn't appear for work. So the police were called, and they responded to the residence, and they knocked on the door and tried to get in, and nobody was there, and they ultimately entered the residence, and they found her upstairs in the master bedroom. And it was clear that she had been there for a couple days and was deceased. And at first appearance, it looked like she had slit her wrists. And as the police were looking at this and investigating this, they realized that there was an individual in the garage. And there was a vehicle in the garage, and it was running. And at that point, they've now, obviously found the wife who's deceased. And what they did immediately was call EMS. And EMS arrived promptly, very quickly, and they were able to get the individual who was unconscious and was the husband out of the vehicle. And he was taken to the hospital and treated. And ultimately, it was determined that it was not a suicide, but in fact, he had killed her and left her in the master bedroom. And so in some sense, you think about that and the responses that could have happened there and how things could have been different. But the police did call EMS, and they did come and, save that gentleman. Now, when I think about the criminal justice system, there's so many levels, right? There's so many layers to it. And that, of course, was just the first responder and the first step in that process. And the next step was that the individual was, of course, charged with first-degree murder and was facing the trial for that case. And while we were getting close to trial and while he was incarcerated, he ultimately ended up taking his own life. And so, there's a lot of questions and issues just there. Should have he had treatment? What should have been done there? But, you think about the interaction and the tensions that you have when you have individuals, and especially nowadays, I think times have even changed since when I started out as a prosecutor. I talk a lot about the opioid epidemic, where we're losing 14 individuals a day in Pennsylvania for overdoses. And you think about the opioid epidemic, you think about the powerful illegal drugs that are out there, fentanyl, and then you think of these even newer synthetic drugs that really are interacting with illegal drugs and making people really act quite different and dangerous psychoses that when people are responding, when first responders are there, it's difficult to assess. And then we talk about that healthcare system and the lack of maybe mental health treatment, how challenging that can be. And I know all of you are going to talk about some significant cases that we have seen that really have highlighted how much this needs attention, from the George Floyd case, where, you talk about liability, and that liability is criminal liability, rightfully so. To the Dluhy McClain case, which is civil liability. But you think about the kind of liability that can happen. And having been a prosecutor for a long time and working at the AG's office, I always try to look at what are we doing, what changes? Well, one is that you guys are all here talking about this for awareness. I think that's so critical. And talking about how we can make improvements, how maybe we can talk about coordinating efforts together, how we can talk about what laws need to be changed. And then I think, too, to some of the things that are happening around the different counties in Pennsylvania. probably a lot of you are familiar with the changes that have been made in Philadelphia County. So in 2020, they had a fatal shooting of an individual by police officers, and they decided to really take a look at what can we do better. Because, you know, if you bring teams together where there's an understanding of what's really happening, it can be a game changer. So now they have a system in place in Philadelphia where there's law enforcement that are responding, but there's also trained professional mental health individuals there that can intervene and take a look at what's happening and can advise, because that is so important. Even in Dauphin County, just last week, I was with the county commissioner, and he talked about their program. And their program also is based on the idea that law enforcement really needs training to understand, because a lot of times when law enforcement is going out, we all know that there's often some kind of mental health crisis. And, you know, that can go a lot of different ways. The hope is it de-escalates. And as a result, individuals are kept safe and the community's kept safe. But if it doesn't go that way, if it is not recognized as a mental health issue or a medical issue, and maybe is handled in a different way, we look at the tragedies that can come out of that. And so in Dauphin County, I know they're working also on training for their law enforcement, as well as when responders are going out, that they have individuals. And, you know, when you talk about having somebody who's trained in the mental health area, hopefully if it's working well and they're working in coordination together to collaborate, to assess these situations, then, you know, maybe the acute medical treatment isn't necessary, other than the mental health piece of it. And that's really what we can strive to do. So we're seeing changes throughout the Commonwealth that I think are positive, but the awareness and the talk about what's happening right now here is so important. So I just really want to thank everybody for coming today, for listening, for caring about this, and to all the first responders that are here, thank you for what you do. It is such tremendous, difficult work. Every call that goes out, you know, you're facing something and you're having to handle a lot of really stressful and difficult issues and circumstances. And so I'm grateful for the work you do to all our first responders. Thanks so much for having me.
Thank you, General. Well, thank you, General. If Brian is in the back, you said, Corinna? Okay, Brian will come on out and he will get us set up. One of our presenters in the next session is virtual. The other one is very much live with us in person. So as Brian is getting that all together, I will do the introductions and get us started here momentarily. Okay, the presenter who is here with us in person, to my left, your right, is Dr. Douglas F. Kupis. And Dr. Kupis is a board-certified emergency physician, subspecializing in emergency medical services. His clinical interests include resuscitation, CPR, hypothermia, therapeutic and accidental, end-of-life care, EMS patient and provider safety, and EMS airway management. His research interests include CPR quality. Dr. Kupis earned his medical degree from Thomas Jefferson University, completed his residence at Geisinger Medical Center. He's certified by the American Board of Emergency Medicine. Up at Geisinger, he serves as the Director of Mobile Integrated Healthcare and Resuscitation Programs and the EMS Medical Director for the Geisinger Danville Ambulance Service. Dr. Kupis is also the Medical Director for the National Association of EMTs, and he served as the EMS Medical Director for the Commonwealth of Pennsylvania for 22 years until December of 2022. Importantly, I also want to emphasize that Dr. Kupis is the President-elect of the National Association of of EMS Physicians, NAEMSP, and NAEMSP is one of the organizations that is a party to this joint consensus statement that Dr. Kupis and Dr. Miller will talk about. On a personal note, I have to also add, he said, no, we're going to both date ourselves here. I first met Dr. Kupis when he was a medical resident back in the, I want to say late 1980s. Is that right? Early 90s. All right. Wasn't as bad as I thought. And we're very privileged and lucky to have Dr. Kupas here. Joining us remotely is Diane Miller, MD. Dr. Miller is an emergency medicine physician at the University of North Carolina, Chapel Hill. In addition to her clinical duties, she serves as the medical director for the North Carolina State Highway Patrol and several other state law enforcement agencies, and is the assistant medical director of Orange County Emergency Services. She is a reserve special agent with North Carolina Alcohol Law Enforcement and supports several tactical teams. Her special interests include first responder physical and mental wellness, as well as tactical emergency medical services. Dr. Miller, welcome. Are you hearing us okay?
I am. Thank you so much.
Great. We are hearing you loud and clear, and thank you for joining us. And Dr. Kupas, you're here at the podium, and the mic is yours, and thank you so much. Join us in welcoming Drs. Kupas and Miller.
Thanks a lot, Doug. What you didn't say was like you were delivering patients to the emergency department to me when I was a resident.
Yes.
Somehow, Shanna and Mike, that whole list of things they came up with didn't suggest that I like to go into the outdoors of Pennsylvania and enjoy the outside and that sort of thing. So I have to add some things. Well, it's great to be with all of you. And unfortunately, Diane is on the verbally, but I don't think we have a picture of her or get to see her. So, okay, they can see her. All right. So Diane, you're at our mercy, because if you're like waving and trying to get us to slow up a slide or something, we won't see that, but just pipe in. We are going to do a bit of a joint presentation here. The one thing in the background that Doug did not mention, so for the group of paramedic students that are here, which is great to see a group of paramedic students here, the NRP, National Registered Paramedic, behind my name is about 3 weeks old. So I just sat and took the test that you're going to take. I've been a paramedic for like 40 years, but a Pennsylvania paramedic, and I was never nationally registered. So I just got that 2 weeks ago. I did. I don't know. It timed out in like 10 minutes and 3 questions. I don't know what that means. An inside joke for those that don't know about the way that testing is done. So we're here to talk about this consensus statement, and you've gotten my background. Diane is also, Dr. Miller is also on the board of the National Association of EMS Physicians. And anything else you wanted to add to introduce what you do, and particularly in this realm, Diane?
No, I've been involved with EMS education for many years, and also am one of our board certified EMS physicians, but I've had some experience from different aspects of this consensus statement, both from the medical oversight to EMS education to field support and law enforcement and fire as well. So I think we've got between the two of us and the rest of our team, we've got quite a few angles covered with this. But thank you guys so much for letting me join remotely from North Carolina.
It's great to have you, and bear with us in doing this, because we are going to go back and forth in the slides, and I think it will be seamless, but it's interesting when you can't see the other person you're presenting with. So go ahead, Diane, I'll let you take
So
this first.
unfortunately, we do not have any financial or other disclosures to report for this. So, we find it really important to understand some of the historical background behind this consensus statement, not only how this group came about, because it's the first time this particular group has worked together, but also how did we get to the point where we need to have a consensus statement on how law enforcement and EMS interface. So Doug's going to talk about this in the next few slides. We'll also be delving over the next bit on the different features of our consensus statement. So everything from how do you define an acute behavioral emergency through some of the biases that we may encounter when we're dealing with these individuals, and then what we need to focus on as a multidisciplinary group in terms of improving our education and training, of focusing on our protocols, policies, and procedures, and how do we transition care from one team to another in a seamless and safe way.
So the historical part to this, I think, is very important. And one of the things we should have said up front is that this consensus document that was just published this year is historic because it was published with the National Association of EMS Physicians and the International Association of Chiefs of Police, and also the International Association of Fire Chiefs. And to my knowledge, this is actually the first time that we have had a joint position statement or a joint statement with law enforcement. EMS has a long history of doing joint position statements, and I'll talk about a couple of them that go way back in the introduction to this. But we have never done one jointly with law enforcement. And really, it's sort of straight out of Elijah McClain and some of the other cases that you heard about today. That causes us to write these position statements that hopefully become parts of protocols, parts of procedures, parts of operational teamwork among groups. And so I think it's sort of historic that this is the first time in this document that it connects law enforcement and EMS. But if you go back historically, the cases we were talking about today, unfortunately, are not the start of a problem. This was a problem way back. In 2002, we wrote the first position statement within NAEMSP related to patient restraint in EMS systems. And that was because at the time we wrote that, so in the around 2000 or so, the textbooks of EMS still actually showed pictures of restraining people prone on an ambulance stretcher. And, if you think about that, the textbooks are showing it, it's being taught in classes, and something has to be done about that. So we wrote this position statement, and one of the big things in that was that prone positioning is not appropriate, it's dangerous. And, these position statements do have an effect because now you can't find a textbook of EMS that says put the patient in a prone position or sandwich them between the backboard and the stretcher and tie that down, into the backboard sandwich or various other things that used to happen. And people died and had bad outcomes back then, and that led to those changes. The other thing is terminology. You heard the term excited delirium, and there are people right now that if I say excited delirium in this presentation, there will be pitchforks and torches. But excited delirium in and of itself is not a particularly bad thing. It is, as was pointed out this morning, it's what you're calling something that maybe isn't, what it's intended to be. The concept that there are people that become delirious, meaning that they can't communicate with you, they don't know what's good for them or anybody else, they could be harmful to you, but they don't even understand that what they're doing. So they're delirious and they are agitated, and those patients exist, right? So by eradicating the term excited delirium because of its some of the connections to it in the past, it doesn't mean that we don't still see people who are delirious and have agitated behavior, and we have to have a way to take care of them. So excited delirium is out of all the nomenclature at NAMSP and the emergent EMS boards and various other places. But NAEMSP chose to use the terms excited or delirium with agitated behavior. And that's the terms that are used in the current position statement that NAEMSP, the National Association of EMTs, the National Association of State EMS Officials, the National Association of EMS Educators, and the American Paramedic Association all did a joint position statement in 2021 that's later on this slide that sort of defines that. So in 2002, Jerry Widener, an EMS physician from Bucks County, Pennsylvania, and I actually were the authors on this patient restraint in EMS systems. It's been updated several times. It was updated in 2017 and most recently in 2021. I bring all this up because there's a subtle nuance in what we're talking about today. Today, we're talking about a consensus statement between NAEMSP and the International Association of Chiefs of Police. It's a consensus statement. It doesn't say position statement. And that's because NAMSP has a bunch, dozens of position statements on various things and the most appropriate way to care for them and treat them and most appropriate practices in EMS. The consensus document is not called a position statement because it has and reinforces some of the things in the 2021 position statement, and that is still valid. So this does not replace any previous things. It is sort of a separate consensus statement, but it still is very valid in saying how should police and law enforcement and EMS interact at the scene. The other thing I will say, and this morning in his opening, Doug alluded to, the other Doug, that ASEP has retermed excited delirium as hyperactive delirium. And, so there's a bit of a difference in that the 5 organizations that I just spoke about call it delirium with agitated behavior. ASEP has rescinded their previous excited delirium policy and calls it hyperactive delirium. The bottom line is, again, I want the message to be, we see these patients that have this kind of presentation, we have to know what to do with them. So don't get too caught up in the semantics. Likewise, I could have put ketamine on here. Our position statement from 2021 talks about pharmacologic management of patients that are agitated. It does not talk about the old term of chemical sedation, but it does talk about the role for pharmacologic treatment. That could be ketamine, that could be midazolam, that could be a couple of droperidol, some other options. It talks about that in and of themselves. They're not a bad thing. It's the proper application.
So you've heard a lot today about more of the details on some of the well-known cases, like McClain, Nichols, Van Syak, and others. So I'm not going to give you any third-hand information on this or get into the weeds on those particular cases. I think the biggest point to know is just that there are many of these cases over the years. It's still a rare event compared to the number of interactions that law enforcement and EMS have with patients in the midst of a behavioral health emergency. But I think we do need to remember and recognize these specific cases to help guide how we assess the scene and approach it. And as Doug mentioned, there's a lot of different terms that have been used over the years to explain this type of phenomenon. There's still a lot that we don't know about it. The names will probably change again in the coming years. But when it all is said and done, the features remain the same. And so that's an individual who's experiencing an event where they're displaying severe agitation and aggression. They may be combative, they may be violent. And it's important to remember, and we'll talk about this again throughout this talk, but this may be due to a specific mental health emergency. It may be a medical emergency. It may involve substance use, or more commonly, it's some combination of these events going on. And the biggest thing to remember with them is that it is hugely risky for the safety of that individual as well as those on the scene. So it may include bystanders, it may include public safety personnel that are involved. But we do need to tread very carefully when we're approaching these individuals to make sure that that safety is maintained. And this is something that, as Doug mentioned, was brought up in several position statements between different organizations. Most recently, just a few weeks ago at the ISAP meeting in Boston, they passed a resolution titled Management of Behavioral Health Emergencies, and it mirrors a lot of the information that we have in our joint consensus statement as well. But this is something that we do need to continue to talk about. There's a shift in focus from different types of interactions that law enforcement and EMS may interface on, and now really focusing on this more widely viewed type of event with these acute behavioral emergencies.
And Diane, maybe if, in addition to being on the NAMSP Board of Directors, Diane also has some connection to the International Association of Chiefs of Police. And maybe if you could give just a tiny bit of introduction to the fact how physicians fit in and the subgroup that they have for that covers some of these things.
Absolutely. So, law enforcement medicine, as I view it, is a newer subspecialty, and there's a group of physicians. It's really more kind of the hundreds in the scheme of things compared to the thousands that we see with EMS medical directors. But this group, we have a variety of roles. We may provide field support for tactical teams. In my role, I have a few different jobs that I do. I provide medical oversight for an EMS system, which is embedded within our state law enforcement agency. So we have law enforcement officers that is their primary job. And then they also are certified and practicing EMS personnel. So they may be the first to arrive on scene, and we'll have to provide a higher level of care until local EMS can arrive. We also, some of us will focus on the physical and mental well-being of law enforcement officers, which has been a really hot topic for IACP over the last year. They've been featuring a series each month on different wellness topics. And so within IACP, we now have a physician section which deals with these different features of where medicine and law enforcement interact. So it may be topics that we discuss involving the law enforcement wellness themselves, or it may be how law enforcement may interact in a medical situation. And so, it's a very well invested and very seasoned group of physicians that are part of this team and do provide some medical guidance to the overall IACP.
And Chief Wolfberg, prior to working on this project, I had no idea that there was even a committee of physicians within IACP. I just pictured they were a lot of police chiefs. Go ahead, Diane.
So, as Doug mentioned earlier, our goal with this consensus statement is really to focus primarily on the safety of everyone involved with a behavioral emergency. And this may involve the individual themselves, the bystanders, law enforcement, EMS, any other responders that may be involved. We want to provide protection to each of these individuals from physical injury, and also not add on to the psychological trauma, if possible, to the individual experiencing that emergency as well. And so really our focus throughout this paper is how can we improve safety of all involved with these types of events. It's also really important for us to recognize that an individual experiencing an emergency like this, their dignity needs to be maintained as much as possible. It may be due to an intoxication event. It may be due to acute psychosis. It may be another medical event or a combination of these. And so we need to treat them with the utmost respect, and their privacy should be maintained as much as possible. And so, really being mindful of that, utilizing our training when we're approaching this, trying to limit the number of bystanders on the scene if possible from a safety perspective as well as a dignity perspective. We also think that it's incredibly important to have protocols and policies and procedures that are EMS specific, law enforcement specific, and then also involve the interface between those two groups of first responders. We'll talk about this a little bit later on today. But we need to make sure that these things are planned out well in advance and keeping them a little bit more broad rather than too narrow in scope, so that they can be applied to a variety of situations. But it is very, very important for us as a joint team that we encourage organizations to have protocols and policies and procedures addressing these events. And then finally, our fourth focus of this paper is making sure that EMS clinicians have access at the earliest point possible when it is safe for them to do so, so that they can access the individual experiencing the emergency. They can do a proper assessment, provide appropriate care, and then provide continuing monitoring and treatment of that person. So we'll again talk about that. When does that transition occur, and kind of who has the oversight over that?
Attorney Pello brought up several times implicit bias. There are other biases too. One of the biggest issues with the cases that have been described to you today, but also with care in general in EMS, is the idea of bias. If you go into a call and they give you a certain information at dispatch, it's very easy to get an anchoring bias, and you are fixated on whatever the dispatcher told you, even though they weren't there at the scene. They've got just a scant amount of information, and they give that to you, and suddenly it anchors your bias to that call. So you walk in the door, it biases what equipment you take in. Sometimes it biases how you do your assessment on the patient, and you can miss things. There's ascertainment bias, there's confirmation bias. All of these biases are a big thing in healthcare too. When a resident presents a case to me, the way they present the case and what they choose to give to me about what they saw biases my initial thoughts before I go and even see the patient. So we all in medicine have to understand that we need to look at things widely and openly, and be very aware of bias, for one thing. And, bias occurs on the law enforcement side too. And then when you get law enforcement and EMS working together, and everybody's biased to something they think is going on, it's very easy for something to fall through the cracks. So we have to be complete in our assessments, patient assessments in particular, so that we don't have these biases.
So it's really important to kind of understand when the transition occurs from an individual being a subject of a law enforcement interaction to being a patient. I think it's a really tough question, as that line can be very blurred, especially during a dynamic scene, as these tend to be. There's a lot of considerations that should be made, and a lot of this can be, a history on an individual can be obtained through the emergency call centers, and also from law enforcement interactions with bystanders or EMS interactions with bystanders. But you want to think about the history of that individual. So think about if they have a legal history involving similar events, if they've been known to have behavioral health emergencies, domestic violence incidents, substance use history. EMS and even law enforcement can use some visual cues, like medical alert bracelets, if there's any medications on the scene, any kind of medical equipment, any signs of trauma. But it's incredibly important to remember that not all of these behavioral emergencies are truly behavioral. They may have a medical source behind it. In North Carolina, we frequently reference a case of Graham versus Connor, which was a case that involved a diabetic emergency that initially presented as more of a behavioral or criminal issue. And so I think that really highlights, it's one that we come up with our legal block every year for our law enforcement in service training. And it really highlights the importance of recognizing that not every situation is what it seems off the bat, that there may be a medical source behind it. And so we need to figure out, one, is that scene safe? And then, is there something potentially behind the situation where EMS may need to get more involved? And at that point, when EMS can go in to do their medical evaluation, or if there's a law enforcement officer that is able to do an initial medical evaluation to identify any potential medical issues, that's where that transition changes from a subject of the law enforcement investigation to a patient. And at that point, we need to shift who is kind of taking command of that scene. Law enforcement will still be responsible for the safety of everyone there. But EMS will be focused more at that time on the individual's physical and medical well-being. It's important to assign roles. It's important to have communication between the different parties involved, because it may change. You know, the scene may become unsafe again, and EMS has to step back and let law enforcement come in and make sure that everybody's safety is still a priority. So you have to have some flexibility with these roles and kind of who's taking on that official command, and kind of have it be more of a joint command situation. There was a question in the chat about which case it was. It was Graham versus Connor is a case. I can see if I can send that out to Doug or through the chat after we're done. So you can have, oh, perfect. Thank you to Chris Geringer. But that's definitely one of the major cases that we do review annually in North Carolina.
You know, there was this conversation earlier about how do you formalize, you know, first of all, I like the idea that we're hearing about places that are getting law enforcement and EMS together and saying, okay, how are we going to handle these joint things? And one of the suggestions that was made was this concept that the airline industry uses, and others of, you know, my aircraft, your aircraft, and then that pilot takes over. You know, I like the communication part about that, to sort of distinctly let people know that, hey, now this is my patient, your patient. It's a medical issue now. The one thing I think we have to be careful about that is this is not so simplistic as, okay, you're a patient, we're out of here. You know, it's a teamwork. And to me, it's not exactly like, you know, 100% in charge here, 100% in charge there. But I think it has to be a little bit of a shared kind of thing. And, you know, when it is patient care, it's obviously EMS's ballpark, and they should be sort of guiding that. But law enforcement's on the team at that point, and they have roles and responsibilities too. And maybe it has now shifted to 80-20 EMS when it's all patient care that you're doing. And maybe when it's, you know, all the initial takedown and making sure there are no weapons involved, et cetera. Now it's more, you know, closer to 80% law enforcement and 20% EMS keeping an eye on what their job is. So I think it's difficult to just make a mine yours, but I think communicating that so that the group knows, okay, this is primarily a patient now, and we're going to treat them like a patient, and we need to make sure that they can get in and get their assessment done, do the things they need to do to make the proper decisions. Makes a lot of sense. So, you know, this all comes down to a lot of it comes down to taking these principles and then meeting within your own community to say that at 3 a.m. when this happens, we shouldn't be figuring it out. We should figure it out now. And our people should maybe train together and drill together, et cetera.
And we'll talk a little bit more about training and education in a few minutes. So, you know, we've mentioned a few times the importance of kind of preparing and thinking about these events ahead of time, and trying to get some protocols and policies and procedures in place. You know, again, there should be some EMS specific protocols. There should be some law enforcement specific ones. And then I think it's really important to try to have these conversations ahead of time with your partner agencies to create some sort of protocols, policies, and procedures on how to manage these shared scenes. For the EMS specific protocols and policies, it's imperative that the system's medical director is providing oversight over those, because there's a lot more behind the scenes in terms of thinking about ethics and legality and safety, and making sure that we're doing right by our patients. And so you do have to have that direct medical oversight. And that's where it's helpful to have medical directors that have had experience working with law enforcement or have a better understanding of that. And so the trend nationally is for EMS medical directors to go through additional training, their EMS fellowship year, and become board certified in medical oversight. And that part of that training involves also doing some law enforcement training as well. So whether it's doing a medical director's course for managing a tactical EMS program, or learning about some other features within law enforcement medicine. But I think that's definitely included in our standard education where our EMS board certified physicians are. When I got my start, I was up in Maryland in a fire-based EMS system. And I will be honest, this was 2002 is when I first got started, and I was up there going back and forth for about 10 to 15 years. And we very rarely trained with our law enforcement partners. It was even difficult to have training with other fire departments or EMS units. And so, how do we build those relationships so that we can start training together and foster more of a unified effort when we're having these shared scenes? And so, some of the tips that I've found over the years is, what can I offer you? Before I ask, what can you give me? And so, providing education, providing handouts or offering to do a brief presentation at the beginning of their shift meetings, where you're talking about the signs and symptoms of things like acute behavioral emergencies, talking about the signs and symptoms of a person who is in distress and maybe having a medical emergency, offering to provide basic first aid and CPR courses. For CALIA accreditation, which most law enforcement agencies have, at least in our state, you are required to have CPR certification. All of our troopers now also have access to AEDs. And so doing medical education is something that we start in their academies. It's part of our basic law enforcement training certification. And so if our local EMS agencies can then provide some of these trainings to law enforcement, it helps to open up those communications and that familiarity as well. And the same thing goes for EMS learning from law enforcement. Our law enforcement partners can come to us and say, hey, can we provide some de-escalation training for you? Can you go to CIT training together at one of the community colleges? It's important that we're practicing restraints and positioning, specifically the application of restraints, as well as the removal of those restraints, especially under duress. Practicing those transitions of care from law enforcement to EMS, EMS back to law enforcement, or one of those groups to perhaps the emergency department or to corrections staff, making sure that you have discussions and education on how we use medications when we're taking care of individuals having an acute behavioral emergency. What are the reasons that we use those medications? How are they administered? What kind of positioning would we need them in? What are some of the downsides to these medications? How do we recognize when somebody maybe is not responding in the way that we would like to those medications? And really, the more that we can try to proactively develop these relationships and then eventually incorporate multi-agency training, I think is really an area that we need to focus on. And that's something that our group within the consensus statement team also wanted to focus on as well.
The next few slides, I want to actually take us to the 2021 position statement. As I said, this is a position statement of 5 organizations with NAEMT and the SEMSO and NAMSP and the educators. And the reason we have to do that is that this is a core. It is mentioned within this consensus document, and it is a core for how patients should be cared for. So for the paramedic students in the audience here, hopefully you have this somewhere along the line. For those that are in Pennsylvania, which is probably most of our crowd, that you have one advantage, and that is since 2004, the language from that initial position statement on patient restraint all the way up to the 2021, position statement have all been baked into the statewide protocols. There's a tremendous advantage to being in the state that has the largest population under a single statewide protocol, because hundreds of people have had input into it, and about 50 EMS physicians have also worked on it. And things like national position statements can be baked in so that you don't have to rely on somebody saying, oh, do we have a protocol for the agitated patient, and what does it say, and what do we say about prone, et cetera. All of the stuff that is in here is actually in those statewide protocols. So hopefully that in Pennsylvania has helped get that information out to the frontline EMS practitioners. Oh, and by the way, I will say that Jerry Widener and I did that first paper in 2002. I hate to ask where some of the paramedic students in the back were in 2002. But we did that first one, but Elvin Wang is the EMS medical director in Montgomery County. So this paper actually has 3 Pennsylvanians on this national position statement. We've said a few times the importance of medical evaluation. You know, I have been very involved in a couple of the cases that you have seen today, and I have studied all of them. But I have been very involved, more so than what the lay person has seen in newscasts and things about some of them. And people like Earl Moore, people like Elijah McClain, that sort of thing. I think every speaker that's been up here, it's just a tragedy. These individuals should not be dead today. And, unfortunately in medicine, we have medical errors, we have malpractice from time to time, and we try to prevent it as much as possible, but those things do occur. But, you saw the video of Earl Moore, talk about the medical evaluation. There wasn't a single set of vital signs done in that patient's bedroom. There was no assessment at all, really. And, he was just sort of grabbed and dragged out to the ambulance. And admittedly, no assessment even in the ambulance. We have this issue, I think, in many places in EMS where it has become culturally okay to walk in with just a clipboard because of what the nature of the call was. I can't fathom that you shouldn't always be walking in with at least a BLS bag with the ability to take a first set of vital signs where the patient is, and to assess the patient, because you really don't know what his issue is until you have done at least your basic level of assessment. And all too often, I see throughout the Commonwealth, EMS practitioners where it has just become the culture to do those things later. You can get it in the ambulance. Well, no, if they're a crashing patient, by the time you get to the ambulance, you may be doing CPR. So very, very important. That law enforcement understands that, we've got to get in there and kneel down and talk to that patient. We've got to at least, have a hand on the pulse and be feeling their pulse and counting their pulse and, getting a blood pressure, that kind of thing. And doing enough of an evaluation to figure out if they are potentially hypoglycemic or something that we can correct, or, or something we can't necessarily correct. Maybe they're hypoglycemic, maybe they have a traumatic brain injury. And then you can at least start your traumatic brain injury treatments. So the assessment in a timely manner, and really, there are a few patients where I think you should make the excuse that, well, it was better to just put them in the ambulance than to do the assessment. And, everything has its, I tell my folks, there are exceptions to every rule. If you are, pulled up to the curb, the patient is there, they're 10 feet from your ambulance, and it is pouring down rain and lightning, then maybe you should put them on the stretcher and put them in the ambulance before you get your vital signs. But for most patients, you should get that first set of vital signs and assessment where they are. Treat them where they lie. The other thing is, just this joint ability to have access to the patient for the assessment, and that sort of thing. And, EMS sometimes is called to sort of provide this medical clearance. And in some situations, an assessment and the assessment is fine and the mechanism is fine, and EMS can do that assessment and maybe in conjunction with medical command, come to the determination that the patient is now not a patient, doesn't need to go to the hospital, and can be released to law enforcement. I'm not saying that can't be the case sometimes, but we do have to be careful about the idea that we're doing medical clearance, or the law enforcement agencies that just call EMS on lots of folks to, can you clear them so we can take them to jail? You have to be very careful about those. So this 2021 or this consensus document that we're talking about reaffirms this joint position statement. De-escalation, I'm seeing more and more. We used to talk about de-escalation to EMS and just say, hey, first priority is to try verbal de-escalation. But the problem is we never really taught EMS people how to do verbal de-escalation. We just said, you know, okay, the first thing you try is verbal de-escalation. And if that fails, you may need to go to physical restraints. And if that fails and they're still agitated and harming themselves, you might need pharmacologic. But if you get the opportunity to get some education on these de-escalation techniques, it is a different lecture, but very important. Physical restraints, we want to avoid the dangerous techniques. The position statement actually talks about hard restraints, which are things like handcuffs. And the position statement basically says that if law enforcement restraints are used, then law enforcement needs to accompany you to the hospital with that patient because, you know, we're not expert in getting those restraints off if they need to come off quickly and that sort of thing. So ideally, we would try to transition those law enforcement restraints into an EMS type of restraint, or law enforcement should be coming along. On the pharmacologic side, you know, this is not meant to be a full lecture on medications and that sort of thing, but there are medication choices. Generally, the real issue is, you know, not as much which medication as when it's appropriate and when it's not appropriate to use medications. You know, if the patient has no delirium, if you kneel down beside the patient and you can talk to them and they're making sense, well, then whacking them with ketamine, droperidol, whatever, is not appropriate. So it comes down to that assessment and knowing as much when to use them as knowing when not to use them. The EMS medical director and physician oversight is essential to the training and education for the medications. There is a gigantic chasm or gap between the training that an emergency medicine resident physician gets, who's a physician, on sedation and the monitoring and the care of a sedated patient. And they have to do basically 30 sedations before they, essentially by themselves, before they can pass out of residency. And sometimes we teach an EMS practitioner in a 1-hour course on a medication like ketamine and tell them, oh, it's a safe medication. Here's when you use it. You know, here's how much you use. Go at it. A big gap. I'm not saying that, you know, we have to have somebody do 30 sedations before they can do it on their own as a paramedic, but I am saying that we have to be careful that we don't overly simplify the safety of some of these things. And monitoring is essential. Monitoring things like waveform capnography, if you are using these medications, is very important.
Doug, I just want to reinforce again that the decision on using medications on these scenes is solely with the EMS provider. And so that's something that I think training and having good relations with your partner agencies will help to make very clear. But it has to be 100% the decision of the provider there in conjunction with their medical oversight.
Yeah, that's a really good point, because none of the cases talked about today, to my knowledge, had this issue of EMS rolling in and law enforcement saying, you know, give them ketamine, or we called you to give them ketamine. I'm not aware that any of the cases today had that. But when this position statement was being drafted in 2021, there were cases, and there are some out there where there's video of, you know, the EMS clinicians coming up to the patient, and basically the law enforcement looks up at them and said, we called you for ketamine, or give them ketamine, where law enforcement clearly was telling them what to do medically without deferring to them as healthcare clinicians, and the fact that law enforcement is not a healthcare clinician, so they shouldn't really be making that. So thanks for pointing that out, Diane. You know, the transportation destinations are another thing that came up when this was being drafted a couple years ago. And one of the concerns there was the idea that in some places, particularly if there was a culture of law enforcement saying, hey, we're going to call them for ketamine, that EMS would sedate the patient with a medication, and then the patient would go off to jail. So the position statement very specifically says that if any patient gets medication therapy by way of any of the sedating medications to calm their agitation, jail is not an appropriate place to go. Those should all go to the hospital and be further evaluated before being released potentially to jail. Let's see. And then last slide I'm going to cover here is transitions of care. It is exceedingly important for any of you that know me. I've spent the last 30 years of research doing all sorts of different things, but the core to my research has been around EMS safety for EMS clinicians as well as for our patients, and have done a lot of work in this field of safety. And one of the other position statements that is a multi-group position statement between NAMSP and even the Emergency Nurses Association and ASEP and others is on this transition of care, transfer of care. The World Health Organization has identified transfer of care as one of the primary things that leads to medical errors. It occurs within the hospital a lot when somebody is transferred to a different service or transferred to a different department or even transferred down to radiology to get a head CT. That's where errors can occur. And it's no different than the transitions of care from law enforcement to EMS, EMS to the hospital, EMS to law enforcement. Those transitions of care should include, a verbal summary and report by whoever was taking care of the person to the one receiving them. It should include an opportunity to ask questions. And in the medical realm, it should include a written summary. That gets left out a lot. But for those of you that don't know, in Pennsylvania, it's a state regulation that at the time of transferring care, you give a one-pager of the important information about your patient. And it's critical. Where I practice, that happens all the time. And, my residents and myself, we go in to see patients in the emergency department. One of the key things we look at is the EMS transfer of care form, because it gives that information, and EMS is long gone, but now I know what vitals they got. I know if they gave a medicine or not. I know, what they were seeing in the patient. And it only takes 2 minutes to fill those out. Well, the same things apply for this transfer of care. I'm not necessarily saying there has to be that written form in this case, but when you're doing that, my patient, your patient, and law enforcement is transferring off to EMS, there needs to be a bit of a summary of the key things that law enforcement did before. Did they have them in a chokehold? How did they find them? Did they just fall off a wall 10 feet above them, or did they find them on the ground? Did they ease them to the ground, or was the patient thrown to the ground and hit their head? Those are all key things in the transfer of information so that you can have a safe assessment and care. And Diane, do we still have you?
Yes, still here. So something that we do for specific types of incidents, for example, a cardiac arrest, a patient in a respiratory emergency that needs an intubation, cases like that, we regularly will review those for quality assurance and quality improvement activities. I think with the unique nature of these events and the potential for high risk to all involved, it should be crucial for multi-agency analysis of what happened. So some sort of after action evaluation. And so taking in statements from bystanders, statements from the different personnel involved, using body cam footage and other types of video, reviewing patient care reports, looking at law enforcement reports, any type of additional information you can get to figure out what happened, put all of those pieces together, and then did we do things the correct way? Are there things we could have improved on? Are there things that we need to continue to do with similar cases in the future? And typically within the EMS world, our quality improvement activities have peer review protections. And so that is something that can't be used against the individual or the agency. So I think that that same type of approach should apply for these events as well.
Yep, and not that it's bulletproof, so to speak, but Pennsylvania, Diane, does have a peer review protection written right into the EMS Act.
Fantastic. And I think it's helpful too to look at similar cases too, and see what was done in those ones if you do have access to that information, because it will just help us all to work better together. So in conclusion, there's a few key points that we really want to focus on again with you, but appropriately managing an acute behavioral emergency on a shared scene requires rehearsed coordinated effort. So we need to plan ahead. We need to have policies and protocols and procedures ahead of time. We need to do joint trainings as much as possible. We need to improve our communications between the different agencies. I think that's, and anywhere in the world, communication is the biggest weakness that we all have. And then taking some time to reflect on the event and see what was done well, what could be improved upon. We need to make sure that the safety and dignity of the individual must be maintained, as well as the safety of everyone involved on that shared scene. Need to remember that we all have a duty to act. So even if you don't have an advanced medical background, but you see that somebody is in distress, you need to speak up. You need to request appropriate resources. You need to provide aid within your training and experience. We need to think about, can we avoid using medications to manage these scenes? Can we avoid using physical restraints? Can we go through trainings like the CIT trainings and learn other de-escalation techniques to try to keep this a calmer environment? It's going to be safer for everybody involved. We should all remember that sometimes what we see when we roll up on a scene is not exactly what it ends up being. And there may be some medical causes like blood sugar emergencies or a reaction to a prescribed medication, or even things like brain tumors or breathing issues that can cause a behavioral response. We need to make sure that any patients that are restrained are closely monitored and in the appropriate position. And then for any healthcare decisions, they do need to be led by EMS, and that involves both patient assessment and treatment, and also involve the medical oversight from the EMS medical director. But again, this is a joint effort between different types of agencies and different types of backgrounds and training. So the more we can try to work together in advance of a crisis is going to be better for everybody involved.
And I want to leave you with a few final thoughts. First of all, I don't know that it was stated specifically around during this, but if you hear your patient say, "I can't breathe," that's a big deal. It pans out in this kind of situation. It pans out in the patient who is, congestive heart failure and drowning in their own fluids. We get a lot of calls for shortness of breath. And usually that's like, oh yeah, they're short of breath, as part of the, are they having chest pain? Are they short of breath? Yeah, they're short of breath. And it's been going for a week or two. That's one thing when they say they're short of breath. But when they say physically, "I can't breathe," that's a big deal. Number two, this is patient care that we're talking about. This is healthcare, okay? And often, one of the big issues that we have in EMS is that you listen to press conferences after a big disaster or something, and who was there? Fire, police, and the other responders did a great job. We are sort of the other responders. It's fire, police, fire, police, fire, police. This is healthcare. We provide healthcare. We are healthcare professionals. You're just taking that healthcare out into the field. And, we need to recognize that. And when you are at the scene of somebody that is a patient or having a medical problem, or you're not even sure if they're having a medical problem yet, somebody has to assess them for that. It's healthcare. It's our ball game. Diane mentioned the importance of medical direction. I can't stress that enough. Not every medical director is going to be on a tactical team, but they may not be on some of these teams and that sort of thing, but every medical director should know the police chiefs in their community and should be part of that working to make sure that there's a good joint relationship in how that patient's handled at 3 a.m. And then the last thing I have to say, Doug, is thank you very much for inviting me to do this, because as my daughter has just started law school this semester, I now have credibility with her because I told her I'm going to talk at the law school.
Where's she going? Duke. Very nice. Well, thank you, Dr. Kupis and Dr. Miller. I am going to get rid of the slides here, and we are going to transition into the final panel discussion. If I stop screen sharing. Hey, Dr. Miller, now everybody in the room can finally see you. So, and they're all applauding. So thank you very much for your participation with us today and your involvement with the position statement. We're going to transition right into the final session, which is the panel discussion. And if I could have all of our panelists who are present with us come on down. Oh, there. Nope, we got the extra chair. We had 5 panelists. We had 4 chairs set up. So. Okay, as we get started here, my colleague Scott and I are going to be roaming around with the microphones. This is a panel discussion session. It is scheduled as an ethics credit, so for those attorneys in the room, the coveted ethics credit. We'll see how much we can adhere to the ethics piece of that in this session, because I know folks have a lot of questions. I've been furiously making notes and taking questions, but you've met the other 4 panelists, and I want to take a moment to introduce our new panelist here in this final session. And we have with us Captain William Slayton, who is the Director of Recruitment Services at the Recruitment Services Division, Bureau of Training and Education for the Pennsylvania State Police. Captain, anything else you'd like to tell us by way of introduction?
Good afternoon. Can you hear me okay? So first of all, thank you for having me here today. And thank you to the medical professionals in the room as well as the law enforcement professionals in the room. Like you said, my name is Captain William Slayton with the Pennsylvania State Police. I've been a Pennsylvania State Trooper now for about 18 years. I started my career in Philadelphia, where I patrolled the highways in and around the city of Philadelphia for several years. I also served on our Special Emergency Response Team as a hostage negotiator for several years with the Pennsylvania State Police. In addition to that, throughout my career, I commanded a unit within our department that addresses hate crimes and civil tension. So I have a lot of experience working alongside EMS personnel as well as legal professionals. So I'm very happy to be here, and it seems like a tremendous discussion. I'm glad you highlighted those specific cases that occurred as well, because they were particularly concerning to me in addition. So thank you for having me, and I look forward to a great discussion.
Great, thank you. So our panelists, you all have the portable microphones in front of you. I see they're all green, so that's good. What I first want to do is give each of our panelists a quick opportunity for a round robin to just go down the line. We'll start down here. You're on a roll. So particularly, should you have any comments that you'd like to just share in a sort of an open forum here about some of the ethical issues in the care of persons in custody. And let me frame the question a little better than I just did. These are difficult issues because some people in custody are bad people. Some people in custody are good people, innocent people, wrongly detained. And it's difficult to look past the circumstances in which a person finds themselves in custody, and in some cases to remember that it's a human being in need of health care. And that is, not only a legal issue, but it's an ethical and a moral obligation as well. In that very difficult situation, and as Dr. Kupis and Dr. Miller were talking about the transition from law enforcement to EMS, I think of it as a continuum. I think of it as a integrative process, not a transitional one, because I could have a person who's in very desperate need of emergency health care who just was the perpetrator of a witnessed homicide, killed somebody, right? We know they're a bad person, right? It's not situations like we saw with Tyree Nichols or Elijah McClain or George Floyd or people who were innocent. Bad person. So EMS says, my patient. Law enforcement says, yeah, still my murder suspect, right? So it doesn't mean we hand off or we terminate our involvement in that interaction. It's integrative, really, I think. But we have the ethical imperative of still a human being who needs health care. So if that helps in framing the question at all, I don't know, you can go in any direction you'd like. But I'd like to first solicit just some open thoughts on some of those ethics and moral related issues because we've been talking so much about the law. Captain, if you'd like to start us off.
Yes, so what I can share is that we do teach our troopers that there's a human element to an individual in custody, and you have to be empathetic to that individual. If you have to use force to put that person into custody, use whatever force is reasonable at the time to put that person into custody. But once it's over, if they need medical attention, we give them medical attention. We don't, take things personally and continue that aggression. And that's what we teach our troopers. If this person needs medical attention, you have to provide them with medical attention.
Thank you. So well said. Chief?
So what the captain said and what Doug said so well is absolutely 100% I agree with. And I think back in my career and if an individual is injured or needs medical attention, they got it. Whether they were in custody or we were just there to assist didn't really matter. But if they were in custody, they needed medical care. That's where we would say, or I would say, get me EMS here, and I make the decision. If he's in handcuffs, I'm riding along, or we go to the soft restraints. But at no time did I ever want to deny or delay health care to that individual unnecessarily. Now, there are certainly times where EMS would be on the scene and law enforcement would have to say, hang on a minute, we need to secure the scene and make it safe so that we don't have any more casualties or whatever. That's a delay, but it's a necessary delay. Once that situation is under control, then get EMS in there and law enforcement will assist EMS wherever necessary. So it is an integration of the two agencies.
Thank you. Counsel?
I have two thoughts on that, Doug, being an attorney and all. The first is absolutely EMS and law enforcement are on the same team. It's the same continuum. You're all trying to accomplish the same thing, which is protecting and helping people maintain their human dignity if at all possible. That's my first observation. The second is in the 1860s, there was a man named Dr. Mudd who was greatly impugned and disparaged as a doctor because he had the audacity to treat John Wilkes Booth, who had murdered Abraham Lincoln. Was John Wilkes Booth a horrible person? Absolutely. Had he done a horrible thing? Absolutely. Should Dr. Mudd be admired by all of us? Absolutely.
Well said. I love the historical reference. So, counsel.
I am not going to try to go to a historical reference. I will say two things. One is I kind of see all of society, but especially within first responder work, a triangle of critical three things: knowledge, communication, and tolerance. And it's a two-way street. And I think if we can all keep that triangle at our forefront, it will help advance everything. And that dovetails with my second piece, which is while I think we're all a team in terms of first responders, in terms of lawyers with first responders, I think it's also society with all of us. We're all on the same team. You're called to scenes because people want their loved one taken care of, or you're called because something's going wrong. I've never heard of somebody calling 911 to say, hey, I'm having, an Easter egg hunt, you want to come over? I mean, you're being called because something's going on. And you have to remember that. So in that vein, be sure you're taking care of each other. Because I think the biases that show up that are so implicit and they're self-conscious. I refer to them as filters. Every single person in this room has filters from virtue of where you've come from, your experiences, your families, your history, but we don't talk about them and we may not even be aware of them. So just check in with yourselves and check in with each other.
So well said. And as you were speaking, I was thinking about the final scenario that the Harvard team played today, the audio from Butte County, where that person, went from describing an escalating scene to an instantly grieving human being. And just the way you just said that was so well said. Last but not least, Dr. Kupas.
So I think I'm going to answer this not totally in the context of what today is about, but in the context of what EMS providing care to patients and law enforcement, serving the community. Everybody that does this got into it for a reason, and presumably, under all of that is a reason that you want to do good and help people and that sort of thing. And I think over the years I have treated a 4-year-old severely injured in a car crash in the bay right next to the drunk driver that hit him, and had to treat them both the same way and with the same professionalism. And you just have to be careful. You cannot go down that road of doing things to patients. So the number of times I've heard, well, they just needed a therapeutic IV just to cause them some pain or something. That's just not, if you're going to that place, you need to talk to somebody and get some help. But you're always going to deal with these terrible things in society. And, I've also treated the intoxicated driver who, when you got to talk with him a little bit, found out that he was on his way home from his mother's funeral, and after the funeral he got intoxicated. And there's every single person you run across has a backstory. The airlines welcome the frequent flyers at the door and thank you for your medallion status, We refer to frequent flyers like, oh yeah, they're calling us again, Get to know your frequent flyers, and I hate to even use the term, but get to know your, the patients in your community, because, often that person that you take repeatedly, you find out that there are other things that are causing them to call EMS, and a little outside of, today's topic, but it's, people could be calling for loneliness, could be calling for whatever, but they are still all reaching out for something. And so when we make assumptions that, that what people are doing is egregious, and then you dig into it and you find out that it's not that egregious. If you were in their shoes, it might be a different story.
Very well said, and very interesting. So I've been compiling my list of questions all day, but this is really your chance. So both online and in the room, we have a couple of us as roving moderators here. If you have any questions, please let us know. Raise your hand, and we'll bring the mic to you. First one is back here.
I'm trying to compete with my colleague over here in the back row. I appreciate the Easter egg hunt, but we actually did have a 911 call so somebody could move a lady's television, so we did have that occur. This is for Captain Slayton. First off, thank you for being here, and thank you for what you do. I've noticed in the videos that we've seen, and I think I already know the answer to this because it's a safety reason, the folks are handcuffed from behind. And I recognize the fact that the majority of the time when you're dealing with a subject, you need your officers to be safe so that they can't reach out and they can't grab anything. If they do recognize it's a medical event, or if they even have the hint of that, is it standard protocol to always handcuff from behind, or are there, for lack of a better term, exceptions depending on the situation itself?
Good question. So in our State Police Academy, we teach the cadets about people who have attacked law enforcement officers. And the FBI studies have shown that when they're handcuffed in the front, they can still maneuver and attack law enforcement officers. So we always teach to handcuff in the back. However, there are exceptions. I've encountered individuals before who had, some issue with their shoulder or something to that effect, and they couldn't be handcuffed in the back, or very large individuals who could not be handcuffed in the back. And of course, I handcuffed them in the front to make them as comfortable as I can possibly make them. So there are exceptions. If you're dealing with a patient and you realize the officer has them handcuffed in the back and it's aggravating some type of condition they have, you can say, hey, officer, would you mind if we just put the cuffs in the front because it's going to further exacerbate their condition? And hopefully the response will be, no problem at all, sir. But there are exceptions to answer your question. You're welcome.
Great question. Scott, right behind you there.
Captain Slayton, does the PSP train working with EMTs so they learn that the police force shouldn't be directing the EMTs how to practice medicine?
So that's a very good question. Our troopers at specific barracks throughout the state, they do train with the local EMS during mass casualty incidents and things of that sort. So we do train with EMTs. Just to further talk about our training, our troopers and our cadets in the academy receive crisis intervention training. They also receive training on how to deal with people with autism, as well as several other medical emergencies. And that training is both classroom-based as well as scenario. So we do extensively train with medical personnel. And like the gentleman said earlier about, EMS personnel visiting the police departments or stations and offering to teach classes on how to do certain things, we'll be wide open to that. We have several meetings throughout multiple shifts per day. We call them roll calls. And during those meetings, we share important information. So nothing will preclude us from bringing in EMS personnel to say, hey, troopers, this is the crew that works near you. Today we're going to teach you about, stop the bleed, which we have stop the bleed training. But just in general, nothing precludes you from just visiting your local police department or state police barracks and saying, hey, can we stop by at some point for 15 minutes and just introduce ourselves and give a brief training to the officers here, because that could potentially save someone's life.
The consensus document, one of the things it speaks to is having EMS leadership and law enforcement leadership within each community, start that dialogue and then eventually get to the point of sort of some joint training on some of these specific things, the agitated patient, how are you going to work on that? So I think, that's in that consensus document too. We just need to see more of that collaboration.
Great, thank you. Question here.
Yeah, hi, my name's Tim Schaefer. I'm with the Pennsylvania Fish and Boat Commission. And so a lot of the scenarios we've seen had multiple EMS personnel, multiple police officers there. But any advice or thoughts on, say, you're a state game warden who's working by themselves, or one of our waterways conservation officers, or a park ranger by yourself, and then there's one lone EMS person from a rural company that shows up. Any tips for those, remote, rural, maybe even add a 911 contact for, and just one single EMS, one single, say, game warden or park ranger out there?
In those situations, are there body-worn cameras or any sort of cameras, and is there supervision, oversight? What's the setup?
Probably not. There's probably not body cameras. I mean, those are just sort of coming into play for those conservation officers. It's really just really isolated incidents, and maybe deep in a gorge somewhere in rural Pennsylvania, and there's no contact.
What about supervisors?
Nope, just two people.
I think in that situation, what I would recommend is making sure there's got to be somebody over that person. But again, it's opening that communication and trying to tease it out, if you will. Have whoever is over that individual, whoever their boss is, have the bosses talking, because quite often it doesn't end up in a report, but we all know how locker room gossip works, and you find out who's having bad days more often than others, who is acting perhaps less than you would want, or who is doing a great job but just maybe is tired or has something personal going on. I think just getting them talking, because that's a very tough situation, and it's not one anybody wants to be in. Plus, they need to know each other, so if there is an emergency, They trust who's coming in to have their six, if you will.
The teamwork is more important in that situation because, and I think this happens every day in Pennsylvania, you know, there are lone officers out in remote areas where EMS helps law enforcement because, you know, they need the assistance even with a restraint of somebody or something. And likewise, there are situations where it's a two-person EMS crew and you've got a critical patient and law enforcement pitches in and EMS sort of tells them, hey, can you put pressure on this? Can you help this? You know, I mean, so I think that there is a natural more teamwork in that situation than when there's 10 of each team there and, you know, and then it's not quite as big a deal that you need extra people to help with the EMS or the law enforcement, you know.
Thank you. Yeah, Captain.
Just wanted to add that we're also a resource to you. You may not see us much around here, cities that have their own police department, but there are several municipalities throughout the state that do not have their own police department. So if someone smashes your mailbox, it's us that you call to come and take the report and investigate that. And just recently, we assisted a state game officer that was by himself and needed assistance with a subject. So keep in mind that you're never by yourself. Call us. We're always a resource to you.
Great. I'm going to slip a quick question in here, one of my questions, primarily for the two police officers, and then if anyone else wants to chime in. This is a how-to question. When we talk about the need for EMS to be clear in when they believe that they need to access or have control of a patient who needs health care, but there can be situations that were very violent prior to EMS arrival or where a person is being subdued in a violent confrontation. And people can be amped up. And this guy's mine, he's going with me, he's going to jail, right? You know, we've all seen that, but wait a minute, he's ill and injured, I think we need to take care of him. What would be the strategies that you would recommend for EMS providers on how, we talk about de-escalation, how do they do it in that situation where law enforcement might be amped up, certainly the patient's amped up, EMS might be amped up. What kinds of things would you think would resonate with you as a police officer, as a law enforcement officer, that EMS would say in being assertive for the rights of the patient and for the interests of the patient, to put the pin in the grenade in those situations?
Yeah, great question. I would say sometimes just explaining to the officer why something in particular needs to be done. For example, if the EMS personnel shows up on the scene and the person is laying on their stomach in the prone position, you can say, hey officer, we need to sit that person up because of positional asphyxiation. They can't lay on their stomach like that. And then hopefully that will resonate with the officer, and you know, the EMS personnel say they could potentially die. You need to sit them up. And then hopefully that will resonate with the officer and they'll sit that person up. Yeah, just explaining to the officer why certain protocols have to be taken. And if that officer in particular is not understanding or it's not resonating with them, maybe talk to another officer or ask for a supervisor to respond and convey that information to them if time allows.
Good, very, very practical. Thank you. Chief?
Yeah, I mean, I would say the same thing. I would always, you know, want to assist if I knew that individual. Let's go back with the violent individual. So if we're rolling around the ground a long time, there's multiple officers there, we finally get this guy subdued, he's handcuffed in the back, EMS shows up and says, hey, we really need those handcuffs, you know, off. Our response is probably going to be, I'm not doing this again. It just took us 15 minutes to get this guy subdued. However, if there's enough people there, and perhaps with the use of maybe a belt or something, he can be re-secured in a way that would work with EMS that they would be happy for. So if they would come and say, we need the handcuffs off, you're going to get a no way, all right? But it doesn't mean they can't be repositioned to a way that EMS can do their job and we can keep control of that individual. So we would definitely do that.
Thank you. And I think that's another reason why we should think about the EMS law enforcement not so much as a handoff or a transition, but as a continuing collaboration, right? Because in many cases that would be necessary. You have an online question?
All right, the first one from our online participants. A follow-up to the captain's statement that they like when the EMS comes to the station, or maybe it was Mark, for training. And while I know it's above the captain's pay grade, how could we get the process started to maybe have the teams, use some crisis de-escalation and like autism training?
I'm sorry, the teams?
I'm thinking they mean the police teams.
Well, for us as state troopers, we have that training. We've partnered with, I went all the way out to Westmoreland County and partnered with their crisis intervention team and received an entire week of training with them, and we sent troopers there as well. So our troopers have that training, but if your local police department doesn't have that, how about have a conversation with some of the leadership within that local police department and say, hey, this is a very good training that you might want to have. Here's the contact person to coordinate the training. How can we go about getting your officers trained? And then it could be a possibility.
Yeah, at the district that I work for, when we started the police department, I mandated that every officer go through the crisis intervention training. Now, in a school setting, there's very specific things that staff cannot do with students who are, agitated. They can't go literally hands-on with them. If they're in a classroom and they're, breaking computers and windows, they kind of need to actually stand back and let them do that. So there are really specific guidelines for school. If they're trained in that crisis intervention, in other words, they may go hands-on, hold the subject down, the student, and then there's somebody else there with the stopwatch, and they're going, okay, it's 2 minutes, time to release them and re-hold them with a different kind of hold. Now, police officers don't have to follow that guideline. So what our officers do now is they will respond to the classroom or the area where there's a disturbance. They'll let either the principal or the head teacher, whoever's running the scene, we're here if you need us. So we are trained in those type of holds and things, but we stay back, and if they say we can't, this is getting out of hand, we need help, then it's turned over to the police officers, and then they will subdue the.
I think, one of the things I'm hearing, but I don't know from a practical reality in Pennsylvania, but I know in Colorado, these multi-agency trainings are wonderful in theory, but we are so understaffed everywhere that being able to have it, trainings are getting canceled within departments. Do you have any suggestions how you can, we can talk about a mass casualty event and then let's just add in a de-escalation while we have all the agencies here, but from a practical reality, how is that?
You're absolutely right. Training is challenging. In my previous role, when I commanded our unit that dealt with hate crimes and civil tension, I was responsible for training local police officers throughout the entire state. We've taught close to 5,000 throughout the entire state in multiple subjects that's around cultural competency and de-escalation. And training is easier said than done for certain departments because you have to pull those officers off the road, dedicate them to a classroom for several hours for training, and then those training programs might last several days. So you have to find, I guess, the peak window of when that training, should be delivered to those officers. It's not impossible. And when I was training, I would visit a department. If there's only 2 officers in a training class, that's fine, because that's all the department could spare at the time. So as trainers, you have to be accommodating to the police department to understand that they just can't pull 20 officers off the road for training in one session. So great point.
Yeah, second question. And I think this is a follow-up to Captain Slayton, your comment about the preference to cuff in the back. So I think there's some concern. Isn't having hands cuffed in the back on the EMS cot putting unneeded stress on the patient and so forth? And does law enforcement have policies that cuffing patients behind their back is dangerous?
So again, it all comes down to communication. If you're handcuffing someone in the back and they're laying on an EMS cot, I would assume that's challenging for EMS personnel. So if they were to say to me, hey, trooper, can we cuff this person in the front? Absolutely. I wouldn't have an issue with that. But yeah, just not being a medical professional, I would assume that's pretty challenging. So communication, just explain that to the EMS personnel, to the officer, hey, officer, this is challenging, can we place these cuffs somewhere else? Or like the chief said, we can use a restraint belt and cuff them in the front.
I'd add that the EMS position statement would say that once somebody is being transitioned to a stretcher, then you should work with law enforcement and see if you can remove the cuffs from the back and go to a 4-point restraint on the stretcher. If they're excessively violent and you need those, what we'd call hard restraints of like handcuffs, you could potentially even just handcuff to either side on the stretcher, but we frown on that. We really want to get to you know, the non-hard police type 4-point restraints, and every EMS agency really should be set up to have appropriate restraints to be able to put somebody in 4-point restraints safely.
I'm going to use a moderator's prerogative. I'm going to slip in another question. This is a very specific one. This is for our attorney panelists about the Elijah McClain case. Your client's co-defendant was convicted of a more serious crime in the case, if I have my clients and attorneys right, and received a 5-year prison sentence. After, I forget the magic number under Colorado law, so many days, the judge has the discretion to vacate that sentence. The judge exercised that discretion to vacate that sentence and released the other convicted paramedic in that case. I wondered if, and I know there are still appeals pending, but I wondered if you had any thoughts about the judge's decision to vacate the sentence. And I understand that Colorado law allows that for extraordinary circumstances, but at least those of us watching from several hundred miles away didn't see any articulation of what the extraordinary circumstances were in that case. I wondered if either of you might comment on that.
To see, so that's Lieutenant Chikuniak. Did you happen to see his sentencing?
I did. The hearing? Yes.
I absolutely agree with the judge's decision. I think it was appropriate. I think it was the right thing to do. I think it was just. You can't just judge somebody in terms of sentencing on this particular incident. You have to, the judge has to take into account all kinds of things, the person's character, his priors, past, what has he done with his life, who is he? Lieutenant Chikuniak, as Shauna mentioned during our presentation, is a much decorated, much highly respected individual in EMS, and has served as a beacon, as an instructor for the fire department, Aurora Fire. And my own opinion is it was entirely appropriate and it was entirely just.
And I think, I'll refer to him as Pete. Those were the magic numbers, 129. But the trick to that is those couldn't start until the sentencing. And the trick to that is he was remanded on December 23rd, but his sentencing didn't hit until March 1st. And so it was 129 days from March 1st. But that's a fallacy because DOC had to have a report done, which wasn't done. And then he had to be present in person, and the Attorney General had to writ him in, and they forgot to writ him. So those were the longest 129 days plus of my life. I would go visit Pete almost every week, and it was agonizing to watch because the court didn't have discretion based on Colorado law and rules that the judge felt he was bound by, which I might respectfully disagree with, but he felt he was bound by. So it was the first he could do, I think, to correct what I think he thought was not a just outcome. And that's my words, and I think it was very long for him, too, to get to that point.
It was interesting for those of us watching from a distance because some of the comments the judge made during both sentencing hearings were pretty stern.
Right.
And it didn't seem that he was very sympathetic toward the defendants. But apparently, he either found that sympathy or that empathy, or was it motions of the parties? Or was it on his own volition?
You know, I can't get inside a judge's head, but knowing this judge and knowing his personal history, I think he struggled with a lot of the different aspects of it. He is somebody who had always been devoted to the system. He was a law enforcement officer before he became a DA, before he became a judge. I think he takes I think the case hit him very hard. And I think I would take what he was saying with respect to the two paramedics as more trying to balance the tensions that were inherent in the community, in the courtroom, and having the cameras of the world on him versus who he was. I think he was incredibly empathetic to Pete and Jeremy, and I think he also, though, is haunted by Elijah's death.
So, and your question raises a good point, Doug, which is the function of a judge at sentencing is to consider both the person before him in this setting and the person before him in everything else. So in other words, a good person, a good man who has been convicted of a terrible thing. And you can't just focus on one or the other if you're a judge doing your job correctly. So.
And those are such great points. I mean, you know, when we all looked at the sentencing ranges on the more serious conviction, which was second-degree assault, which carried the 5 to 16-year range, I believe, it was a minimum. But then this is, I guess, essentially a footnote to minimum sentencing in Colorado. Is that correct?
Well, I would say it's a footnote and asterisk. I think the court didn't, under Colorado law, the court had the way he interpreted it, he had to impose the 5, but even at the initial sentencing, he went out of his way to say, at this time. He said it 3 times, at this time. The court has no discretion at this time, which to lawyers is a cue of like, I can't do it yet, I'm bound by this 129 days, which was accurate under the way he applied the sentence enhancer. That was what made it that. So without getting too far into the weeds, yes, I mean, but I felt like he was trying to let us know. And I mean, as hard as it is to believe, judges are human. And, you know, you've got the Attorney General asking to be called before the verdict is read. You've got one side, a large contingency of people supporting Elijah's mother who were very vocal in terms of protesting. You had media presence unlike anything. And then on the other side, you have first responders. And I think sometimes judges don't want to be seen as being too easy on a side or being biased, and sometimes you might overcorrect, but they're human. And I think that's what we are seeing.
Yeah, thank you. The attendance of the other firefighters and emergency response personnel every day in court was quite a visual in your case. Other questions from the audience here? We'll turn it back to you folks, because if you don't, I'm going back to my big long list of questions. Scott?
So I have one that kind of touches on all of us. In terms of these patient interactions, the one thing that stuck with me the most today was the patient on the bus who was in an overdose, was revived, and then wanted to terminate the interaction and leave. I know the medics at that point seemed like they kind of backed off and were doing their own thing. The police kind of reinitiated that encounter. I know there's some legal liability in letting people who want to terminate the reaction break and leave, but what have you seen in the court systems, medical providers on the other side who terminate these interactions prematurely being charged? Like, what's worse, making someone who's already agitated worse and them, you know, kind of escalating to these situations, or just kind of cutting it off and allowing them to leave? Obviously there's risks and, you know, they could have some other issue going on, but it seems like some of these situations could have just stopped at certain points and didn't.
Seen him charged yet? No, my fear is that we will. And so if you have, because of fear of being charged, you cut something off quick, and you're like, okay, they don't want to go, or whatever, I tried. And it turns out that person, in fact, was in more serious situation and perhaps couldn't have given that consent. I wouldn't say you're safe. I mean, I'll just give you a very personal example to myself that I clearly didn't want medical charged, but my mom had fallen. It was during COVID, and she's, at the time, was 79. She was taking care of my 80-year-old father, who also had fallen and had brain surgery, and she's trying to care for him. And we're getting a call. I'm in Colorado, my sister's in Wisconsin, and my dad's saying, your mom won't wake up. She won't wake up. She won't wake up. EMS is literally right around the corner, like 5 houses away. They know our house well from my brother. But it's COVID, right? And so they're worried, and you've got these seniors, and my mom now had woken up, and they were quick to let her dismiss. And fortunately, we knew, my mom kept saying, we knew she wasn't feeling well because she kept referring to COVID as Kovac, but that's neither here nor there. She's like, I have a Kovac test, I have a Kovac test, I have a Kovac test. She's trying to find it, and my daughter, who is a first responder, had thought to call her my dad's Apple iWatch, and we could now see the bruise starting to evolve as these seniors are trying to drive around. My dad can't drive because my dad's the one that had brain surgery. My mom should not be driving because it turns out when she fell, her entire face turned black and blue, green, and it turns out she had sepsis. And by the time we were able to coordinate where they were going to re-engage and get her to the hospital, she was in the ICU and they almost lost her. And do I want that paramedic charged because he left because my mom said go? No. But how do we keep that from happening, right? And so you guys have a very hard job. It's a very tough situation. And all I did was call and talk to the chief. He's the chief in Naperville. He was EMS. He was over all of management of safety. So he had multiple over all the agencies, law enforcement, EMS, and fire. He was wonderful. And it was dealt with through collaboration and group trainings. Group trainings to me are the ideal solution for a lot of this. It's just how do we make it practical today?
Dr. Kupas, can I throw a variation of that question to you? And I don't know if this is where you were going or not, but I mean, in that case, they gave Narcan, right? And we see patients respond to Narcan. Same thing with diabetic patients. We control their blood sugar and they regain their mental capacity. At one time, they were very sick people, and now magically through pharmacology, they're not. Our instinct is, you need care, you got to come with us, right? But now we almost have a fresh interaction with a competent patient. And can you maybe speak to the clinical indications of our desire to want to help a person who 2 minutes ago we saw very, very, very sick and now is magically competent?
Sure, and with the caveat that comes with all of these things, you see a little video and you make some impression and interpretation of what was going on, but we don't know the whole story. So we'll just make up and add to the rest of the story. But no, I watched that video and I'm thinking, this guy doesn't have delirium. He sounds like he's totally appropriate in what he is saying. He is standing up. He is, he's got no neurologic deficit that you're seeing. He was awakened after naloxone. And, there are a number of studies that have followed up on the number of people that get naloxone and then refuse treatment and go off. I mean, the CARES cardiac arrest database has a patient that was treated in place and left and refused treatment because the guy got legitimate CPR, but he got the naloxone, and he wakes up and he's like, see ya, So I looked at that and I did wonder about why they and it seemed like it was a common thing that, oh, you've overdosed, we've got to take you in. If you don't go in voluntarily, we're going to turn this into an involuntary psychiatric thing because you overdosed. Not everybody that overdoses is psychiatrically ill and in need of, being involuntarily committed or even taken in for an assessment of that. But it seemed like in that location, they seem to have this culture of, no, you've had an overdose, so you either come to the hospital with us or we turn you into a, involuntary psych eval, and that's, and not that there's any good excuse for what he did, but I think the his buttons got pushed enough that where if they had said, okay, I'll tell you what, we need to assess you though. So sit down over here, we're gonna get your blood pressure, your pulse, we're gonna do a full set of vital signs, et cetera. I mean, in Pennsylvania, if that patient was assessed by EMS, and I keep coming back to that, like, don't just talk to him and say, all right, sign here, you need to assess him. But if he was assessed by EMS with a full assessment and didn't want to go, I'm not quite sure that I believe that there was any grounds to take him against his will and force into that situation. Other states may handle that differently, but.
I'm glad to hear you say that. I mean, a formerly sick patient doesn't then lose their subsequent rights to make healthcare decisions.
tend to, and now they're wide awake, and and you've got a good plan. I mean, we are on the cusp of hopefully getting to national treat in place, in EMS. So we're going to have a lot more of this. I mean, if EMS can assess patients, treat them, come up with a good plan, with telehealth, with a physician, with a protocol, we're looking at having EMS do a lot more of that. So, that was a little bothersome because I was looking at them arguing with him, and he just didn't seem like he was any longer impaired.
Thank you. We have a question over here. Go ahead, sir. So in my neck of the woods, we see ourselves being called out more for evaluations for patients that the police have interacted with that usually have mental health concerns. Now, on a couple of those instances we've gotten there, as we're trying to do our assessment, the patient does exhibit some concerning signs. We call command. Command says you should bring them in. And at that point, on one of the occasions, the person locked himself in a car and another in their own house. And in which case, the police were like, we're not able to help you or assist you because we don't see it as a police emergency. And so even though the physician's saying, hey, we should bring him in, this is concerning, the police are, we're not going to assist. And a lot of times 302 is what they're saying until there's a valid 302 in place. So then we stand there kind of locked as to what do we do and how do we proceed if police are unable to do what command is. And even when we tell command we're unable to get access to the patient, they're kind of left with what you need to bring them in. So what would your guidance be in these situations?
I think you're in a hard situation, and I'm aware of a couple of these in Colorado where law enforcement's they're under the law. I mean, give a little similar scenario where somebody, let's say family calls a welfare check, law enforcement's there, but the person's not opening the door. Family is relating through dispatch about a psychiatric concern, suicidal ideation, suicidal history. Medical's concerned from a medical standpoint. Law enforcement's like, I don't legally have grounds to go into that house. If we go in, we might be violating the Fourth Amendment, the Fifth Amendment, whatever, but medical's like, but we need to go in. There might be an M1, in Colorado we call it an M1 situation. And so I think that's where it has to go up. It's tough. Our medical directors have had to show up and talk with the senior law enforcement on the scene and make a joint decision. In Colorado, a doctor can then override it and dictate it, but then they don't have the ability to do the restraints in terms of the physical restraints. So this is where that communication and collaboration is so critical, because while maybe law enforcement legally can't be the ones to go in, they might be able to legally stand back and provide safety and cover if you have to be the one. I don't know, in Pennsylvania, how would you deal with that, Captain?
No, you're absolutely right. We have to have a legal basis to put the person into custody. And if they go inside their home and just lock the door and they're not a threat to themselves or others, we can't just necessarily go break the door down and put them into custody.
My add-on to that is if you were concerned enough to call EMS for evaluation, but now you're saying that you're not concerned. And
So you're talking about a particular circumstance that I'm not familiar with?
no, there are multiple. I mean, they
Okay.
call us for evaluation because they've determined that there's a mental health concern. So now we come out to do the evaluation because obviously now it's kind of tag, you're it. So we're the last person to talk to the patient, and now the patient or whatever has wandered off. We don't have access to them anymore. And the police is like, well, we can't help you. You're concerned enough to call you, but not concerned to continue.
Yeah.
If, let's say in Colorado, our buzzword's grave disability, but it sounds like there's a level in Pennsylvania where in order to take them in voluntarily on a medical, there needs to be a certain threshold. Is it the same threshold for law enforcement in terms of going into the home, do you know?
It be a threat to themselves or others. And what it sounds like is maybe the police department that you're working with, there needs to be more communication between the two agencies. Because I don't think that's fair to you that they call you to the scene there and then kind of wipe their hands and then take off. So I think, there needs to be more communication with the leadership.
Service 6 municipalities.
Hold on.
So.
Really protect yourself
Yeah.
with the reports. If you don't have enough to say they're a threat to themselves, you weren't that far yet. You have it from law enforcement, but you haven't confirmed it, right? So you're putting yourself in a precarious position if you're only going on what you've been told and haven't been able to confirm it, and law enforcement isn't now supportive of it. All you can do is protect yourself with your reports, but I'm not sure I'd be going in on those without more information.
Yeah, I'm sorry.
Yeah, I think there's also a degree of, the police are gonna document that. So they show up and it's like, well, this isn't really a criminal issue right now. It sounds like he might have some problems. Let's call for EMS to do an eval on this guy. So we're gonna document that, all right? And I'm not gonna call it CYA, but we're gonna document that we passed it on because we determined that it's not necessarily a criminal event. So let's go to the next step. We'll document that we called EMS for eval. We do that for accident scenes so many times. You know, you have somebody there and they're kind of dazed and we're saying, hey, you know, I think you should, you know, we should call an ambulance. And they're like, no, I'm fine. And we're going to really talk them into it. And then they'll sit down and they're shaking their head and they're getting dizzy. And we're saying, all right, we're going to call for, you don't have to go necessarily, but let's have them come in, check your vital signs. And if they tell you, look, we think you should go, you should follow their advice. So we do that quite often for evals on even accident scenes.
Questions? Hey, I'm going to sneak one in then. All right, back to Colorado. So one of the facts that hasn't been talked about a whole lot in the Elijah McClain case is that the ketamine that was administered by the fire paramedic was not ketamine being carried on the fire engine. It was drawn up and given to the paramedic by a separate transporting ambulance that the city has a contract with. And I've been asked this a lot in seminars that I've given, but I'd like to hear comments that anyone else here has, particularly our Colorado counsel, about the non-liability of the paramedics who drew the vial and gave it to the paramedics who administered the drug, right? And the question that I'm often asked is, if another paramedic comes and says, I need this drug, does that paramedic have a duty to assess the patient before they give up the drug, right? And they just say, well, here's a vial of ketamine. I'm going to trust that you've made the conclusion that the patient needs that drug. I've been asked that question a lot. I have my thoughts on it, but I'd certainly like to hear your thoughts about it.
Not say I would not refer to it as non-liability and don't think about it as non-liability, because what happened in Colorado on the civil side is everybody under the sun was listed, including the paramedic team that drew it up on the civil side. On the criminal side, the only reason certain people ended up as witnesses, they had attorneys that got them immunity. So I would not conclude that they did not have liability. It's just, I would have done the same thing if I was their attorneys. You want to protect, you're trying to get in there. So as a prosecutor, you have to decide who's on the witness train and who's on the defendant train. And so as the defense attorneys, you're trying to get your clients to the witness train. But I would not think, and I would think it'd be very dangerous to presume, I'm just transport, or all I did, because it could just as easily be argued you handed him the loaded gun. I mean, we've seen bartenders charged because they poured the drink that the drunk driver then drove and killed somebody. I think it's very dangerous to think you are not liable. I think it's you have your duty when you arrive, and I think that duty's only getting tougher about duty to act or intervene.
Mike, and then Doug, you're on deck next. But Mike, do you have any thoughts about that you'd like to add?
My thought on that is, if you're going to start with criminal liability for medical professionals, where does that stop? The Falk ambulance is what they were called. They brought it. They didn't do their own assessment or evaluation. You could charge them. The medical director who drew up the protocols, you could charge him. The person who did the training and did the 300, 400, 500, you could charge him. You could go everywhere with criminal liability if you wanted to. Is it fair? Is it just? Hell no, it's not. But you could. And unfortunately, in Colorado, we've started down that path now. I don't know where it's going to lead.
And the backstop is really only prosecutorial discretion.
Correct. And even where a prosecutor says no, a duly elected district attorney said, no, I'm not filing this. This isn't just. It isn't provable beyond a reasonable doubt, whatever the reasoning was. And as you said, wrote an extensive letter, gets overridden by the state attorney general. That's a bad precedent. No way around it.
Yeah, thank you. Dr. Kupas, I'd like for you to comment on what you see as a clinical duty of a provider in that, almost like the pharmacy, the dispensing provider. You're a person who has written statewide protocols. When you said we have the state with the largest population living under a statewide protocol, you immodestly excluded that that's because of you. So it is a team, but I'd really like to hear your perspective on that as to the paramedics who, particularly in this case, who
Sure,
dispense the drug.
I think there are two things here. One is this idea of criminal or civil. I mean, I think that I don't find too many people that defend that there wasn't, a reason for civil liability from malpractice issues that occurred in that case. How it went to criminal just freaks me out, because I think it is so scary for EMS, for having people become healthcare practitioners anywhere. Like, why would you go into healthcare if you can go and sell insurance or something instead, and not have that that you're going to have criminal liability for everything you drop and give and what have you. So that's really scary that it's criminal. But even at the civil level, I'd speak more to that. This falls into all of that stuff that basically I've looked at for a long time in EMS safety. And, one of the things for medication safety is, the more people that touch it and the more handoffs you have of something like a medication before it's given, that's every one of those is an opportunity for an error. You don't know, you didn't read the vial. Ketamine commonly comes in 2 different concentrations, particularly people that have protocols where they give it both for pain and for trying to sedate somebody that is agitated. They often have 2 different vials. So what if you grab the wrong vial and it's the wrong concentration? And, the person that grabs it in the back of an ambulance that's not even your agency's ambulance takes their medicine that you don't carry and draws it up out of a vial and gives you the syringe with it. And was that labeled? Now, in the hospital, that happens a fair amount. If I'm sedating somebody, I've got a pharmacist in the ED that draws those meds up, but hands each of them to me, and here it is, it's labeled, and tells me when they hand it, this is X and there's 10 milligrams per milliliter. And you wanted 80 and there's just 8 milliliters in here. And this is, and they do that kind of handoff. I'm guessing that may not have occurred when they were handed this syringe, that has this drawn up medicine that wasn't even drawn up in your presence. You haven't seen, all the paramedic students, I'm sure you're being taught, you look at the vial, you look for the expiration date, you make sure it's the right medication, the right concentration, you draw it up, you know exactly how much is there. And maybe if you're really safe, you do what's called a medication cross-check with your partner and verbalize it and have them look at it and double check that that's what it is. So there are a lot of opportunities, I think, when you have a practice where one agency brings a medicine and draws it up and gives it to another agency, and you don't really know what.
Yeah, thank you. And you said that that was more opportunity for error, and I guess conversely, it's also more opportunities for checks on patient safety as well.
If it's done well, yes. You have 2 paramedics at the scene. You should be doing a medication cross-check. Still, ideally, the person that's giving it should draw it up. They know exactly what's in it, but then they hand it to somebody else and say, hey, check me that this is what's in this vial, this is what's in the...
And for you paramedics to realize also, though, another thing to realize is against your colleague. That is the worst position. It was so awful. And trying to stay in your profession, and now they're making you the star witness against your friend, your colleague, your coworker. It's an awful position to be in. So it's a chance for everybody to slow it down and communicate and catch it.
Thank you. And one of my prime takeaways from this is, are you on the witness train or are you on the... I loved it. So, ladies and gentlemen, please join me in thanking our panel for all of their great insight. And if you guys want to return to your... Thank you so much. Professor John... to Dre. To Dean Cummings, who's going to make our closing remarks. Thank you, Dean.
At the beginning of the session today, I promised that we were going to talk about critical, important, and controversial issues, and we accomplished that goal, did we not? One of the things that I wanted to remind is that we are very proud here at Widener Law Commonwealth to engage these issues that are of national importance and that come home to us here in Pennsylvania, and I felt like today's events were really thought-provoking, very critical, and really important. So thank you all for coming here. Thank you for allowing us to host you. Just a couple of things quickly. I'm really grateful to Paige, Wolfberg, and Wirth for sponsoring this event, as well as the Ambulance Association of Pennsylvania and the Pennsylvania Fire and Emergency Services Institute. So thank you to our sponsors. I want to thank our team here at Widener Law Commonwealth that was just fabulous today, including our technical team, Brian Fernbaugh and Rob Brown, as well as everyone that put the event together. Thanks to Doug. Again, we're really proud of him as an alum and also all of our alums at PWW. And I welcome you to come back to the 7th annual next year. We will be just as engaging and controversial and important as we were this year. So on behalf of the law school, thank you so much for being here, and we look forward to continuing the conversation. Thank you all so much.